Okay. We have answered the question whether an application for anticipatory bail under Section 438 of the Code of Criminal Procedure, 1973, is maintainable at the instance of an accused while he is already in judicial custody in connection with his involvement in a different case. Our final conclusion is as under. An accused is entitled to seek anticipatory bail in connection with an offense, so long as he is not arrested in relation to that offense. Once he is arrested, the only remedy available to him is to apply for regular bail, either under Section 437 or Section 439 of the CRPC, as the case may be. This is evident from Para 39 of Gurbakh Singh Sibia. 2. There is no express or implied restriction in the CRPC in any other statute that prohibits the Court of Session or the High Court from entertaining and deciding an anticipatory bail application in relation to an offense, while the applicant is in custody in relation to a different offense. No restriction can be read into Section 438 of the CRPC to preclude an accused from applying for anticipatory bail in relation to an offense while he is in custody in a different offense, as that would be against the purport of the provision and the intent of the legislature. The only restriction on the power of the court to grant anticipatory bail under Section 438 of the CRPC is the one prescribed under subsection 4 of Section 438 of the CRPC and in other statutes like the Atrocity Act, etc. 3. While a person already in custody in connection with a particular offense apprehends arrest in a different offense, then the subsequent offense is a separate offense for all practical purposes. This would necessarily imply that all rights conferred by the statute on the accused as well as the investigating agency in relation to the subsequent offense are independently protected. 4. The investigating agency, if it deems necessary for the purpose of interrogation/investigation in an offense, can seek remand of the accused while he is in custody in connection with a previous offense, so long as no order granting anticipatory bail has been passed in relation to the subsequent offense. However, if an order granting anticipatory bail in relation to the subsequent offense is obtained by the accused, it shall no longer be open to the investigating agency to seek remand of the accused in relation to the subsequent offense. Similarly, if an order of police remand is passed before the accused is able to obtain anticipatory bail, it would thereafter not be open to the accused to seek anticipatory bail, and the only option available to him would be to seek regular bail. 5. We are at one with Mr. Dave that the right of an accused to protect his personal liberty within the contours of Article 21 of the Constitution of India, with the aid of the provision of anticipatory bail as enshrined under Section 438 of the CRPC, cannot be defeated or thwarted without a valid procedure established by law. He is right in his submission that such procedure should also pass the test of fairness, reasonableness, and manifest non-arbitrariness on the anvil of Article 14 of the Constitution of India. 6. Under Section 438 of the CRPC, the precondition for a person to apply for pre-arrest bail is a reason to believe that he may be arrested on an accusation of having committed a non-bailable offense. Therefore, the only precondition for exercising the said right is the apprehension of the accused that he is likely to be arrested. In view of the discussion in the preceding paragraphs, custody in one case does not have the effect of taking away the apprehension of arrest in a different case. 7. If the interpretation as sought to be put forward by Mr. Luthra is to be accepted, the same would not only defeat the right of a person to apply for pre-arrest bail under Section 438 of the CRPC, but may also lead to absurd situations in its practical application. So we have also explained why Narinderjit Singh Sani should not come in the way of applying. So we are dismissing the appeal with a clarification that now the bail will be heard on its own merits. Beautifully read. Thank you. You are appearing? We have allowed the petition. We appoint Shri Justice Mohit S. Shah, former Chief Justice of the High Court of Judicature at Bombay, to act as the sole arbitrator. The fees of the arbitrator, including other modalities, shall be fixed in consultation with the parties. It is made clear that all the rights and contentions of the parties are left open for adjudication by the learned arbitrator. Fine.
In 1502, I'm not in the matter, I have nothing to do with the merits. But when your lordships were hearing the constitution bench on this issue, Lord, my lords were pleased to require the original file of the government to be placed for my lord's consideration, which was placed. Lord, if that can be returned.
Can be fair.
Yes.
When the 7-judge matter was going.
Yes, at that time, my lords.
Yes, of course, that. Make sure that is returned to the Solicitor General.
Lords, if I may, if I can mention, my lords, there's a matter for which we've sent an email. We have also gone between 10 and 10:30, as your lordships have mentioned. It's listed tomorrow before the single judge division bench of the Madras High Court. Despite judgments of the Madras High Court which say quashing petitions must be heard by single judges, about 30 matters have been heard and disposed of, dismissing the quashings. We are a little concerned.
Yes, all other mentioning applications, the moment we rise, I'll pass orders so that we'll have orders by the answer.
Except for these are matters before your lordships after notice matters. What's concerning the university which your lordships have been hearing in part, lords. Sorry, my lords. My lords, it was last listed before your lordships bench, my lords, on 13th of February, my lords. Since then, it has not come up. It's showing on 13th of October. It may not be deleted because there's some.
All non-deletion requests also just give us in an email and make sure that I pass.
It previously pending this matter for listing. So after notice matter, Lord, 1100 crore award in my favor, upsetting 37,
Email.
and not a rupee brought in security.
Thank
And we had previously emailed, but it keeps appearing and disappearing from the list, Lord. It be not fixed. So replied. Last it was listed in March to be listed in April. So replied.
My lords, may I mention 2 writ petitions, which are already,
Say it on the email. It's a fresh matter.
no, my lords, only for non-deletion, my lords. The date
I
is
just
showed as,
say,
last 3 dates it was deleted, my lords.
just send an email. I say NTD.
Email
I've
us.
even got a code. NTD, not to be deleted, and I initial it.
Yes, my lords. Problem.
Only thing is the reason I insist on emails is because then it's tabulated. So then it's easier for them
Yesterday we
to
have sent an email.
process it.
We have sent an email.
I have a tabulation by the end of the day, so that I would just say NTD and initial it.
My lords, this is a writ petition filed on 9/7, my lords. Defects were cleared on 18/7. Since 50 days, it is not being tested, my lords.
1 second. Right, I'll tell you. Just send an email, I'll circulate.
My lords, may I mention a matter which is listed today before my lords? My lords, actually,
Wait for the matter to be
Lordship.
called out. Wait for the matter to be called out, yes.
Like,
My lords, we have filed, my lords, the status report, which you have circulated yesterday. And then, my lords, we've also filed the report of the State Health Department. My lords, they've not gone back to work, the doctors, my lords. 23 people have died in the process.
Now, what about the CBI? Has the CBI?
Lord,
prepared a
my
status
report
report?
is ready, my lord.
We saw your status reports, which were,
My lords, we filed a separate application, my lords, which
Lord,
I think has.
I don't think I have the copy. I'm not complaining. I'm just requesting him, my lord, to give it to me right now. Maybe they have served, it has not reached me, or they have not served, whatever. my lord.
It's not served. It's not served.
Not served, my lord, they have not served on me.
Yes.
Sealed on it.
Put it in a sealed envelope and therefore we.
Sir, sorry.
Yes. Means for the parents. Say one thing, my lord, what is filed by Mr. Sibal is not served upon me. That's what he says.
It is not filed. It's not filed. It's only given to the
Sir, if
court.
they want to say something, why hide something from the CBI? You've already hidden many things.
I mean, I think let's not get lost in.
Yes, my lords,
Yes,
otherwise.
Let's see what let's see the, first and foremost, let us find out what the status of the investigation is.
Yes.
So can you?
Not even with them.
The residence of the, Mr. Solicitor, what is the distance between the residence of the principal of the R.G.Kar Medical College and the medical college?
15 to 20 minutes it takes, maximum.
More than 6.
Check.
Consider reading this, my lord, along with this chart, my lord, the report.
Like a clarification on two aspects.
Yes, my lord.
First, what is the time at which TD 861 of 2024 comes into existence? That's the first. So we want to know, as a matter of fact, what is the time at which
The UD.
UD, yes,
Yes, I'll certainly.
UD 861 of
Yes,
2024 comes into
we certainly answer that.
Lord, your lordships had the benefit of going through this, my lord. I would request your lordships to go through.
Yes, we have.
Yeah, just to assist your lordship, my lord. Not, I am not adversarial, because we are dealing with a daughter and she is a daughter of each one of us. Therefore, my lord, I am taking it in that spirit. Please have a look at, my lord, this left-hand side and the right-hand side, my lord. Kindly go through it, my lord, with some, my lord, degree of attention. Your lordships, I have gone through, my lord.
Death certificate, yeah. Yeah.
उसमें कुछ हुआ था।
May I answer? Well, the death certificate was given at 1:47 p.m. Malas, and the UD entry was at 2:55 at the police station. 2:55.
That is 861.
That's right. There's the second question, Your Lordships. All subsequent proceedings, whether the inquest report or the CJM's order and all other documents.
What is the GD entry by virtue of which 861 of 2024 comes into existence?
565.
565.
Yes. DD entry 565.
And what time is GD entry 565 recorded?
At night, Malas. 2:55 p.m. Malas. 565, 2:55 p.m. I can hand it over.
So GD 565
At 2:55 p.m.
is recorded at 2:55.
Yes.
GD? No, GD was
Yes, it's there.
23:30.
This is
But
a certified copy, Malas.
565 is merely a medical
This
certificate.
is a certified copy, Malas.
Page 64.
It's not a medical. It's an
Extract
I
from
have
the
the copy of
Tala
GD
Police
entry at
Station Daily Register. It's not a
23:30.
medical entry.
No, that, and that's 11:30 night. I have the copy.
No, I have a copy too.
certified.
We've certified copy, we've just given it to the court.
So he is still this. He's still this. Stupid.
The inquest, my lords.
What is the time?
Yeah, give your lords.
4:20.
Just make sure, just, let's not.
Yes. Judicial magistrate.
4:20 to 4:40.
Judicial magistrate arrives and conducts.
And the judicial magistrate arrives and conducts it. He comes at 4:10. And then the inquest is conducted at 4:20 to 4:40.
Inquest is videographed.
And the it is videographed.
Yes, and the same has been saved on a card which we can.
Sybil, also, second question, when was the search and seizure actually carried out?
Just, Maharaj, just. 8:30 to 10:45. 8:30 to 10:45. The photographs had been taken before, Maharaj.
8:30 in the morning or in the evening?
Evening, Maharaj.
The body was found in the morning at 9:30.
That's right.
It cannot be
Photographs were
before that.
taken.
It's only once the water is removed.
Once the body was removed, Maharaj, for post-mortem, then only, Maharaj.
And by whom? There is some relevance. Therefore, my lord, I would like my learned friend to ask. There is some relevance.
Maharaj, we have photographs from 12:45 PM onwards of everything that happened. We have the original with us.
Now, during the course of the previous hearings, and therefore I think though the investigation is going on, we can share this because you've all said it openly.
Yes, Maharaj.
That there is evidence that there is a CCTV footage to indicate what time the accused
Yes.
enters the seminar room and what time he's exiting the seminar room.
Correct.
Right? This is
Yeah.
shared with us. Now, obviously, therefore, there would be CCTV footage after 4:30 in the morning throughout the day.
Yes, there will be.
Has the CCTV footage in its entirety been handed over to the CBI?
Yes.
Yes, we have taken.
Yes.
We have taken.
You have taken the CCTV
taken,
yes.
footage.
But we had to reconstruct the scene because of the distance.
But
It
then,
covers only a part.
Mr. Solicitor, how do you explain this statement in your affidavit at small Roman 3 at page 14? Just see the last sentence.
My report, my lords?
Yes.
Yes. Page 14, my lords.
Just one para above 7.
Yes, my lord. The SOC was apparently visiting.
Have you handed over, as the Calcutta police handed over to the CBI, the entire footage of the proceedings which took place between 8:30 PM and 10:45 PM? Because CBI seems to have.
Yes.
What is shared with us
Is about 27
minutes.
27 minutes, they say. The
4 clippings totaling duration to 27 minutes. And the proceedings conducted from 17:06, that is 5/6, to 22:45 hours.
Mr. Sibal said that
Well,
they have actually
I'm just
conducted from
taking
8:30 PM, that is 20:30.
I'm just taking instructions.
Yes.
Yeah. Well, that's, yeah, all right. Two separate things, Malad. Seizure 8:30 to 10:45. The video of that. Well, seizure 8:30 to 10:45 given. Then, Malad, in parts, the videos have been given. In parts, there was some CCTV in hard disk. In parts, completely given, Malad. There was some technical glitch. It was stored in part, but given in full. Hard disk is full. And he's made a statement that I've given it.
It's, in this context, I need to, my lord, come in, my lord, here, because there is something, my lord, which, according to me, is very, very serious, my lord. My lord, I want a flap. My lord, we have the forensic examination report. I'll not read it, my lords. But one thing, my lord, is admitted. When the girl was found at 9:30, I'm sorry, but her jeans were removed and even the undergarments were removed and were lying somewhere nearby. So she was in a semi-nude condition. It is also an admitted position now that there were injury marks on the body and other my lord, areas. Now, your lordships may kindly see the report. Give me copies. And this, my lord, this is a foreign, my lord, your lordships may mark. They have taken the samples. They have sent it to an FSL in West Bengal. And this is the result. And
CFSL.
CFSL West Bengal.
Central Lab, not,
Yes,
not
yes,
an FSL.
correct. I'm not on anything else. वो कहाँ गया दूसरा? यहाँ पे लगा. Lord, I have only one copy right now. Please see this, my lord. This is serious. And the CBI has taken a decision to send the samples, collect, my lord, to AIMS and other, my lord, Central Forensic Science Laboratory. The person enters, the body parts are not covered. The lead girl is made nude. There are injury marks, and this is the result of FSL. Therefore, who took the samples becomes relevant. Kindly, my lord, have a look.
The injuries are all set out in the inquiry.
See this, my lord.
So this is
Lords,
CCTV camera 16. CCTV.
Which is what is this document?
copy for my Lord Justice Padiwala and Justice Mishra also. Just give me a minute, I'm just flagging it, my Lord. My lords may just see, my lord, the highlighted part in the flap portion. There are two specimens or two swabs and the result.
Mr. Mehta, we have seen now the further line of investigation which is open. We do not want to comment in it in the open court, obviously, so that the course of the investigation should not be affected.
Correct.
We will give you a week's time. Tell us by next Monday what further leads have emerged during the course of the further investigation. We'd like a status report to be submitted to us by next Monday. Mr. Sibal, it's advisedly we should not be referring to what has emerged during the course of the investigation.
Yes, absolutely.
Let the CBI proceed on the basis of what they are now exploring,
Sure.
the leads which they are pursuing.
Sure.
And we'll keep it now on next Monday. So that
It's a holiday, it's a Tuesday.
Only a minute, only a minute, Mr. Lord, there is one IA which we have filed, IA 200162. Lord, where, Lord, your lordships were pleased, Lord, require.
Well, before my learned
CISF
friend says that, I just want.
deployment. Only a minute. Mr.
Before
Sibal,
my
if you
learned
don't
friend
mind,
takes up, just hold on.
if you don't mind, sir, let me just show.
No, it's on the previous matter.
we'll just pass a short order on this.
Lord, the lady.
Well,
One second. We'll come back to you in a moment. Let's clarify this part.
Yes.
A status report has been, a status report dated so and so has been filed by the Central Bureau of Investigation. We'll stop. Having perused the report, it appears that the investigation is in progress. So stop. We direct the CBI to file a fresh status report by the next date of hearing. We'll stop. List on so and so for considering the fresh status report to be filed by the CBI. So we take it up on Monday for, Tuesday for considering the status report, which would be then filed by the CBI. Let's see what happens between now and there's a lot of what has been collected during the course of the last 10 days is subject to further verification. And
we'll also investigate,
analysis.
my lord, who collected the samples because this.
Fair enough.
We will send.
We will stop you, nor are we guiding the CBI that we want a particular line of investigation to be conducted. CBI is doing it. You have flagged issues in the status report. You tell us next Monday what further emerges.
Take this also on record, the report of the FSL.
We'll return this back to you. Why should we retain it right now?
Whichever way, my lord, comments.
We'll return that back to you.
Lord, one more thing.
Just
Lord, out of, my lord, the lady.
First, we'll retain only the second status report on the record. The rest of the papers we'll return back to you.
My lord, there are 3 lady companies, my lord, of CISF. My lord, they are not providing the accommodation to them. They have to travel, my lord, from CISF camp, which is 1.5 hours away from the state. My lord, thereafter, my lord, there are several things which we have requested. It is ordered dated 22nd. We are, my lord, almost 15 plus days down the line.
Well, as we have provided, in fact, if your lordship looks at our note, we have provided all that they wanted us to provide, everything that they wanted. Just give it to my.
The three companies of women constables.
Yes, and
who are guarding the
accommodation
R.G.Kar
for the
college.
women.
Where are they presently housed?
Well, that's I just show to your lordships. Please. Kindly see.
Look, can I have at least that?
Yeah, we'll just give it to you.
Yes. And I'll also share what is not provided so that you,
Just give it to you.
at least henceforth you, instruct
Kindly
them
see,
to
madam.
provide.
Kindly see the accommodation.
Yes.
KMCP Day School, 2.6 kilometers, 13 minutes away. One company proposed things, one company 54 women personnel. Indira Maitri Shishu Kalyan Hospital, 6 minutes away. One company 54 women
No,
personnel.
when?
These
Because
have
we
been
have been
provided.
clamoring since
Then
2 weeks.
3 flats in RMO quarters within so-and-so, on-site 20 for 25 personnel. Currently, 20 CIFS personnel are staying in 2 flats of RMO quarters within
Within the hospital.
the hospital, and the rest of the CIFF personnel are commuting from 12 kilometers away. And the school and Indira Maitri Shishu Kalyan Hospital were undergoing construction, and therefore these are identified by the CISF themselves, Malal. So we put them there. And most of the state police officers deployed by so-and-so come from far-off places like Police Training Academy, Howrah, which is 22 kilometers away, Bodyguard Lines, which is 12 kilometers, and Police Training School, which is 10 kilometers. So, Malal,
Lord, this is my instruction
and
as on
our
10:30
status
today.
reports, Malal, sets out everything.
No, as on 10:30 today, my lord, this is my instruction.
No, but we are telling.
Kindly have a look at this, my lord.
This is, this.
We should not be fighting on this, my lord. The
I-
CISF,
and Therefore, exactly.
we requested for
once I have
handheld metal
stated-
detectors. We requested for door-size metal detectors. other
Everything is
equipment.
provided.
They provided that after 2 weeks, but this is
No,
still
no,
not
we
provided.
provided there.
Let's have a look at this.
Just a second. What is now remaining to be provided? Mr.
That's
Solicitor, you have
what I
seen this. They say for housing one company of women personnel consisting of 54 persons, they have provided at KMCP Day School, which is 2.6 kilometers.
Kindly have a look at 10:30, at 10:30, this is
Well,
yet.
let the registrar of the High Court go and see, Malal.
Yes.
Let 10:30, my lord, this is at 10:30.
Let him go and see.
I don't want, my lord, I'm not enjoying.
Can we can we look at this for a moment, please?
Yes, Lord.
Accommodation for one company provided in 3 locations as below. RMO Quarter, R.G.Kar Hospital, 20 persons. KMCP School, 40 persons. Indira Maitri Sadan, 30 persons. Likely to be handed over by evening today. 2 companies are
Yet to be provided
yet to be
accommodation.
provided.
Some security gadgets are provided, some are not provided. Lord, I'm not gaining anything by pointing this out. This is what is needed. Lord, if some incident takes place, Lord, I stand responsible now for the security, the CISF. is responsible.
Just one second. Mr. Sibal, you just check, Ms. Astha Sharma, you can check with the officers.
Yeah,
In your statement, where you have said one company, 54 women personnel,
yes.
that covers one and the same company,
Oh,
which is
Either
being
one
provided
company
at
or 54 women
KMCP and
personnel.
Indira Maitri or Shishu Kalyan
no, Malal, it's
Hospital.
one company / 54 women personnel.
Right, but the same one company.
Yeah.
But now, as of date, they have deployed 3 companies. So the other 2 are yet to be provided by you.
My Lord, when
One
this is
second.
provided?
One
This
here,
is
Malal,
provided
kindly see
yesterday.
Indira Maitri, that's the other one too.
Yeah, that's the second one.
That's the second one. It's in Indira Maitri, Malal, which is
So
1.7
we are trying
kilometers.
to tally what they have handed over with what you have handed over. What they have handed over suggests accommodation for one company provided in 3 locations, which includes 40 persons at KMCP and 30 at Indira Maitri Sadan, and 20 persons at RMO Quarter. Now, that indicates that only one company is taken care of. There are other 2.
According to us, no.
Persons plus.
Just ask the registrar to go and
Why
check.
don't you,
One
can,
company,
can,
why register?
can we suggest this? Why do we have to ask the registrar to do all
Malal,
this?
because they are
An
contesting.
officer of the state government and an officer of the, a senior officer of the CISF.
We have done that,
will go and,
Not one
On
company
ground, we have
can-
done that. They are not wanting, in fact, Malal, on the ground, the story is different. Malal, what can we say, Malal?
But one
All right,
company
ऐसा लिख
is
लीजिए।
90 individuals,
Okay.
90 my lord, officers.
A total of 3 companies of CISF personnel has been deployed for the security at R.G.Kar Medical College and Hospital. Full stop. Mr. Kapil Sibal, the state of West Bengal has in its submission indicated that provision for housing the personnel has been made thus, colon, ये in case में page 1 को tabulated chart ले लीजिए. Prima facie, it appears from the above tabulation that the prima facie, don't say prima facie, it appears from the tabulation. In the statement which has been placed on the record by the union government, on the other hand, it has been indicated that accommodation for one company has been provided in 3 locations, namely at bracket 1, RMA quarter dash R.G.Kar hospital, bracket 20 persons, 2, KMCP school dash 40 persons, semicolon, and bracket 3, Indira Matri Sadan, 3, bracket 30 persons. And that the premises are likely to be handed over by the evening today. Full stop. In order to obviate any logistical difficulties, we direct that an officer of the nominated, a sufficiently senior officer of the Home Department nominated by the state of West Bengal, and a senior officer of the CISF at the spot shall jointly liaise so as to ensure that all the 3 companies of the CISF personnel which have been deployed at the spot are duly provided for accommodation in the vicinity at par with what has been stated in the tabulated position set out above. Full stop. Next. In the event that any further full stop arrangements have been made for providing 6 buses, 4 trucks, and 3 light motor vehicles. Full stop. The 2 officers shall ensure that all requisitions, that necessary requisitions which are made by the CISF are duly complied with by 5 p.m. today. Full stop. Necessary gadgets for security purposes shall likewise be arranged no later than by 9 p.m. Today.
No, but
As a matter of fact, this is also provided, must have been provided tomorrow, yesterday or day after. I don't wish to trivialize the magnitude of the problem I am dealing with.
One further thing now.
But I have 3 issues that I wish to place before you.
Before we hear you on those issues, Mr. Sibal, what steps have been taken by the state of West Bengal for, because we had said that pending the finalization of the recommendations of the National Task Force, we would like the state of West Bengal to immediately put into place necessary measures which would bring into being some sense of security and
We have got a report, Manoj, from the health department.
and provision of adequate measures for the doctors,
Yes,
nurses, and the paramedical staff.
Yes, Manoj.
Status report.
Status report that we have filed, Manoj.
The health secretary.
Make a prayer, let the competence of the autopsy surgeon be also involved within part of the investigation. And also they had offered money so that they can, my lord, speak in tune of the police. These should also be within the purview of the investigation. That's my humble appeal.
Look, we need not pass any separate order because what you are saying is already a part of the status report. The CBI is looking into all these aspects.
I would appreciate just one thing, that this postmortem could not have taken place after 6 o'clock in the evening. There are standing instructions. Everything, my lord, will just kindly take the postmortem report once and just give me 2 minutes. I will show your lordships how this entire investigation has been compromised. After 6 o'clock in the evening, a postmortem cannot be conducted anywhere in India and in the state of Bengal when it is a rape and murder. There has to be a noting of the civil surgeon on the postmortem report that the Deputy Commissioner of Police or the Commissioner of Police has certified it. Then it has to go to the superintendent. Superintendent certifies it and then sends it to the postmortem doctors. These 3 postmortem doctors, one of whom is a professor of forensics, my lord, knows this, but still, what is the reason? The reason was to get rid of the body. What Justice Patiwala was continuously asking, the GD entry number 576. My lord will ask them to show Form 27. And I'll answer Justice Patiwala's questions in 1 minute. Form 27, please. Form 27 is the first information report. In the first information report, there are various columns. Column 3 C2 gives the GD entry number.
Column C,
C2 gives the GD entry number by which the FIR was started. The FIR was started by GD entry number 577. The UD case was 576, as pointed out by Justice Patiwala. It was registered at 11:40 in the night, 45 in the night. But in the history,
That was better the last time also.
in the history, in my last 27 years in my career, I have never come across a case where seizure takes place prior to the lodging of the FIR.
the FIR has been registered at 23:30 hours.
Yes,
Yes.
now,
The UD.
there was a previous FIR.
Along with,
The FIR has been suppressed.
If you see,
I will show it,
3 doctors sign off on it.
Anok,
I will show on the,
6:10 to 7:10. Let him say.
Let him complete his submission.
Dead body arrives, 6:10.
Mr. Counsel, please complete your submission. Yes.
my lord will kindly take once. My lords will kindly take section,
Just tell us on the facts, what are you saying?
my lord will kindly take the postmortem report and compare it with the UD case which was started. In the postmortem report, the lordships will see whether the clothes of the victim were produced before the postmortem doctor. The entire the jeans, the top, the undergarments, everything was produced or not. Because as per I'll show the notification, they have to be sealed by the postmortem doctor and handed over to the investigating officer. If your lordship sees in the top whether the clothes were sent to the investigating officer of the UD case by the postmortem doctor. I will kindly ask them to just give a copy of it.
Of the postmortem?
Postmortem. And allow me to place.
We've handed over the postmortem.
We have seen the postmortem report. Just show us the postmortem report,
We've handed it over.
either the state of Bengal or the CBI.
Well,
We saw it last time, but since
Yes.
he's making a point, let's appreciate what the point is.
So the parents wanted, they had a list of demands, including the parents.
postmortem report doesn't even say at what time it is conducted.
Give it to us.
I'm sorry, that too.
Yeah. It says that at the time, everything is there. I don't know why you're making these.
Please tell us what the time of death is.
It's
Just
a
1 second.
condition of
Take out copy.
the subject, Malas, your lordships will find on the left-hand side.
Lordships will kindly see at the top.
Right.
First will be the videograph. Conducted by whom? No designation. Who is he? From where did he come? Nothing. Was the
Conducted
CD
by Shekhar.
on a
Shekhar.
rewritable CD or was it a non-rewritable CD? It has to be mentioned on the first line of the postmortem report.
Malas, the judicial magistrate was present during
is
postmortem
immaterial.
call for his report.
All the 3 doctors are part of the,
5 female doctors were present.
all are part of the North Bengal
And
lobby.
the family.
For by the family.
Don't discuss such things here. Please.
My lord will kindly see the second line. It has to be at 4 degrees centigrade.
The postmortem report refers to Tala PS UD case number 861,
Yes.
dated 9 August 2024.
Yeah.
My lord, that's where the mystery lies, because between 2:30 in the afternoon, when they say the GD entry was lodged, that is 5:65, and 11:30 in the night, there are only 10 GD entries in Tala police station. Lordship should kindly appreciate that. Between 2:30 and in the afternoon and 11:30 in the night, there are only 10 GD entries. Or was this entire thing manufactured? And my lord, this started way back in 1953. It was the first case in Bengal where GD entries are manufactured.
Know that, what he said. everything will be clear.
One thing, this just.
The judicial magistrate witnessed all this. Call for that report.
Not on magistrate or these.
I say it makes no difference.
Lord, give me a minute.
My lord,
Please have a.
every police station has
a
a
minute.
natural death.
No difference, he said.
Sorry.
Lord, kindly have a look at left-hand side bottom, the finding. In the case of wounds, not note whether there is any indication of wounds being homicidal, etc. Then the report is death was due to effects of manual strangulation associated with smothering, as noted above. Now, please see manner of death, homicidal. There is a medical evidence of forceful penetration, insertion in her genitals, possibly of sexual assault. And see, my lord, the FSL report. My lord, I have marked, my lord, two
CFS.
my lord, seized items.
Just give us that.
Given that, I'll just. Lord, in the second flag, I'm sorry. In the second swap, Lord, second flag, please see B, the observations. In the second flag, please see B. First, my lord, please see the first flag. My lord, I have marked 2. Exhibit U1, Exhibit U2. Correct, my lords?
Right.
Does my lord Justice Pardiwala and Justice Mishra get? Yes. Now, kindly come to the second flag. And please see, my lord, the findings of this laboratory. From the above observations, it is concluded that, then B. So and so, I am not reading it. So please see the underlined portion, my lord, rest. The CBI will send this again for retesting by AIMS and some other level.
You have said in the status report that CBI is.
Malad, now,
Take the postmortem report once.
Malad, now,
Because it is shocking. Kindly take the top column and see whether all the wearing apparels were produced before the doctor.
Just 1 second, let me.
Of how it has been tampered. And the undergarment.
Do you have a copy of this?
No, I
report?
don't. But now compare it with the UD case.
Mr. Solicitor General,
Yes.
officer is present.
Yes.
Just ask him to take this report in his hand.
You have that.
The first line on the top. He doesn't want to disclose, no problem.
You have an answer you can give. You.
No, if it is coming in his way of investigation, he may not.
No.
We just want to know.
He knows he can also answer. But first line,
Just read it in your mind. The very first line,
your lordships are on this line, Manoj, and
you have this report, right?
correct. I'm just, and to understand.
Just
this line, we
give
are
it.
assisting your lordship with.
Correct. The one which we have marked in red.
Correct.
No. Sorry.
I'm sorry. Therefore, Manoj, I was also a little confused.
Sorry. Wait a minute. I'm marking it.
Yes,
Now it is bracketed with pencil.
correct.
Have they looked into this? Is it in the form of some interpolation or something? Did you get it?
Yes. Lord, that is under investigation. The time difference is a matter of investigation.
You
That's
have
what,
said that in your status report.
yes, and
Therefore, page 9 of your report
Looks up
Roman 4
Apropos what fell from you. Some of the aspects which you have highlighted are the subject matter of the investigation by the CBI. So obviously at this stage, when CBI is looking into it, we should not be commenting on
We
it presently.
appreciate that there was a previous FIR. That Lordships kindly just take 2 seconds and give me just 1 minute.
How do you say that there was a previous
I'll
FIR?
explain to your Lordships. Lordships will kindly take section 173 of the BNNS of the new code. It says on receipt of an information, an FIR is to be lodged. Now, what does 176(3) state? 176(3) of the BNS states that if an offense is above 7 years and a forensic expert has to be called for, on the receipt of an information regarding an offense, so there has to be an FIR. Without an FIR, 176(3) cannot come into play. The forensic team was there in the afternoon. So they could have only been called under section 176(3). So there has to be a previous FIR, because if there's no FIR, then you can't call the forensic team.
it's okay.
We are being led to believe that the first registration of the FIR takes place at 23:30 hours.
That's right.
There was a previous FIR, which was there. Now, Lordships also appreciate one more thing.
possibly he says there has to be. There has to be, not there was. Possibly, as I understand him, he said there has to be a
The
previous.
forensic team cannot come.
Otherwise, forensic you can't call.
There was an
176
FIR which has been
status.
suppressed or has been destroyed. By whoever, I do not know.
Yes. Okay.
I would
As
also
a-
kindly take the PM report once, kindly take the top
Look,
line.
at the same time, we have now looked at the status report, we have looked at what has been produced by the other side. There are UD entries, one is 542. Sorry, GD entries.
GD entry.
The GD entries, 540,
Right.
1 second. 542 first,
Till 10 AM. Well, that is also wrong.
that's a matter of, that is a matter of investigation.
Has to be at the,
That is a matter of investigation. Today, on the record that has been handed over, and CBI has also referred to it, is 542, 565, 576, And then
575, then 576,
565, 576, and then
577.
and 576 and 681.
No, then 577, that is the formal FIR.
My lord, leaving the brief aside, the problem is, my lord, we are dealing with, my lord, whenever rape and murder takes
These
place,
discrepancies
alleged,
which you have pointed out, CBI is alive to them. And on the basis of these discrepancies, CBI's further investigation is going on.
Yes, let them investigate.
Take the sample. Now the vaginal wash, the blood had to be preserved at 4 degrees centigrade. These three doctors purposely did not preserve it at 4 degrees centigrade. Now that sample might be contaminated. It has to be preserved at 4 degrees centigrade.
Well, if the CBI,
Not
if
me.
the-
therefore I said that there
doctors
is
are-
something very serious. I'll tell my lord, your lordships, in case of a rape and a murder, the first 5 hours are crucial. My lord, the first 5 hours is the period where you have to cordon off the area. You cannot have an ingress and outgress. Whoever wants to come and go, they take pictures, photographs, evidence is destroyed. And thereafter, after 5 days, if we enter the scene,
That's why
we have our own challenges.
We asked, the first question which we asked was, has the CCTV footage between 4:30 in the afternoon onwards been handed over to the
yes, it has
CBI?
been.
They say it has been.
Well, we've got
No,
the
no,
document of
27
handing over.
minutes.
CBI says that they have it. Let them look into the.
27 minutes only, not.
No, the entire, we've got the handed over document.
There is a little bit of a confusion on this, Mr. Solicitor. What CBI has been handed over, which you have also said, is about 23 or 27 minutes
20.
of 27 minutes pertaining to the actual search operation which takes place and the inquest which thereafter has taken place. We wanted to know whether you are in possession of the complete sequence of the CCTV between the time that the accused leaves the hall
Mullah, I've got
and
the document.
events
But
which
my lord,
take
the
place.
CCTV
over
will
document.
only show the accused entering, etc. Here.
No,
the
no,
crucial-
Who else, Mr.
Crucial
Solicitor, who else entered after the accused deadline?
Mullah, handed over,
dealt with the
over
body.
memorandum.
Look into these aspects.
Mullah,
We will.
Tell us on the next date of listing, because these are obviously, now that some leads have emerged, we'd like you to further investigate and come back to
Mullah,
us.
I just want to mention,
But only one.
can I have a word? Can I have a word?
My lord, may I just speak on behalf of the student?
Mullah,
Only a minute, ma'am. I'll just.
Yes,
in the
sure.
date.
this would go on till.
Different.
It's all there. Mullah, I just want to,
Not will kindly-
May I just say
Mullah,
two
may I?
words?
Whether the X-ray plate, because one of the body was found, the legs were found at a 90-degree angle. Now, 90-degree angle cannot take place without the hips being broken. I will kindly see in the postmortem report whether the X-ray plates have been handed over to the CBI.
Lord,
Whether the X-ray was actually done or whether the X-ray plates were handed over.
We've got the photographs with us.
Mr. Solicitor, just one question from your officer. When the body is dispatched from after the inquest for the purposes of the postmortem, you have that letter by which the body is dispatched for postmortem.
Yes, my lord, it is there, form number
Array, wait a minute.
5363.
Once again, how will you
Let
have
me
it?
have-
We are
I'm seeing the form number.
obviously, we're saying it with a certain purpose. We want to see that.
It will be a long.
I'll
document.
check up, my lord, and.
He knows everything.
Yeah, it is there. Because it was shown before the High Court, before the High Court I argued.
Can you just, 1 second,
I don't have it. It was before the High Court, it was argued.
just 1 second. Let's not get into these bickerings. We have flagged a document. We want to see that document. Do you have the document here?
Yes, I'll just my lord, check. Immediately. The body was handed over. From in.
Ms. Astha, do you have the documents?
We just were trying to see. But in the meantime, I just
All the
mentioned.
dead body chala.
Lord, in the meantime, can I
Just
just?
1 second. So only deflect Yeah, on one particular issue, let's seize that issue and then
Yes.
see if there is a satisfactory answer.
Yes.
Otherwise, CBI will look into our query by the next day.
There is also an antecedent aspect to what the lordship.
What, sir?
Yes, yes.
Till they find out, my lord, your lordships have kept it on
Tuesday.
17th. 17th. Can it be on 18th? 17th would be miscellaneous day. That's the only.
We'll get a little more time.
Yes, but no, miscellaneous day has its own problems, your lordship knows.
But let them
18th.
investigate it.
Mr. Sibal, do you have it?
Well, I only have this that is handed over, dead body challan that's handed over. That's all I have. To the family. Yes, to the family.
But not the family. It was from the
Come on now.
person who does the UD.
Let my lord, the
who
Chief
deals-
Justice,
It's
see
not
the
not
doc.
that-
This is the blank one. It would be like this. This is blank one.
I'm sorry, Malad. No, who can
This
read
is
this?
the blank one. It would be like this.
This is not what we are asking for.
No, no, I'm just saying
This
that's
is-
all we have at the moment.
Disposal order accompanying corpses sent for cremation. This is when the body is given to the parents for cremation.
I cannot find the document immediately.
We are just trying
This is
in.
the only thing we have at the moment. That's all I can say, Malad.
Because when the body is dispatched from the post-mortem after the inquest, surely the doctors who act on that and do the post-mortem would first look at what is given to them.
We just look at it.
It would be like this. No.
You just have the format.
The blank form.
All right, let's see the blank format. This is the challan for use when a dead body is sent for examination.
Yes.
Where is that filled out challan?
But it's part of the case diary because it was shown in the High
You
Court.
wouldn't know it. Let the CBI say. We asked
was there.
we asked the state of West Bengal whether they have it here in the court. Let them give it to us.
It should be part of the case diary. That's all we
But
get.
that is not
What's
given
the
to us.
form by which you handed
That
over?
is not given to us.
Not be given to you.
That's what my lord, my hand.
That's very important.
It's not in the file which is given to us.
Ms. Sharma, where is the challan when the dead body was
We're
sent
trying
for?
to figure out, Malad,
for
where
the
it is. We're trying to
post-mortem.
figure out. Huh? See, let's not state something unless we are absolutely sure what it is.
Month later and they're still figuring it out.
It's of very crucial importance because this form also has a column which says remarks noting what clothes and articles were sent in with the body, which means that together with the body, other things which have been then seized,
Must have been.
and other material is also sent to the doctors who conduct the post-mortem. We want to see that.
It was definitely a part of the CD when I argued the matter before the panel.
Part of the case diary.
The last column. Are you sure? Make sure. Have given, maybe. Or may have given, we don't know. They say they have not seen this and the file handed over to the CBI does not contain this document. But it appears from the argument of my learned friend that it exists because according to him, it was shown to the High Court.
No.
Without this, my lord, the post-mortem doctor cannot accept the body.
Post-mortem doctor will not carry out the PMR, the post-mortem, and he will not accept the body because first and foremost, he has to have a request in the challan that please, this body is being sent for the purpose of
On the
examining.
challan, he gives a seal saying accepted.
Mullahs, your lordships will give us time. We'll try and place everything before the court.
There, Mr. Sibbal.
It's not, Mullahs. We've checked it up. It's not there.
And CBI says that they also don't have the document under which the body was sent.
To us, that file does not contain
What
this
I'm
document.
told, what I'm told is that the CJM came, Mullahs, and he filled it up himself, and there's no separate form. That's what seems to have happened.
Was the postmortem carried out without a,
Again, it's
without,
impossible. It's
without
impossible.
a formal dispatch of a request to the postmortem doctors to carry out the
Not
postmortem?
just an administrative form, it's a statutory
Mullahs, I
form.
don't have that information. I can only
Just have this postmortem report in hand. You
in
must
hand.
be having
Postmortem
it, right?
report. Yes, we have it, Mullahs.
Now see the third column.
Yes.
See the third column on the top of it.
Third column.
Constable by whom brought.
Yeah.
So this constable is supposed to carry this.
This challan.
Okay.
He is supposed to carry this.
Yes.
And if there are any relatives accompanying, the names of those.
Sure. Yeah.
Now, it has been struck out.
Blank. That's blank.
So there is no reference of this challan for use when a dead body is sent for examination. You need to explain.
Yes, yes, certainly, Mullahs.
So tomorrow, if this document is missing,
Yeah.
then something is happening.
Yeah, sure, Mullahs. Sure. So we'll find out, Mullahs, as to why this is brought. This is why it crossed.
বইটা পাঠাবে
To that effect. Mullahs, we'll file the affidavit to that effect, Mullahs, so that we can't be making statements, Mullahs, in this fashion.
Solicitor, please do, if you need that, and that has not been forwarded to you, CBI should make a requisition for that.
No, certainly, my lord, we will have to end it, that fact being absent in the
Also,
postmortem
this in
report.
light of the fact that learned counsel says that when the matter was argued before the Calcutta High Court, that was part of the CD.
It was one of the video, it was live, streamed live. The lordships can call for the particular link and see it for your lordship self that it was shown. In fact,
But in absence of mention in the postmortem report, the possibility of it having been created subsequently cannot be ruled.
That's subject matter of investigation.
Investigation, I'll not say anything more.
Investigate.
Somebody has verified for the.
What has been created subsequently?
All right,
Nothing has been created.
all right, should
We'll
we
file an affidavit,
we'll
Mullahs.
move on to next
Yes.
Tuesday after this is
Yes,
over?
Mullahs.
My lord, Wednesday, my lord, Tuesday is a miscellaneous.
All right, Wednesday, Tuesday is miscellaneous.
Lord.
Keep it on Wednesday.
Lord, may I?
Wednesday, no. Wednesday.
One
18th.
second.
Well, Wednesday is 18th, that PMLA matter starts on Wednesday. Mullahs, please don't have it on Wednesday.
All right, we'll keep it on Tuesday after the miscellaneous board is over.
Yes.
So may I just say
Lord,
one
may
thing?
I say-
One thing.
Mullahs, can
No,
we?
but just one thing. So we are 1 month down now since this death took place. We do not have any clarity about the estimated time of death. I thought the postmortem report, which normally says, may not be exact, approximate, but we still don't, what is the West Bengal's case as to when this death took place? I would imagine they would say it's before 5 o'clock
Clarity
sometime.
on that. There is some clarity on that.
Yes. In the CBI,
There is clarity on two aspects.
Yes.
One, when the body was discovered,
yes.
there is some clarity on when the body was discovered. And there is some clarity about the movement which takes place in or around the room where she was staying for the night, where she came in late after the
But then the person,
stomach contents also reveal that,
she had a meal.
yes, that's right.
No, so there should be one more aspect then. The person who actually first discovered the body or learnt of it should actually be the first informant. And the time of his knowledge should be the time of the first information report. So the delay starts from there.
There's a delay of almost 14 hours in recording the first information report. It's very clear that there's a delay of about 14 hours. At least 14 hours.
14 hours, at least, yes.
My lords, if I may, with regard to the other investigation that is happening, with regard to the financial irregularities.
That CBI is investigating, but right now that is,
Exactly, the CBI is
obviously we have started that investigation, but we are on far more pressing issues at this point of time.
My lords, the trouble with that, the difficulty with that, and I am for those 25,000 doctors, which include, in fact, whistleblowers who have placed and are assisting the CBI and have placed documents with the CBI. Now, some of us are still in R.G.Kar Medical College, some of us are in the health department, and there are threats, frankly, my lords. So what we are seeking is that, my lords, just seek a status report for next time, because the two are inextricably connected, my lords, as the High Court has found, in fact, that the two are connected.
The nature of the link between the two is itself the subject matter of the investigation which is going on. Let's not say much more than that.
Absolutely. So we are not seeking that we see the status reports, of course, my lords. What we are seeking that my lords keep track of that.
Really, three issues.
Your Lordship,
I
Your
also did
Lordship,
not
may
take
I
it.
just say?
My lord,
Only
only a minute. Mr. Sibal was, Mr. Sibal was to explain why the administrator or my lord, superintendent was immediately accommodated somewhere else. But I did not start with that.
My Lord,
He was to explain that.
Your Lordship had told us to give the names of the miscreants, some of the miscreants that we know in R.G.Kar, and give them in a sealed cover. So, my lords, may I just give the names in the sealed cover to your Lordship?
Of those who vandalized the.
Of those who vandalized, who came to the scene, even tampered with the scene. So I'll just give
Look,
this sense.
One second.
Well, there's
Before you
nothing was
make a statement tampered with the
Fair, my
scene,
lords.
Yes.
please be a little careful. Tampered with the scene is a very strong word to
I
use.
just-
The vandals
no.
tampered with the scene.
I'll just show your
Look,
Lordship.
please
three
allow the
photographs.
CBI to investigate.
No, I'll just show your Lordship 3 photographs. Can I just show in sealed cover 3 photographs? That's all.
You want us to make any observation that the
No,
crime
I
scene
don't.
was
I just
tampered
want
with?
your
Look, the
Lordship.
investigation
Your
is going
Lordship,
on.
just look at these photographs. We've got them for
Follow.
your Lordship. And give these names, please. And give the names to Mr.
Don't know what.
Kim.
what's-
To DSG for the details.
The junior doctor.
West Bengal, front.
Well, the CBI has till date not said that their seal has been broken.
Sorry.
I don't know why these statements are being made.
See, I'm not saying
The
anything.
CBI itself does not say so, but you are saying
Please give me a second.
you can't.
My Lord
You
would
just
see
can't make
this
statements at
was-
random like that.
What
Lord,
time are these photographs
just
taken?
me-
What time are they taken? What is the
My
date?
Lord, this is at the, where the body is there. Annexure A2.
Time.
My Lord, this is on that
We're having
day,
a
on the day of the incident, and I've given the name of the person who is, and very many other persons who are unauthorized, who are going to that place. Then your Lordship would see page 2, annexure 3, where I've given other persons. They are all walking in and walking out as if it's not a scene. The very next day, my lord, just look at page 3, annexure 6. They
This
pray.
made our work a little more challenging. She's right. And but
One second. And last page, which is most important, my lord, just see the last page.
We saw the last meeting.
So what I'm saying, if the manner in which it is you can make out that this has been redone at a later time. Otherwise, there would be struggle, there would be some sites, there would be some stains. This is completely botched up, and the very next day, they demolished
Right, you made your point. I think he has
next
also
2
pointed out
rooms.
something.
But that,
Can you
what was,
or
my lorry friends not be
next-
able to explain it. What was that? That was the toilet,
Please.
which had a basin and the tiles on the wall. Now the entire tiles have been changed and the basins removed.
Please.
So even if you do the luminol test now, which is after washing of a crime scene, there's a test called the luminol test. Even if you do the luminol test, you will not come to
has
know
said
whether
the tiles
the
were removed?
accused actually went over there to wash his
Who has said
hands,
tiles
legs.
have been removed?
It's a
And
part of
Lord,
the
we are
report. It
also
was done on the
asking
10th.
Don't know what.
that
And
Well,
because the luminol test now fails, because the entire tiles
Well,
and the thing was changed.
my lord, two,
may I,
serious investigation.
Millard, may I make
my lord, two other
May I just-
requests. One, CISF is letting people go to the emergency room without checking the iCards because people say they are doctors or they say they are staff. Now in West Bengal, about 1 lakh odd people are civil employees who are over and above the police. And therefore, they seem to have identification cards without any verification. So they walk in and out. People who say they call them civic volunteers. Now that's dangerous. And this person was perhaps one of the either touts or a civic volunteer who's
He was
gone
a
in.
civic volunteer himself.
Yes, yes, that's what I'm
Huge
saying.
Jesus.
They may call themselves whatever, but they have no identification.
Because
no
we are the one who
verification.
arrested him.
This is going on because the moment that they say we are doctors, people are going.
CISF personnel are in charge of the security of the hospital.
Remove
Obviously,
the
they have to
social
take adequate measures to ensure that any person who's seeking to gain access to the emergency ward, it can't be a random access to anybody.
Yeah.
Otherwise, how are the doctors protected? So CISF has to tighten up the measures on who can access the emergency wards also.
Correct, Manoj.
It
You're
can't be that any random civic volunteer can have full access to the entire emergency ward, which is where all the doctors are on duty at critical care facilities in the hospital.
That is being done. Manoj, that is being done.
So please ask the CISF company to ensure that
It is
all-
ensured. I
all-
can assure your lordship, it is ensured.
that
She is saying.
all necessary security and safety precautions are adopted
Shall-
for protecting the doctors,
That-
especially
And
those who
what-
are on duty at R.G.Kar, because they were there, right?
My lord, one more request. On social media, photographs of this victim are being floated. These may be taken off. I'm requesting if that a general direction
Respect
can
the
be
dignity
given.
of the.
Because this is not
Of course, it's
permissible
not possible
anywhere in the
to-
world that it should be sensationalized or what it.
But the photographs which you have produced before us at random.
Because we were there, all of us were there, many of
taking
us,
pictures.
So
10, 20
Photographs are everywhere.
were there.
you mean to say you took the photographs?
My lord,
course.
I mean, several persons,
Where did
just
you get those
to-
photographs from?
the scene of crime was not cordoned at all. People were
But
walking
tell
in.
us, therefore you took those
It is
photographs.
our suspicion that next, the 2 seminar rooms was where the crime may have
You are
happened.
also showing
which
all
are
these
being
photographs, and
published.
how do you get possession of these photographs?
My lord, the fact is that they are being circulated. And this person, one of the persons, I've given the name of some 10, 20 people who are the main miscreants and in this hospital. And my lord, all other hospitals there are having this issue.
Mr. All counsel, we are going to direct that the photographs of the dead body of the deceased have to be forthwith removed from all social media.
Absolutely.
Correct, correct.
Because
Absolutely. We agree entirely with that.
damage has been done by the
Yes, yes.
circulation of these photographs. It said that all social media posts
Malaj, even the seizure list, Malaj,
circulating.
Not the only one aspect on
Photographs
this.
of the dead body of the deceased shall forthwith be removed to ensure the privacy and the dignity of
Dignity.
the victim.
Not direct.
Think of a family.
Direct.
may I add
Not
this,
something more than that.
including the seizure list, because there are issues of privacy involved. Malaj, seizure list includes all the garments, all the other things, Malaj, with photographs, all this is being circulated. Malaj, therefore, all this must stop.
Obviously, that leaked when you were in charge of the investigation.
No, not at all. Just the opposite. Published on 4th of, Malaj, published on 4th September, when the hearing is on 5th September.
Mr. Sibal, we'll,
My lord,
Only add one thing.
This is not fair, Malaj.
we'll see what happens on the next occasion.
Malaj,
There's a form,
ये form दे दो जरा.
Police.
5-3.
One addition, my lord, I would request. My lord, only one addition I would request. Direct and indirect photographs, because my lord, some of the photographs I have seen, my lord, the girl had a specific, my lord, hairstyle. So they remove the face, but the hairstyle is quite recognized.
During the course of the hearing, it has emerged that during the course of the hearing, the court has been apprised of the, into invert commas, challan for use when a dead body is sent for examination, into invert commas, complete. Full stop. the Solicitor General, on the instructions of the investigating officer of the CBI, states that the above challan, duly filled in, is not a part of the file which has been handed over to the CBI for investigation.
Sure.
Stop. Faced with the above, faced with the above. Is faced with the above, comma, it has been submitted by the learned counsel appearing on behalf of for the original petitioners before the Calcutta High Court.
One of the petitioners.
Appearing, saab ka naam likh lo. For one of the petitioners before the Calcutta High Court, that the form was, as a matter of fact, produced before the Calcutta High Court during the course of the hearings. Stop. The form is unavailable with Mr. Kapil Sibal, Learned Senior Counsel, and Mr. Astha Sharma appearing on behalf of the state of West Bengal at the present stage.
I just want to know whether it's form 5370.
5371.
I have 5370.
Can I just see?
What does it
I'll
say?
be able to tell you in 1 second.
It says,
Changes now.
formation of.
It is in another PRB.
No, that's for cremation.
No, not for cremation.
Yeah,
I have 5370 here, Malad.
Show
Can you show it to us for a
Yeah.
second? वो दिखाइए जरा.
No, give this.
नहीं, ये अलग है.
The identity, Malad, of the
Covers the one.
deceased. Name of deceased.
Number 53.
53 under
This is
174.
form number 54.
We wanted form 54.
54.
That is WB form number 5371.
This is form 53. Malad.
Even their file doesn't have, Malad, that's.
वहाँ पर आपने
So,
जो into
that
invert commas
justifies by
बताया,
saying that we
वहाँ
will.
पर लिख लीजिए into brackets WB form number 5371. The
पता कर लो.
PRB form number 54 dash Vide rule 282.
Milord, these
A
CIs,
copy of the form, a copy of the form duly filled in, comma, which shall be produced before this court on the next date of listing.
Milord, we have complaints.
My lord,
1 minute.
also to produce form number 5363.
What is 5363?
That is the case, when in a case diary, you have 172 in the old form. My lord, start date, end date of an investigation for a particular day. From there, your lordships can call out what exactly happened in this case after the investigation started. From there, your lordships, the first entry has to be the UDA case number, because it was lodged at
That is form 5363.
5363.
Do you have a pro forma of the form?
At the moment, I don't have it. But I can hand it over
Case
to.
diary would have been handed over to the CBI.
Please do that. Please do that to me. I'll hand it over to this.
Malad,
It says case
just
diary
look at form 5363 and keep it ready on the next date.
536.
5363, sir.
Just keep it ready.
Three.
We'll examine it on the.
find out.
Milord, various
My lords, one last thing that my
colleges-
lords may record.
various colleges, one,
Yeah.
Task force will be doing its work. In the meanwhile, CCTV cameras and distress
Yes.
call systems be installed in all hospitals. So that should be implemented firstly, my lord. Secondly, my lord, I have a suggestion that there should
We
be
filed the report, Malad.
connectivity between all hospitals and the nearest police station. That's one. And secondly, my lord, whenever a complaint is filed, why should a victim have to go to the police station if there is any incident of violence or harassment? The management of the hospital should be the complainant. That's second. And thirdly, my lord, we should go beyond the CCTV cameras. There should be wearable devices, as a badge or on the wrist, where if there is any violent incident, that should be immediately, that should lead to an alarm.
That we have asked the committee specifically to formulate it.
That's due tomorrow.
We expect the committee to come out with its
My
recommendation.
lords, that's due tomorrow. Could that be placed then on the next occasion? Because our doctors, my lords, are working, they're back at work and they are not feeling safe.
Well, they are not
So,
back at work.
my
This is one of the issues I've raised, madam.
25,000 doctors are back at
So
work.
Sibal,
One second.
we would expect the state of West Bengal to put into place, even without waiting for the report of the National Task Force,
My doctors are.
basic measures for ensuring.
We have done it, madam. We've done it already, madam. We filed an application.
Your status report merely indicates that funds have been sanctioned.
No, 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 no.
Not
no, madam.
indicated what steps have been adopted on the site.
Report, health secretary says all that, madam.
My lord,
Madam, can
my
I,
lord, the CISF,
If there are goons
If-
in the
madam,
hospital.
can I have the liberty, madam, at least to address your lordship for 5-7 minutes, madam?
That's the report of the health department?
Yes, yes.
Let's see what you have done.
Yeah.
My
Madam,
seek urgent direction.
One second.
My-
Just because there's a moment of silence is not a reason for everybody to just,
says State Department through, your lordship may see, page 1, 2, the surveillance, the rest.
no, page 1 is state government has issued comprehensive guideline on 19th August.
Next page.
Next page, madam, next page.
Sanction 37.28 crore.
No, no, and after that, CCTV, madam. CCTV surveillance cameras in medical colleges, other hospitals, state government has taken and installed additional CCTV cameras in all government.
1,747 CCTV cameras were functioning in medical colleges. Why would this offense have taken place?
Yes, yes, yeah, you're right, you're right.
But state government has taken the initiative to install additional 6,178 CCTV cameras.
Yeah.
Are being constructed. 893 additional duty restrooms are being constructed. Illumination is, state government is looking at the installation.
That naturally, these are not, they're not available there, madam, so we have to do this right away, madam.
But tell us one thing, what is it that the state government has installed at R.G.Kar, for instance? Tell us at R.G.Kar what
Today,
additional equipment has been installed after we took charge of the matter.
All right, I will tell you that, madam.
Not just that sanctions have been issued. We
No,
want
no,
to
no,
know
your
what is
lordship is
the,
absolutely
what
right.
is what is the progress on the ground that the
Let's
state government.
kindly see, we have said at page 4, madam, that we are taking up works regarding security infrastructure upgradation of R.G.Kar Medical College as suggested by CISF and assigned an amount of 50, that a copy of memo dated so-and-so, so-and-so. State government has given
taking up
distress
work. Tell
helpline
us-
numbers. CFS told us we are moving forward, madam, in that direction.
Tell us by the next date
Very well.
on what steps have actually been implemented on the ground.
Sure, madam, we'll do that.
Because we are back
Will
to
do.
work, my lords.
Definitely.
And let the district collectors, we look at the government hospitals. Let the district
Para
collectors.
7, madam.
Just one
Para
second,
7.
please.
at work.
Let the district collectors engage with the heads of each of the government medical colleges and ensure that whatever steps have to be taken are taken in the next 1 week.
Very well, we'll do that. But in the
So,
meantime,
Lord,
madam,
my lord,
madam, may I be able?
We'd be very
Can
grateful.
I have 5-7 minutes of your
Yes,
lordship's
sir.
time, madam? I'm sorry to trouble your lordships. Mullahs, kindly have a look at page 5 of this report, mullahs. Para 7. So see the problem that we are facing. 23 people have died, mullahs, because they don't come to work. Para 7, further, the resident doctors of different medical colleges and hospitals across the state have been abstaining from duty for the last 28 days. The healthcare system is facing severe disruptions and can come to a standstill as resident doctors are the backbone of the healthcare in government medical colleges and hospitals. Due to continued ceased work, public at large is suffering. Some of the details are as follows. 6 lakh individuals have been denied treatment as resident doctors are not attending OPDs. Where do we go from here, Malaj? Causing the delayed number of attendees of government medical colleges to drop from 70,000 to 40,000. This has restricted access to specialty and super specialty treatments, especially to poor patients such as cardiology, oncology, neurology. These facilities are only available in medical colleges. Cardiology treatments such as stenting and angiography have been withheld for approximately 1,500 patients. Then, Malaj, 20 cases of deaths have occurred. In the meantime, Malaj, we are now, another 3 have died, Malaj. They don't go to work.
May I answer
And Malaj,
that?
1 second.
My lord,
They ju-
may I
Malaj,
answer?
Your Lordship said last time, I remember now, allow me to please say something. Your Lordship said
Can
last
I-
time that you must
can-
go back to work. They
Can
don't
I
go back to
answer
work, Malaj. And
Can I answer that?
1 second.
None of our doctors are on stress.
Before you answer it, allow him to make his point.
Yes,
Exactly the-
yes.
So, Malad, therefore, your lordships may now indicate in your order that, Malad, if they don't go back to work, Malad, then proceedings will be taken against them. But it can't be, Malad, that people die, they don't go to hospitals, and Malad, if it's a cancer treatment, we are sending them to pilot hospitals, and they are dying there because they can't get this treatment.
Doctors are back, but what?
My lord,
We have, may I help you, booths, Malad, we have set up all over
let
they have
me
ransacked
answer.
those booths. This is what's happening on the ground. But Malad, because we don't get any time to even address your lordships on issues. And I'm very happy, Malad, at last we've got an opportunity. Then what's happening is, Malad, now protests are taking place all over the state. There is no program that is submitted to the police. There is no route that is submitted to the police. There is no permission sought from the police. They are protesting all over the place. Now, Malad, what do? This is what's happening on the ground. And now, Malad, it's turned into something entirely different, which I don't want to mention, Malad.
Who's appearing for the Doctors
My
Association?
lord, I'm appearing for the doctors.
I am
Malad,
for
41
senior
if I
doctors, my
show
lord.
your losses, the
See,
photographs,
doctors are at
41
work.
police
Let's
personnel
suffer
have been
junior
injured.
doctors.
One has lost his eye permanently.
Senior
And
doctors.
Malad, I've seen the photograph.
Not by doctors.
And they are denying treatment to the police. That's the other thing that's happening. And there's blood over their bodies, Malad. I have the photographs with me. If I show them to you, your losses
My
will
lord,
be shocked.
I,
60.
my lord, I appear for the
Malad, kindly
doctors
see now.
grant.
Well, let's kindly see the page 69. Yes, kindly see page 69.
If you can give us what he is saying.
Page 73 of our status report, of the police report. Malad, kindly just give me.
The state was
Allow
quite
me, Malad.
silent.
One
Malad.
second, please.
State
Mr.
was quite
Solicitor, I
silent
never
when your lordships
interrupted
were
you. Allow me
examining
to
the
say
offence.
something.
Now the state has
Mr.
become aggressive.
Solicitor, allow me to say something, please.
Lord,
Doing this all the time, interrupting whenever we, Malad, kindly come to an extra 44, page 73. Allow me. Please allow me. Malad, this is not fair, Malad.
As authorities of the state of West Bengal,
Malad.
they have said that a person had died within
Malad.
continuous and profuse bleeding.
Allah.
But that was a statement made on the social media by one of the.
Malad, kindly see 73.
On duty, are they not on?
No.
My lords, if I may
allow-
clarify, there are two
Can I-
sets of doctors.
Can I address your lordship
One second.
one
Yes.
by one?
Order. Do we record the assurance of all the council appearing on behalf of the doctors that you are on duty and you're not abstaining from work?
They are on
We are
duty,
not
they are
on
not,
duty.
and they will say why.
Just address
We
your
are on
lordship.
duty.
1 second.
Can I
Miss
address your
Salika?
lordship?
Yes, what is your statement?
So our statement is that the West Bengal Calcutta doctors, junior doctors are not on duty. There are 1737 hospitals and nursing homes in West Bengal, in which 1500 are fully on duty. Senior doctors, even in the balance, 200 odd are also on duty, but the junior doctors are not on duty because
Across the state of West Bengal?
no, Calcutta, only Calcutta. Yeah, so the figures are for the whole of West Bengal, but the ones who are not on duty are in Calcutta and its periphery. They are not on duty because they are still getting threats. People are being told, we know your father's in government service. We know what you will face.
No
I have
complaint has
given.
been filed, they say
I have-
anything.
1 minute. I have filed an application. I have given in sealed cover the name of some of the miscreants in R.G.Kar, R.G.Kar. And I have given a detail of at least 5 or 10 hospitals.
Putra, we
and
will
college-
direct that if the doctors resume work immediately, no adverse action shall be taken against them presently because of the fact that we are seized with the matter.
My lord, can I
But equally now, if they do not resume work as doctors, then we can't restrain the state government from taking disciplinary action. That's entirely within their jurisdiction.
My lord, first the action has to be from miscreants who are actually threatening them day in and day out. I've given examples of complaints by Burdwan Hospital, Midnapur Hospital, Medical College, Kolkata, Not, I didn't want to burden your lordship, so I gave 4 examples in Calcutta itself where there are threats to the doctors from within and without, just because, so we had, obviously, my lord, all they are asking, we should have separate rooms, separate toilets.
These,
I'll tell your lordship.
what are the threats about?
The threats are they are just bullying, beating. 1 minute, 1 minute, because several of these persons supported the R.G.Kar protests. So many of them are being victimized. There's a group which is being headed by a medical forum. I don't want to name it. I don't want to make it any political. I'm only saying apolitically that it cannot be that just because these students, and they are doing volunteer duty just outside the hospital in camps. They are working in various health clinics, and I can show the photographs.
Might as well go back to your work
No,
in the
because
hospital.
there we are receiving. So what I'm saying, we need a room for females to rest at night because 36-hour duty. We need a room for males separately. We need toilets for them. We need CCTVs. We need senior women, CISF people near us so that we are not threatened. I have no difficulty. If I can work inside, I can work inside, but I have to have a safe environment. And I have given a sealed cover. Sorry.
Ms. Luthra, just give us
Sorry.
30 seconds.
Sorry, my lord. Just
If you have the information on hand,
Yes.
you may give it to us. At a time, doctors, they work for 24 hours,
Yes,
correct?
yes.
At a time in a given shift, how many doctors, resident doctors work?
Okay, I'll find out, Mullas. I'll find out. I don't know, Mullas. I don't know. Mullas, may I request, apropos her complaint,
Female doctors are there at a time.
I'll find out. I don't know, Mullas.
Totally, how many hospitals in, public hospitals in the state of West Bengal? Is it correct?
Mostly-
1737?
Basically, Mullas, all the really healthcare network is in Calcutta itself. The large part of the network
How
is in
many,
Calcutta.
how many government hospitals are there?
In Calcutta or all over the place? In West Bengal. Government hospitals in West Bengal. We'll just find out, Mullas.
And in Calcutta?
We'll find that you should be able to.
All right, ऐसा लिख लीजिए.
About 24 or so.
Just 1 second. During the course of the hearing, a grievance has been made by the government of West Bengal in regard to the mass abstention from work of doctors from government
Junior
medical
doctors,
colleges.
my lords, it's
Junior
junior,
doctors.
it's only junior
Words
doctors.
in his mouth, right?
Pardon.
Of the of the abstention from work of resident doctors of
Yes, my lords.
medical colleges and hospitals across the state for 28 days, as a consequence of which the healthcare system is facing severe disruptions. Full stop. Paragraph 7 of the status report, paragraphs 7 and 8 of the status report, which has been filed by the Health Department of the state of West Bengal, are set out below. Copy down that. Next. We are of the view that before that you say the state of West Bengal must take necessary steps to create a degree of confidence, to create confidence in the minds of the of
All
the,
doctors.
of the doctors, that their concerns in regard to security and safety are being duly attended to. Full stop. In order to ensure this, comma, all the respective district collectors and superintendents of police shall take stock of the situation and ensure that necessary conditions have been created for ensuring the safety and security of all doctors in the government medical colleges and public hospitals, including, to brackets, provision of separate duty rooms for male and female personnel, semicolon, bracket 2, availability of toilet facilities for male and female personnel, semicolon, and bracket 3, the installation of CCTV cameras. Full stop. In the affidavit which has been in the status report, which has been filed on behalf of the state police, comma, it has been indicated that funds have been sanctioned by the state of West Bengal for setting up additional CCTV cameras in the government medical colleges and hospitals, and for carrying out necessary structural work and for carrying out necessary work towards creating other attendant facilities for the doctors. Full stop. This shall be continuously monitored by the district collectors in conjunction with the superintendents of police. Full stop. In order to create a sense of confidence among the doctors, we also direct that in the event that the doctors report for duty within a period of on or before 5 p.m. tomorrow, no adverse action, no adverse disciplinary action shall be adopted by the state of West Bengal. Full stop. Moreover, in the event that any complaint is made for their abstention from work for the antecedent period, full stop. In the event that any further complaint is received in regard to the lack of safety or, as the case may be, security, such complaints shall be promptly attended to by the superintendents of police by making suitable arrangements with the local police stations concerned. However, if there is a continued abstention from work despite the above facilities which have been directed to be put into place, there may be a likelihood of adverse action being adopted in the future, which may best be obviated by the return to work. Full stop. The resident doctors must be aware of, cannot be oblivious to the needs of the general community whom they are intended to serve, and should reciprocate by returning back to work within this period. Which
May I just... One second, hold on, I've not yet finished. Allow me...
One aspect. One, we are only 2% of the doctor force. We are just junior doctors. So we just senior doctors.
But you can't say others are working, so we need not work.
No, I'm not.
You have to get back to work.
I'm unsafe. I'm only saying, give me 3 days. And let them put an affidavit of compliance in place.
We are giving you 2 days. We have asked them within these 2 days for them to take necessary steps. That's why we didn't say today. We have given until 5 p.m. tomorrow, right?
May I now? What is all this? Is
but one of the most associated that a boy died out of.
Anyway, look, we are not here to either lend a ear to the politicization of the matter or other. All that we want to, we want to ensure that due security and safety is provided to the doctors, but equally, the young doctors must now return to work and attend to their patients.
Well, one second, I haven't finished. Just allow me, please. I'm on my...
Well, let's see what the protection is. Well, let's see page 73.
We know what is happening on the ground. All that we want to assure the doctors is first return to work. We have said that the district collectors and the superintendents of police will monitor the situation. They shall provide adequate facilities to ensure their safety and security. They must now come back to work. You can't say that, well, others are on work, therefore we will not
No,
work.
that's not at all an argument.
But
I'm just
equally,
saying that.
equally, we have put everybody on notice that if they do not return to work,
Yes, yes.
then please don't hold anybody responsible if disciplinary action is taken, because then
Lord,
we
we are
can't prevent
more
any
than
government
willing
from.
to work if we are working outside.
Hold
But
on. May I finish?
May I say one thing?
What? I haven't finished, my dear.
There is a threat.
Take your time
and I-
after lunch.
Ms. Luthra, we have therefore taken care of your submission on the threat. We have
Yes,
said
yes.
that.
My Lord, the names of the miscreants, can I give it to the solicitor?
Give it to Mr. Solicitor.
Yes, my Lord.
Yes.
There are several miscreants in this hospital itself.
Well,
We are
let's-
giving
well,
the
let's-
names to the solicitor.
Malad, may I finish, Malad? Now kindly turn to page 73, Malad, of the police status report.
So what is that?
Well, just have a look at it, Malad. There are some photographs your lordships will see, Malad.
Yes.
Give it to my lord.
One second. You filed it, right?
Yes, we filed it. Therefore, I'm saying, yesterday we filed it, we circulated. We have hard copy now, Malad.
Status report by Kolkata Police.
Page 73, Malad. Annexure 44.
Sir,
It may be given to
44.
us, otherwise I'm not.
it only goes on to Annexure A37.
No.
Page 73.
Page 44, page 73. We've got hard copies. Just have a look at it, Malad.
Very small.
PDF
78.
PDF should be 78, I believe, Malad.
Anything else left? But that is dealing with. Action against threat culture.
On the ground, Malad.
Therefore, we've asked the doctors to come back to work first and foremost. And we've seen this as well.
Yes. Okay. Now, Malad, then two more things. Number one, Malad, there should be no protest without an application to hold the protest, and the route to, they just hold the protest without informing anybody.
In the last order, we have clarified that when we said that you will not take any action against peaceful protesters,
Yes.
we had equally said that.
One second.
Respect of any protest which.
Well, see what is happening.
And protest will not be, any protest will not be at the cost of their duties.
Yes. This is not clarified. This was not clarified, Malad. This is not the doctors. These are not the doctors, Malad. Malad.
All right, let him say what he has to say. We got your point.
Nobody has protested beyond duty time.
But letter was sent to the protesters on the Kolkata police, wherein that sought for certain information. But in that letter, it was categorically all the necessary information was served upon the police with regard to rally that they mark that is going to be.
No.
Everywhere. False statements have been made.
Malad, which court are we in, Malad?
Unless their courts, no regulator.
This.
Kolkata police, nor the West Bengal police, they did nothing on the part of the regulatory.
All right.
And it's beyond duty.
One last word, and then we are going to rise for lunch. We want to ensure that the doctors resume work.
Only one thing, Malad, they
Doctors are in the system to render service to the patients. We will provide every kind of measure of security to the doctors, but they have to reciprocate. We have said that no adverse action shall be taken.
Yes, please.
My lords, if they are also protesting and joining work.
We have CCTV footage. Malad.
When we said that no, one second, we said that, why don't you hear what we said? We said that no adverse action shall be taken against the doctors. Mr. Sibal, please ensure that those of the doctors who resume work, please don't take any action.
It's our duty. It's our duty, Malad. It's our duty. This gentleman who is before your lordships, I have got videos, photographs, he's throwing stones.
Lordship, there has been
This gentleman.
Lordship, a threat culture has been established.
Mr. Sibal, Learned Senior Counsel states that no action, including punitive transfers, shall be adopted against the doctors who return to work in terms of the directions and stipulations.
Those are the peaceful protesters also, right?
IA.
Kindly see.
Because the individual who was found to throw stones.
Yeah.
These sort of submissions come from.
What? 1 second. Are you trying to address the gallery outside the court?
That's what he's doing.
1 second. Can we just, I've been noticing your demeanor for the last 2 hours. Can you first lower your pitch?
I'm sorry.
Please lower, 1 second. Listen to the Chief Justice. Don't raise your voice. Lower your pitch.
My lord,
Second, you are addressing 3 judges in front of you, not the large audience which is watching this proceedings in the video conferencing platform. 2, Mr. Sibbal's statement, we can't start recording every police officer's statement here, right? Mr. Sibbal is representing the state of West Bengal. We have recorded that there will be no adverse action, including punitive transfer. You said transfers. We have said, therefore, no punitive transfer shall be resorted to. Right? Therefore, there's no
one
point
thing.
raising the
No, but
Lordship, the peaceful protesters
The last thing is
who had
the application
participated
we
in-
have filed. Well, there's an application for
participated
directions
in
that I have
reclaiming
filed,
the
Manas,
right.
which has some really serious things that your lordships have to deal with. Well, the kind of things that are in this application and the statements made in this application will destroy the credibility of institutions in this country if this is allowed to happen. Well, I seriously, I request your lordships.
Sibbal,
Yes.
have a copy given of that to Mr. Solicitor.
Yes, I will do that.
Please give it to me.
I will do that.
Lordship, only
Manas,
one thing,
And
Lordship.
Manas,
Lordships, may I?
your lordships must be on this, decide on the parameters
Lordship, may I?
that are to be adopted in matters of this nature. Because this can't go on, Manas. It will destroy institutions. I can tell your lordships that, if this is allowed to go on. And your lordship, Manas, lawyers are threatened.
Lordships, may I mention?
Our lady lawyers are threatened, Manas. This is what is happening.
Your Lordships, may I mention an IA? Your Lordship,
Kind of things that have been said, Manas, your lordships can't imagine.
My lords, can doctors and other peaceful protesters be protected? Other government employees, my lords?
We have said doctors. We are concerned with doctors here.
My lords,
Concerned with doctors. The others, we are in charge of the matter relating to the doctors because this, all of it originated in the act of the crime at the R.G.Kar College. We are not concerned with the wider aspects of what government employees are doing. That's for the state government to handle their employees. So far as the doctors are concerned, because we are also concerned about their safety. We have said that their safety shall be protected, but they must go back to work. We are very clear on that.
I seek
on the matter
my
of
lords,
peaceful
I seek
protest,
a-
what's up?
If all of you, one second.
Your Lordship,
7 or 8 people, at least in the last 20, I'm not used to this kind of advocacy where 7 or 8 people are arguing at the same
While-
time. We'll now take up the matter, I think.
my lords, your Lordships, may I mention an IA? Your Lordship,
This must stop.
my lords,
This
if
must
I
stop.
seek a very single
Stop
direction.
this.
My lords,
Lord, only one line.
my lords,
Instead of assisting the court,
Sir.
the state has sought to politicize, but Lord, I can't help it.
my lords, one line, if I may.
Politicized.
It's a very limited direction with respect to the constitution of the NTF, my lords, if I may, please.
If this is called politicization, God save this country.
Yes, my lords.
What do you want to say about the constitution of the NTF?
My lords,
Surely you know this, that when an order is passed by the highest court,
yes, my
you
lords.
can't just bring up and say, I want a change in the constitution.
Not a change, my lords, not a change, my lords. Only one consideration by my lords.
Yes.
My lords, all I pray is that one representative of the dental association may be added to it. This is, and there's a reason for it, my lords.
We have asked the NTF to engage all stakeholders. Are you a stakeholder? Are you not a stakeholder?
We are stakeholders, but there's a reason.
Therefore, all that you have to do is you submit an email. Last time we have created a portal where any request can be made to the NTF. Submit an email on behalf of the dental association.
Sir.
We have these concerns. Please take these concerns into mind. They will hear the dental association.
Yeah, my lord.
Okay?
Your lordships, if
Can't keep
I,
adding people in there.
Sir,
All
my
that you have to
lordships-
do is you have to submit. We have laid down modalities
Sir.
for every stakeholder to engage with the National Task Force. We can't have individuals now indebted to the task.
your lordships, if I may mention, my lord, your lordships, if I, your lordships, if I may mention, your lordship.
Participating in the protest, day-to-day protest, who participate in the reclaiming of rights, and who are also holding their protest peacefully throughout Calcutta or other suburbs area also. Kindly, police should not take any adverse steps against.
What we have said last time still continues to remain in operation.
Great.
That's not until today. That's an
They
order.
don't ask for permission, Malad. They don't ask for- It's not peaceful. You've seen the photographs.
Your Lordships,
We are keeping it next week now.
Your Lordships, Your Lordships, I have a small submission.
All right, this young lawyer here, yes.
Your Lordships, I appear for senior doctors in the state of Haryana. Your Lordships, the state of Haryana had an act in 2009. It has been 19 years, Your Lordship, there's been no implementation. The first FIR that was even registered was in 2017. Your Lordship, what?
We'll have to delink your matter and deal with it as an individual matter separately.
Your Lordship, what I propose.
Instead of the intervention, you file whatever you want to file for him.
I propose, Your Lordship, I have a proposal. If Your Lordships may direct the state governments to send a status report to the NTF, so the NTF can take into consideration the ground realities and why have the acts not been implemented till now?
But that's one act in.
No, Your Lordships, there are 21 states which have the act.
No, we have referred to that in our.
Yes, Your Lordships.
But can we issue those directions in an intervention? You must also know that there's.
I'll file.
While your lordships are rising, all this should not happen, Manoj. I'm sorry to say, but this should not happen at all.
Can you just pass it?
The board.
My lord, before your lordship takes up item 2, my lord, may I respectfully submit?
Not in the previous matter.
No, no, only thing, my lord, only previous matter, I'm not saying on merits.
No,
But
no,
we
no.
have a,
The previous matter is over, sorry.
we have a grievance, my lord, that we are not heard because we are disciplined members of the bar. Those who shout, my lord, they are being heard.
Thank
That's
you
all,
for
my
your
lord.
compliment. Item 2.
Very well, lord.
Your Honor, I have come from Pune.
This
I'm
is all
Dr.
I have to
Rajiv
say.
Joshi. I have come from
Item two?
Pune. Item 2, I am appearing.
Item 2. Yes.
I want to give some documents.
It is being called out, sir.
The only submission, Millard, is this whether it is a single project or not, Millard.
Yeah.
Kindly
They
appreciate.
are different projects, different RERA.
Millard, kindly appreciate, Millard. That's my submission. The only submission, whether it is a single solitary project and 2 documents. One is the sanction plan, another the builder or the project promoter's document. Kindly appreciate, Millard, the 2 documents, and that's it. I won't bother you beyond that. Kindly come, Millard, to page 751, 752. Otherwise, it is in volume 3, Millard. And this is nothing but sanction plan, Millard, of the entire township. Township have many facets. There may be sub-projects.
Substantial question of law on this.
No, Millard, if your lordship won't mind, as I said, I'm not going to pursue it further than these 2 documents.
Yes, 751.
And I'm sure I will pursue it.
Annexure.
Annexure 14, Millard, page 751.
Yes.
And kindly see, Millard, at the bottom of the page, Millard, of rather the sanction plan, project name on the left-hand side, your lordship will see that.
Once there are different projects, project finance is arranged differently.
No, Millard, kindly, the sanction plan says it is one project,
Maybe so for the
high-tech
sanction
city,
plan,
Dadri, Millard, and then the land
second
uses
document,
are different.
Which is the second document?
Your lordship has page 20.
Yes.
Your lordship may kindly see the first part and the disability range in that the middle column, eligibility for medical course, eligible for PWD quota. 40 to 80% disablement. Person with more than 80% disability may also be allowed on case-to-case basis, and their functional capacity will be determined with the aid of assistive device. If it is being used to see if it is brought below 80% and whether they possess sufficient motor ability as required to pursue and complete the course satisfactorily. Now, my respectful submission is, your lordship, the medical board ought to examine 2 things, your lordship. The first is what is the percentage of disability, and secondly, the medical board ought to have considered
Donation and on the specially petition.
Please, your lordship.
Returnable on, keep it after 2 weeks. That's the permitted in addition. Who are the respondents?
Your lordship, the respondent in this case is
State of Chhattisgarh. Liberty to serve the standing counsel for the state of Chhattisgarh in addition.
and also, your lordship, the college in which I got the provisional admission, they are also party. I'll serve thus the. I'm deeply obliged, your lordship.
We'll have a re-examine back games or
Your lordship.
Connect. Yeah. I am a sufferer and
We have issued notice in that section 15 challenge, Khopkar's case.
that is coming for 27 September.
Yes, we'll issue notice and tag.
Can I make one request? In the Khopkar case, there was SLP also, and in tag matters, there are SLPs also. Now, my SLP has been listed by the registry before court number 7. So that, because
Sorry, you tell court number 7.
I have told your lordship, just say we will examine whether it is connected, because my substantial issue is this. Even the report has been given by the registry that the matter is pending before this court. So I can't, I have.
All right, we'll see what to do. Next, just remind us on the next on the 27th when it comes.
Please, please. Your lordship.
Main exams have also been held here.
Yes,
What can be done now?
Lordship, this is,
You are now dealing with the preliminary exam.
no,
That's the second time that's happening. Last year also the same thing.
I know, but now with the main exams having been held, how can we now go into the preliminary exam? You are relying on three questions, questions 9, 48.
Not religious questions, Lordship. My objections are at the 4 level, and most important is also is the cutoff. Lordship may have page number 7, Lordship, of my SLP.
There was no cutoff for the screening test, for the reason that the screening test was only to ensure that the number of candidates who appear for the mains was 10 times the number of vacancies. Therefore, otherwise there was really no cutoff as such. It only.
If you see, Lordship, the page number 7, the judgment, the part of an order that has come from the Honorable Court, the page number 7, Lordship.
And there were not enough categories, not enough students from SC/ST categories. Therefore, they said with candidates with lower marks were also deemed eligible for the main exam. Otherwise, whether they appear or not, they have to clear the main exam.
But in unreserved categories also, as per the High Court, the cutoff is 233. They have also allowed students who have scored 230, 231, 232 to also appear. So the cutoff which they have given, I mean, what is the sanctity of cutoff which is being given? And then there are people who are appearing who are below.
You were below it also.
No, but these are in unreserved. So there are issues in unreserved categories also, the female categories also. So the cutoff, what they are saying is 233 in the next cutoff, but also they are allowing somebody who has scored 232, 231 and all to appear in the examinations.
But thereafter they may have failed the main examination. They may have failed the main examination.
But my score is, Lordship, 210. In that case, somebody who is getting 212 in the unreserved female category and the cutoff is 213. Now the High Court is saying the cutoff is 213, but they are allowing somebody who is to appear in 212.
Can't interfere at this stage because your whole grievance is about the preliminary exam. But after the main has taken place, therefore the preliminary exam now ceases to have any relevance.
Lordship, there has been instances within the High Court itself where 2 times the examination have been conducted in the past. 2021 also the same thing.
Prepare better for the next exam because now everything has come to an end with the main.
It has not come to an Lordship because the results have not been announced also.
Now we can't have a fresh preliminary exam for you now.
No, I'm not saying the
or a fresh main exam. The main exam is also held.
Lordship, the issue is, I mean, the whole judgment.
I think we'll not interfere.
Judgment says that 233 and they are allowing somebody's.
Item 8. 8 is a section 11 matter, right? We'll issue notice.
For the applicant.
We'll issue notice, make it returnable in 3 weeks. Thus the permit. Liberty to serve the respondent by email in addition.
Lordships, I had just one request. I have seen the records. The respondent is quite responsive. He is responding to emails, etc. Returnable date may be given. Ultimately, the
we'll make it returnable, yes.
I am deeply obliged.
Item 9.
So, my lords, there are already a bunch of petitions which
so
are.
Why should we transfer your petition? You go on with your petition before
I'll just explain why. My lords, ours is a notification.
Your petition of 2021.
So what has happened is this, it's in respect of a notification of 2018, right, under which, my lords, this temple has been acquired under the 23B of the Act. Now, my lords, I cannot challenge 23B before the High Court because the High Court actually decided the constitutional, it struck down the validity of the Act. And the matter is pending over here, that bunch. So, my lord, it would significantly enhance, my lord, my case if I'm able to address the court on 23 as well, which I cannot do before the High Court.
But you can intervene in this proceeding because your petition is independently also challenging the takeover, not just the.
Yes, but below that can be relegated. But what would happen
Otherwise, what will happen is that if we tag it here, our court will be dealing with those issues on merits also.
My lord, all the court would.
Unless you're giving up everything else.
My lord, if the validity is decided in my as in the act is struck down, then in any case,
but if it is upheld, then you'll still have a challenge, right?
I still have it. Then it may be relegated. But my lord, at least.
That's it. Why this? You can intervene in the pending proceedings on the constitutional validity. So you have your day in court, you file an IA for intervention.
Liberty to do that.
You can do that.
Well, your lordship may indicate because once a transfer petition is.
All right. Since the writ petition filed by since the writ petition under Article 226 of the Constitution is pending before the High Court of Karnataka, there is no reason or justification for a transfer of those proceedings here. stop. However, we clarify that in the pending proceedings before this court, where the validity of section 23, capital B, right?
No, my lords, just B.
23,
Just B, small b.
bracket small b, is stated to be in question, comma. It will be open to the petitioner to move an appropriate application for intervention if they are so advised.
Very well. And my lord, we hope that the High Court will also expedite it. It's a 2019 petition. Yes. Very well. I'm obliged.
इसमें गवाही साहब ने notice issue किया है.
If you may please, my lords. My lords, an identical set of matter, my lords raising question of law, same question of law.
Sorry, we can't have it. Obliged, your lordship.
This is an important petition dealing with international humanitarian law. In fact, my Lord, Gaza is
What is the
facing
relief?
worst. The relief is to
You are
stop
seeking a direction to the Union of India to cancel existing licenses and all the issuance of new licenses for the export of arms and military equipment to Israel.
That's right.
Mr. Bhushan, how can the court
Yes.
adopt this kind of jurisdiction? It's a matter for the conduct of foreign policy or defense policy.
No policy can be against.
We can't tell the government that you shall not export to, say, country X, or that you will cancel all license for defense exports to a particular country. It's a matter of it's a matter of national policy.
If the export is to a country which is committing genocide, the International Court of Justice has held so, the Hague Court of Appeals has held so, the UN experts say so,
But way municipal courts
yes,
and the government of the day,
yes,
ultimately the conduct of two aspects, the conduct of war.
yes,
Of course, we are not dealing with the conduct of war by the union government.
correct.
But the conduct of foreign policy is entirely a matter for, it's a political expediency of the government of the day.
With great respect, my lord.
We can't say to the government that you are exporting, say, solar power, or you are exporting, say, you're supplying oil to a particular nation. Stop supplying oil. I mean, where do we get that jurisdiction?
Yes, my lord. So let me answer that. If the export of arms to a country which is committing genocide, which has been held by the International Court of Justice to be committing genocide, and those arms are going to assist, aid and abet and assist in that genocide, then, my lord,
ICJ didn't go as far as to say that Israel was committing an act of genocide.
Yes.
ICJ's judgment was a very guarded judgment. They never went to that.
No, in fact, my lord, they have said, if your lordship,
Mr. Bhushan, the
this
point
is
is
the
this.
provisional measure.
Any such direction will immediately impact upon India's conduct of foreign relations with a foreign state.
But this is a very
To what extent should the government do that, not do that? It's a matter of national self-interest as evaluated by the government. How do we prevent the government from doing that?
With great respect, my lord, if that national self-interest is against the law, is against the law, against the Genocide Convention.
But look, see, under the Foreign Trade Regulation and Development Act or the Customs Act,
yes,
government can ban. For instance, in the case of Pakistan, I remember, we dealt with the Brother Justice Joseph and my judgment.
Yes.
What time did the notification come into force?
Yes.
A very interesting point which we decided. But it was, if the government issues a notification under the Foreign Trade Act,
yes,
banning, then that has to be enforced.
No, I agree.
But can the court direct the government?
One more aspect would I would like to be heard.
I'll
One
answer your
interesting
lordship's
aspect would be,
question.
will the
Let
constitutional
me-
court of one country,
Let me
only a
make my
minute,
submissions, my lord. If the Union of India wants to respond to it, they can respond to it.
Yeah,
But my lord, if they don't want to respond, then they should file a form.
Now see Article 253.
Yes.
Notwithstanding anything in the foregoing provisions of this chapter, page 250.
What is your lordship reading?
Article 253.
Huh.
Parliament has the power to make any law
Yes.
for the whole or any part of the territory of India
Yes.
for implementing any treaty, agreement, or convention with any other country or countries, or any decision made by any international conference, association, or other body. Yeah, absolute power of Parliament to either implement a foreign convention.
They have ratified the Genocide Convention.
But now convert it into a law is the domain of Parliament.
No, I'm saying.
We can't say that, look,
Your Lordship has
this is
held.
what we held, even if Parliament is silent for some reason, that we direct now that you will stop exports to this country.
There are any number of judgments of this court which say, including your Lordship's recent judgment in Puttaswamy, including Gramophone Company, including Vishaka, which say that so long as an international convention ratified by India is not inconsistent with our municipal law, it can be and should be read into municipal law.
Absolutely.
That was the basis.
Very absolutely correct.
Now, my lord, the Genocide Convention is ratified by India. Therefore, it can be read into municipal law. International Court of Justice is saying that export of arms by any country to Israel at this point of time, when genocide is being committed by Israel in Gaza, would amount to violation of the Convention of Genocide. And therefore,
in our law, the union government is entrusted with the power to ban exports. Right?
Yes, yes.
Now, the union government has not exercised the power for whatever reason. It's a matter entirely of.
But policy cannot be against law. The question is whether an international convention ratified by India can be read into our law, can be understood to be part of municipal law or not. And therefore, any policy, whether it is.
We accept that for a moment.
Policy
Let's say the Genocide Convention, our law should be so interpreted so as to give effect to an international agreement.
Yes.
You say that we are a party to the Genocide Convention. Right. But that's one thing, no difficulty at all about it. But can we say that in the exercise of your duty under the Genocide Convention, you, Government of India, shall ban exports to Israel?
In fact, my lord, in fact,
gravely doubtful because, you know, this will seriously impact. Why is this restrained? Because what is the fallout on international relations? What is the fallout on the position of our India, of the nation in relation to the conduct of international relations?
So your lordship may.
It's something we are not aware of. We don't know what the fallout will be.
Your lordship may read ICJ's opinion on Nicaragua versus Germany. Just read this part. ICJ's judgment on Nicaragua versus.
There's no difficulty. I mean, the ICJ operates in a different sphere. The municipal courts, we are the municipal court, the highest municipal court.
The basis that they have given is, that this will amount to a violation of the Convention of Genocide. And therefore, arms exports at a time when genocide is being committed by Israel on Gaza, to Israel at such point of time, arms which could be used for that genocide.
Now take a different case.
Yes, yes.
There is a war between Russia and Ukraine.
Yes.
All right?
Yes.
Russia today is supplying oil to India.
Yes.
Matter of economic self-interest, our energy needs have to be catered to.
Certainly.
Right? Can the Supreme Court direct the government of India that you shall not source oil from Russia because Russia, theoretically, some petition comes before us and says that Russia is in violation of this particular international convention. We are not saying they are, only for the sake of argument. Can we then direct the government of India that you shall stop importing oil from Russia?
In this
we
case,
can't, obviously, because ultimately it's a question of, you know, the energy needs of the nation. It's a matter of the conduct of foreign policy. To the extent to which the government should deal with, say, Russia, not deal with Russia, it's a matter exclusively of the conduct of foreign policy.
Great respect.
Same thing in its application to, say Bangladesh now. There are disturbances which are taking place in Bangladesh. What should be the extent of the economic engagement with a neighboring country? Entirely a matter for government to decide.
No problem, my lord. I am not saying that the court can interfere with policy or foreign policy normally. But this is a very special case, very different case.
Or we had a problem, say, in Maldives, right? We had a defense agreement with Maldives. That our
Lord, I am not saying, I am distinguishing.
You can't then make a distinction. You know, look at the look at the cumulative consequences. Maldives, we had our defense personnel situated. New government came into Maldives after elections. They said, remove your defense personnel. Can we then say, now people are, say, traveling from here to Maldives for tourism. We have Indian hotels in tourism. Can we issue a direction to the government that you ask all the investment to be repatriated to India?
My lord, with great respect, my lord, that's an entirely different situation. Here is a situation where it is absolutely crystal clear. Any number of UN bodies have said that Israel is committing genocide. Hospitals are being bombed. Schools are being bombed. Aid workers are being bombed. Aid workers are being prevented to supply aid to the dying and starving children and the injured people there. This is the finding of any number of United Nations bodies, which has been noted by the ICJ in its provisional order, by which they say that Israel must take all steps immediately to stop this genocide. And in another order, Nicaragua versus Germany, the International Court says that subsequent judgment, it says that the export of arms I am not at all saying, I should not be heard as saying that this court can interfere with any normal foreign policy. And I agree that this is a matter of normal foreign policy also. But here is a very special situation, very unusual situation. This is a situation, International Court of Appeals, the Court of Appeals at The Hague, Netherlands. Spain stopped a ship which was carrying arms from India to Israel on the ground. From India to Israel, it was en route stopping at Spain. They said we cannot allow this ship to berth in India because it's...
Mr. Bhushan, yes. Envisage a situation.
Yes, no.
Before the start of this war between Israel and Gaza,
yes,
if the country has entered into a contract with us for supply of arms or anything,
yes,
and that we have to fulfill that contract.
No, Lord, with great
would you say that it is your assumption that they may be used? Your allegations are of genocide.
It's clear. It's clear, my lord, from the nature of the export.
You have raised a very delicate issue, and court should not interfere.
My lord, with great respect, my lord, what is the duty of a court? Of a court which is to enforce fundamental rights, enforce the Constitution, enforce the laws. The duty of a court is to ensure that Article 21 rights. Now, your lordship has held that the fundamental rights interpretation can be tailored in accordance with international conventions that we have ratified. Article 21 is applicable to non-citizens also. It has been held by this court in any number of cases. Now, the question is, when there is a country which is committing, which is no doubt about it, any number of...
That's a very wide statement, no doubt about it.
No, my lord,
wide statement.
any number of UN, ICJ, human rights, UN...
very wide statement, we should not.
Lord, it has been said so by the ICJ. Just let me read, Lord, what the ICJ says about this genocide.
Their role is different.
What's Lord?
Yes.
Sorry.
ICJ says all the UN organizations say that genocide is being committed, hospitals are being bombed, schools are being bombed, aid workers are being bombed, they are being stopped from going and providing aid even to these injured children, etc.
Let's not get into all this. It may unnecessarily create problems for our country. Sorry.
With great respect, my lord, it is the duty of a constitutional court to interpret the law of this country in accordance with international humanitarian law which India has ratified. That's what this court has held in so many cases.
But therefore, does that mean that we issue a mandamus that you shall issue a notification prohibiting exports?
In great.
Otherwise, look at it this way. As Brother Padiola just said, there would be contracts by Indian companies. We are now also an exporter of capital. We are not just importers. Suppose we issue a mandamus as you are seeking, or we grant an injunction.
Yes.
An Indian company tomorrow is saddled with a claim for damages for breach of contract.
They will say,
I'm ready to supply. I've made arrangements. I've invested money. But because our Supreme Court has now injuncted me, I'm open to a claim for damages in an international arbitration proceeding.
great
Then
respect.
how can we look at the grave hardship?
great respect, my lord,
These
that
are
would be
facets
force
which government
majeure.
can evaluate. That look, what will be the impact on India's companies? Is ultimately, is this net result? Is this in the interest of the nation as an international global state? Government is also seized to the fact that we are a very responsible power. But conduct of foreign policy, therefore, courts don't step in to this area, you know, because it's replete. Actually, in a state of war, we can say it's replete with a minefield of undeliverables by the court.
Not just the ICJ, but also the Hague Court of Appeal says so explicitly.
Will record a short
Explicitly, my lord, says so explicitly
the
that this would be. UK has suspended, my lord. Just see the letter written by 600 jurists, including 4 retired Supreme Court judges of UK, to the UK, on which, my lord, the UK government has suspended the export.
The action was not by the UK Supreme Court. It was by the UK government. Today, if the government of India does it, well and good. It's for them to take a call.
True. But if the government, if our government is not doing so.
Mr. Bhushan, only give me a minute. Lord, whether to decide, whether to term a particular action of one foreign country to be an act of aggression or genocide or act of defense, etc., that's essentially a diplomatic policy of the government. Lord, would the Constitutional Court take a call accepting that this is a genocidal act and therefore the treaty applies and therefore, my lord, even the contracts are to be interdicted? Well, that would be very.
The petition invoking Article 32 of the Constitution has been instituted by former civil servants, scholars, activists, and experts in fields such as international relations, human rights, and policy analysis. Full stop. The petition seeks directions to the Union government to cancel existing licenses, stroke permissions, and to halt the grant of new licenses to companies in India for the export of arms and other military equipment to Israel during the ongoing conflict in Gaza. Full stop. These companies, as the petitioner has described, include a public sector enterprise under the Ministry of Defense, Munition India Limited, and private companies such as Premier and private companies which have allegedly been granted licenses post October 2023. The petitioners claim a violation of India's international law obligations and of Articles 14, 21, and 51, bracket C of the Constitution. Full stop. Next.
As well as under the...
Yeah.
And the International Convention side, which India has ratified.
Supporting the submissions, or submissions of the petitioners, Mr. Prashant Bhushan, Learned Counsel, urged, has relied on the rulings of the International Court of Justice dealing with
I wasn't able to show your lordship.
We have relied on the well settled. We didn't go into the merits. Relied on the rulings of the International Court of Justice in regard to the conduct of Israel, allegedly into the conduct of Israel in the Palestinian territory. Full stop. The submission is that India is bound by international treaties which disallow the supply of military weapons to states who have engaged in war crimes, stroke genocide. Full stop. In other words, the submission is that the continuation of the export licenses would constitute action complicit against the Genocide Convention and other international obligations to which India has assumed. Full stop. Next. The fundamental objection to the maintainability of a petition of the nature that is before the court is simple. It lies in the fact that both in relation to the conduct of defense and engagement in foreign affairs.
Is your lordship saying that law or no law that would be?
So conduct of foreign affairs, we are not dealing with defense, conduct of foreign affairs, comma, the authority and jurisdiction is vested with the union government under Article 162 of the Constitution, read with the parliamentary control in terms of, don't say read with, it's stop. Apart from Article 160, apart from Article 162, the provisions of Article 253 of the Constitution stipulate that Parliament has the power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement, or convention with any other country or countries, or any decision made at any international conference, association, or other body. Full stop. Now, it is well settled that international law is, that there's a presumption that international law is a part and parcel of national legislation, of the law of the nation. And hence,
Unless it
as a
is
matter, unless it is specifically, unless the application of an international principle of law is expressly or by necessary exclusion, necessary implication, excluded by the competent legislature. Stop. However, the basic issue which falls for consideration in the present proceedings is as to whether the court, by judicial fiat under Article 32, can issue a writ to the Union of India to cancel existing licenses and halt the issuance of new licenses for the exports of arms and military equipment to Israel. Full stop. We are affirmatively of the view that the answer to this question must be in the negative for more than one reason. Full stop. First, the grant of relief in the present proceedings is presaged on the submission of the petitioners in regard to the conduct of an independent sovereign nation, namely Israel, in the conduct of its operations in the theater in Gaza. Full stop. The sovereign nation of Israel is not and cannot be made amenable to the jurisdiction of this court.
We are not even asking.
Full stop. Hence, for this court to consider the grant of the reliefs as sought, it would inevitably become necessary to enter a finding of fact in regard to the fundamental allegations which have been leveled by the petitioners against the state of Israel. Full stop. Absent jurisdiction over a sovereign state, it would be impermissible for this court to entertain the grant of reliefs of this nature. Full stop. The next, the second aspect of the matter, which equally requires to be noticed, is that the petition seeks a bar, a prohibition against a cancellation of existing licenses and the issuance of new licenses for the export of arms and military equipment by Indian companies. We'll stop assuming that some of these licenses are now governed by contracts with international agencies, with international entities, including within the state of Israel, the grant of injunctive relief by this court would necessarily implicate a judicial direction for breach of international contracts and agreements. Full stop. The fallout of such breaches cannot be appropriately assessed by this court and would lay open Indian companies which have firm commitments into into proceedings which may affect their own financial viability. Full stop. The provisions of the statutory provisions in our law confer sufficient power on the union government to act in such cases. Full stop. For instance, prohibitions can be imposed by the union government under the Foreign Trade into brackets Regulation and Development Act, as well as under the provisions of the Customs Act 1962. Full stop. Whether in a given case, comma, any such action is warranted is a matter which has to be decided by the union government, bearing in mind the overall economic, geopolitical, and other interests.
Diplomatic considerations.
In fact, Your Lordship should say, bearing in mind the international law on the subject and the conventions which India has ratified.
In taking an appropriate decision, the government bears into account all relevant considerations, including the commitments at the international level. Full stop. The danger in the court taking over this function is precisely that it would be led into issuing injunctive reliefs without a full and comprehensive analysis or backdrop of the likely consequences of any such action. Stop. The restraint which courts, the self-imposed restraints on courts in entering into areas of foreign policy is thus grounded in sound rationale which has been applied across time. Full stop. For the above reasons, we have come to the conclusion that the reliefs which have been sought in these proceedings are not amenable to the exercise of judicial remedies under Article 32 of the Constitution. Full stop. We clarify that the observations which have been made in the earlier part of this order are not intended to reflect any opinion by this court, either in the conduct of foreign policy by the Indian government, or for that matter, by any sovereign foreign nation, which is not amenable, which is not subject to the jurisdiction of this court. Full stop. The petition shall accordingly stand for the above reasons.
No, there is one application that will be disposed of. One application pointer that will be disposed of.
Grateful to you.
Yes.
Thank you. Thank you.
Your Lordship, there is a already settled. Yes, Your Lordship, there is a already settled position of law. No law will be law until it's gazetted notification.
But who's your client? What is your locus?
We are concerned only with the rule of law and process of the law.
Let somebody, you are saying that those rules of 93 were notified by the government of Bihar in 2023. You may be right.
Yes.
But who's your client? He's some lawyer who's filing a PIL.
Your Lordship, we are only concerned because
somebody has a problem with the sanction in a given case, they have their remedies in a criminal court.
Even Your Lordship, the Honorable High Court already
lawyers enter into this.
High Court already recognized there is a defective notification, Lordship. If Lordship not will consider that notification will be continued, Your Lordship, and until somebody not come.
But how is the lawyer concerned with all this in a PIL?
Lordship, we are concerned with the rule of law, Your Lordship, and we are.
There's always the behest of somebody. That's why the High Court has rightly rejected it.
Your Lordship, there is substance is saying the law will be applied retrospectively.
There's nothing on this. Item 14, thank you, dismiss. Item 14 is to be tagged with Gamescraft, no?
Yes, my lord. I'm appearing in item 14.
And 38 also, I think.
Yes, my lord, and the matter is coming up tomorrow.
We'll just notice and tag.
My lord.
Item 15.
My lord, may I just make one more request, my lord? There were two other matters which are to be listed today, which are to be tagged tomorrow, my lord.
All right, tomorrow, when it's called out, you mention it.
My lord.
Item 15. 15, such a big crowd.
That's for the next one.
Oh, I see.
That's
You're all sort of, all anticipatory mobilization. Yes.
I'm appearing in item 15, Your Lordships.
Ma'am, now this NEET is over.
Your Lordships.
Now admissions are being made. Now you said you should have been given more time because, you had, there was a paper mixed up.
Lordships, there are three reports, Your Lordships, I want to highlight. There are three documents, Your Lordships. There is one report by the city coordinator dated 6th of May.
Now it's too late in the day to
Your Lordships, the counseling is still going on, Your Lordships.
Not it. Can't interfere now.
We are just 7 students, Your Lordships. The counseling is still
The
going.
court has applied its mind now. We have to close it.
Your Lordships, just one point.
Yes,
Lordships,
ma'am.
just one.
Sorry, ma'am.
There is a report of the deputy commissioner which is recommended for the retest, Your Lordships.
No.
That has not been considered.
Now, at this point now, no more eating.
No, Your Lordship, this was on 18th.
Children are tired now.
Your Lordship, this was on 8th of May, Your Lordships, and that has not been considered by the NTA, Your Lordships.
Thank you, ma'am. We'll close it. Yes, discuss.
Obliged.
Plus 37.
I'm in 16. But anyway,
Yes, I appear in 16.
all the connected matters to 16. So these are people who were appointed
We are on the
4 years ago, etc.
5 years.
Subject to.
God for the selected candidates.
We are for candidates
No.
who would come in.
We are selected, we are working for last 5 years. By
Correct.
virtue of the DB's order reversing the single bench, the effect will be, Lord, we will be pushed out. This is not a scam case, no.
No, that we know. This is the ATRE. This is the Assistant Teacher Recruitment Exam.
My lord, the short question really will be whether, when you enter in the reserve category, whether you can migrate subsequently. Now, we are all
the question is if
merit
Information
came
Section
in the
36.
general category. The people who came in on the reserved category with concession marks in
Who are
both
your
exams.
clients really? Because we have seen the judgment.
General.
But frankly, I read and reread it actually today, but who are your clients?
We are general. We are general.
On merit.
You're all together in one group.
We are in
All
one.
right, then we'll hear just for any one person, Mr. Who would like to just tell us in 2 minutes.
2 minutes without reference to
Minutes.
papers.
Can I just make one submission?
This is assistant teacher recruitment in UP, Milord.
UP Basic Education.
So the two qualifying, Milord, benches, one is TET, Milord, and one is BD or BEd, etc. So there's no issue on that. So,
That doesn't matter. ATRE.
ATRE.
no, Milord, for these, Milord, for these minimum qualifications, even for TET, Milord, the benchmark for reserved is lower and the benchmark for unreserved is higher. But I am not, Milord, making any grievance out of that. After this qualifying, we go for selection. When we go for selection, it's an exam called, Milord, Assistant Teacher Recruitment Exam, ATRE. When you, even in ATRE, Milord, the qualifying mark for, Milord, unreserved is 65, while it is 60 for them. So, Milord, when this happened, Milord, we were eligible. If you get 66, we are eligible. If they get, Milord, 61, they will be eligible. But then this 65 and 61 also, Milord, will be counted at some stage. So when we got our positions, Milord, in the so-called roster, we got our positions, Milord, in the unreserved category. General category.
You're all general category.
We are all general.
We are all qualified. We have all obtained more than the cutoff. It's not that we are waiting list, etc. We are not one of those Calcutta matters, etc. So we were appointed, Milord, we are serving. So some people said that, Milord, if you are reserved, can you occupy only a reserved seat? Or can you also occupy, Milord, an unreserved seat?
If a reserve category candidate gets into the order of merit, then you occupy.
No, this is only because of concession marks.
They got in only because of the concession marks, not.
That may be, that might be, my lord.
But it's weightage.
I'm going to show you.
For the quality marks.
Those of the reserve category got above 65
Explain it, maybe.
have been appointed.
Yes.
In the reserve category.
In general.
No, not in the reserve.
65, but who are just eligible because of 60% lower cutoff.
Yes.
So they come in because of the reserved category. So that's the
So in
question.
other words,
Whether having come through the reserved category or the lower relaxed mark concession.
60, that is 60.
60.
So if you have 61,
Can you again get?
can you again get, my lord, the benefit of saying, I will go and take, my lord, the unreserved seat and push out those who have got 66.
So they are not above 65.
They're not. No.
Above 65 have been appointed.
Correct. So it is, my lord, the game between.
They only came in on weightage.
So the other way to look at it is this way. So this is, my lord.
Lord, may I?
Make sure one to those rules. Rule 14 I saw in the judgment.
Yes, correct.
in the morning.
Schedule 1.
Then you have appendix 1. Now, at what stage do the quality points?
Yes, at schedule 1 stage.
One stage.
At schedule 1 stage.
How does it work? Because frankly,
That's the
I was
third
little
stage.
unclear on
Lord, may
where
I?
the quality
May I?
points.
May I, after the reservation is done. And then, my lord, the advertisement is.
That's the error.
Look at the marks, then calculate.
Yes. And subsequently, they're allowed to migrate. This is what we're objecting.
May I may I just
Broadly out.
We are not,
may I just tell your lordship what the controversy is?
fact, Lord.
There is
just one
there is an-
70% are
there is an ATRE examination. A general category candidate qualifies ATRE at 65. A reserve candidate qualifies ATRE at 60. Once you qualify, you are in two lists, the general list and the reserve list. What the state government did, any reserve candidate who had 65 and above was only considered in the general category. A reserve candidate who had less than 65 was not considered in the reserve category and kept reserve.
not considered in the general category.
General category kept reserve. Controversy arose whether this ATRE is only a qualifying examination or is it part of a process of selection? Because if it is merely a qualifying examination, then you can't decide reservation on the basis of qualifying examination. That is a concession which is permissible. Like we had in TET, the case is completely covered by Vijay Sankla. So then after you pass the ATRE stage, then you come to the stage of selection process.
First, everybody appears for the
ATRE, and it is a sort of a.
If you are a reserve candidate.
Yes, you are shortlisted for the next stage.
Right.
Now the
next stage.
Next stage is Rule 14, Sub Rule 3 and 2, read with Appendix 1. There are various qualifying marks which are added. How much you have got in your first academic standard, second academic standard. ATRE also 20% of your total ATRE score is added in your total, 60% is added in your total score to make the merit list.
No concession there.
ATRE carries 60% weight.
Yes, no, just kindly now have the schedule.
1 second.
1 minute.
We're just trying to understand the
So
broad.
page 19 is the schedule.
If the judgment was clear, we wouldn't have had.
Just see page 19, which is the schedule, page 19.
Lord, it will have to be heard, my lord. We are being pushed out after 5 years.
Page-
Confirmed service. The lordship will hear it. That's all we are saying.
Correct.
And it's reversal, my lord. Single judge is reserved by.
Page,
reversed by
page, it's, the controversy is very narrow.
Yes.
Now the question, just kindly see page 19, how the merit is to be made. If your lordship will, it says, high school percentage of marks 10 upon 100, intermediate marks are added, graduation, BTC, ATRE, teaching experience, etc. All that is added at page 19 to make your final merit. Now the question is that it is at this stage that reservation is to be applied.
That's the question.
If my minimum marks are more than the general candidate, then I have to be considered in the general category. And that is what now the learned single judge said, the division bench says. That is precisely what the division bench says. You cannot just put me in a compartment of reserve on the basis of that qualifying examination, which is not a process of selection. This issue your lordship decided first in Jitendra Kumar, and then the identical situation happened in TET.
TET was merely a qualifying examination for the purpose of further appointment subsequent. So the issue arose before your lordship that a candidate who qualifies TET with a reduced standard in the reserve category, when he competes when the post is advertised, can he migrate from the reserve to the general category if in that process of selection, his marks are more than the general candidate? Your lordships have emphatically answered it, relying on Jitendra Kumar's judgment, saying that is only a qualifying standard. And 20% of the qualifying marks are to be added in your total score. And therefore, or 60 here or 20, whatever. So 20% or 60% of your marks are to be added to your total score. And therefore, it is the total score which is the selection process.
So you take 60% of the ATRE marks.
Correct.
Plus
Whatever it
quality,
is.
yes, whatever it is.
Plus
And
add
the
your
quality
high school,
points,
intermediate.
add the quality points.
Correct.
Then draw up a merit. Then
Correct.
And thereafter, any candidate who is in meritorious enough to get into the
Yes.
will go in as an unreserved.
Correct.
As for millets, just to add two things,
That's
under the well-settled principle that a meritorious reserve category making it on his own merit to be counted for. Now, millets, your lordship said in TET, as my learned friend just pointed out, that insofar as TET, then millets also had two facets to it. It was a qualifying examination and then also determined merit along with other factors. Your lordship said very clearly that the first part is a qualifying part. When it comes to selection, there a level play field is the expression your lordships repeatedly use, and say a level play field has been given.
So this is
fact.
where the learned single judge. All appointment letters say subject to result of the petition.
What we want to say is this. The judgment needs to be in the sense that the law needs to be correctly stated in our judgment, right?
Correct.
What we'll do is that maybe if you can, all of you can give us one small compilation of not 2 to 3 pages of your submission, because the point is very narrow.
Yes.
And likewise over here, we'll write a judgment and clarify the position in law.
Yes.
So can we keep it, maybe today is Monday. Should we keep it next Monday? Will you be able to circulate your note?
Your lordship may just your lordship may just note 2 judgments and just see those 2 judgments. Just 1 minute.
But with the number of counsel, we just say that nodal counsel on one side, if you can put together not more than 2 or 3 submissions, otherwise it will become.
May I make a submission request? This 2017 1 SCC page 350. 2017 1 SCC 350. Beyond that, we need to argue nothing. It is settled here.
No.
2017 1 SCC 350.
Because Sankala is distinguishable, there's no TET marks involved.
It is.
In respect of
That's the only difference.
reservation, my lord.
What is the one second? What did the single judge do?
Single judge said TTE is all right, but the ATRE you cannot get concession twice over.
Yes.
In the ATRE also they've been given concession. So the single judge said if they've taken the concession at the ATR stage, then they cannot claim migration afterwards and decide in our favor. Division benches reverse that.
Now, what is the nature of the concession which they took at the ATRE?
Weightage.
60 and 65.
60 and 65.
Yes,
That's
all.
they had
Not in
this
the final.
Even
The
in
final
TET, but we are not basing our case on TET, which was merely qualifying, while ATRE is a part of selection.
Selection and merit, and it's an open exam.
Not the advantage of.
I'm sorry.
Migration is.
Just one second. Let's do Mr. Dwivedi here.
No, I'm sorry.
Single judge says that TRE examination and the appendix quality point marks, they are together forming one recruitment process. They are not disintegrated. It's not like the TET eligibility. So this ATRE examination, when it grants a relaxation, then it is based on that computation is done along with certain other quality point marks that are added. So this is one process, and having come in
on the reservation
on the basis of relaxed marks, now those who are below 60% or 60% who have come in, they can't
Migrate.
over and migrate to the reserve category.
The general category.
Because at stage one, they had to put up with a less qualified.
Can't be.
Less threshold of 60 as opposed to
Now,
65.
kindly, my learned friend relies on Sankla's case that has been considered
by
by a
three judge
judge bench.
Yes, Malaj, three judges affirming this.
Case, kindly have this.
Yes, please. Yes,
Para
Malaj.
20,
Malaj, three judges,
Two copies.
three judges on this point affirm it. Three judges say this.
Just hold on.
Yes, of course, I have that right here.
You were not citing it so far. And now you want to.
Citing a judgment which is already mentioned here.
Para 20 and 21, they have said that you can't migrate
And that
if
is,
you have come in like that.
that is the case of, in any case, TET, we are not taking advantage. We are not taking advantage.
Malaj,
of
in
TET.
this case, it is only there is no marks given to it. That is the rationale. Please see that.
Weightage has been given in the ATRE.
TRE and they are integral.
Please see para 18, Malaj, para 18.
Back from para 19.4 to 21.
18 is important.
18 is important.
18
Your
answers
lordship may
it.
see the rack.
Also.
Malaj, para 18.
Your lordship may see the rack.
The point is this, we'll probably have to hear this again. The point is really this, that once you have qualified on the basis of the lower threshold of 60% for reserved categories, then you can't say that, well, I'll still gain into the unreserved category based on the quality point.
That's what the lordships have said, because it's not part of the selection.
Already got the benefit.
The distinction here is,
The question is between
this is a
horizontal and vertical
qualifying
application of
examination.
reservation.
The whole purpose of reservation is to give the reserve candidate an opportunity of making it to the final select list. So this is not a process of selection. This is in the nature of a concession. In Jitendra, the jurisprudence is discussed in Jitendra.
Stay the operation.
Monday week.
My SLP is also listed 39507. Could my lords list it along with this? SLP 39507.
On 23rd September, bearing in mind the urgency of the need for filling up posts.
No, posts are already filled up.
It's already
working.
They are protected. Bearing in mind the need for certainty in the case. The
Let be a status
be listed at this stage for hearing and final disposal. Full stop. Mr. Prashant Shukla, instructing advocate on behalf of some of the petitioners.
Yes.
Mr. Prashant Shukla, on behalf of the petitioners, and
Mandeep Kalra for the response.
Mr. Mandeep Kalra for the respondents, shall act as nodal counsel. They shall put together, preferably, one set of submissions on behalf of the petitioners and one set of submissions on behalf of the respondents, not exceeding 7 pages each. Full stop. The petition shall be listed for list on Kardo. So, yeah, file it. The petition shall
Could
be
it be
filed
immediately after the fresh matters?
filed on or before.
High Court has given a status quo that this session you will continue. That status.
Therefore,
We've already been there for the last 4 years.
March.
Yes,
We've been there for 4 years already. So
That's why that session benefit they are given.
There's also one important fact. Lord, there's also.
Actually, the judgment is very.
Yeah, the Honorable Single Judge makes it simpler to understand.
We'll now, next time what we'll do, I didn't read the single judge.
Yes.
We'll read the single judge, I think.
Because Malaj, here I agree with your lordship, Malaj. Although the conclusion is right, but it was confusing.
I am instructed that the state wants to say something which might.
Can I just make one humble submission? SLP number, the diary number 39507 also needs to be listed along with this.
You're not filing an independent SLP, right?
Not.
All right.
Well, it's item 37.4.
Ms. Aishwarya Bhati, when the AG appears for the state of Uttar Pradesh, the state would also be at liberty to file its independent submissions not exceeding 5 days.
My lords, we'll order a status quo in the meantime. We've been there for the last 4 years.
Happen between now and the 24th.
Nothing will happen.
They are secure till March. They are secure till March.
All of the list should not happen.
They are secure till
All
March.
that we are saying. It will
Let there be a status quo.
Let the status quo. 69,000
All right,
people.
fresh steps for redrawing the list in pursuance of the
Yes,
assumed
please,
directions
please.
of the division bench shall be held in abeyance.
My lords.
That was item 37.
By the single judge also. The list is squashed by both.
No, but
Single judge
both have
also.
quashed the
Therefore, Manoj, in any case, that has to be.
My lord,
Item 30.
They will not give effects, Manoj. Let the process continue.
Till the 23rd.
That it won't be wasted, that time in drawing up as per appendix 1. It means that list will be drawn up in the meantime. No one.
my lord, J. Sai Deepak sir wants to appear online.
Lord, there is one important fact,
J.
Lord.
Sai Deepak sir.
Even now, with all the faults pointed out by other side, 70% belong to reserve category.
I'll tell you, Lord.
Of the total recruitment, Lord,
I have to figure,
69,000.
I'll give it right now.
70% belong to
will
reserve
happen.
category.
My lord, I'll tell you, Lordship, what will
Lord,
happen.
can I make one non-adversarial submission, please? Just one
Is
non-adversarial
only
submission.
as per appendix 1 and nothing else.
That is
Now,
the whole
today,
issue.
that entire process will get derailed because the losing of the job is in March 2025. Today, what is required is do the list. What prejudice will be caused?
Your lordship may say it may not be finalized.
It will open in Pandora box, my lord.
You know, not be given effect to Manoj.
My lords, the whole issue is that appendix.
Yes, the list can be prepared and not be given effect to.
My lord, may I mention diary number 39507, identical SLP, my lord, same order may be passed.
Item 17.
Wait, please.
37 also, Lord, these are.
Yes.
Appearances may have to be taken. My colleague hasn't filed.
17 raises a question that is being considered by this court, Lord, as to what is the context and contours.
You are facing prosecution for cheating, forgery of 1,301 crores. The Punjab.
Go on. I'm not saying that that would have any, that would be any.
Why stay the 138 proceedings?
No, I'm sorry, not.
It's covered by judgments in Mohan
No,
Raj
no,
and
with respect,
Goenka.
this question is being considered. Just kindly have para 27 of P. Mohan Raj.
Let the trial go on. Why should
Bear with me for a moment.
And the moratorium against in the 96 proceeding will not affect the 138 proceeding.
No, bro, with respect, it does. Your lordships have held so in Mohan Raj. Kindly have para 27 of Mohan Raj, bro. It's completely in my favor. Please have Mohan Raj, bro.
I just pass on. It says when any application is filed under 94 or section 95, any legal action or proceeding pending in respect of any debt shall be deemed to have been stayed.
Lord, may make a respect.
Not with respect of any
Just bear with me
debt.
for a moment.
It's for a criminal offense.
Just bear with me for a moment. Lord, in para 27 of P. Mohan Raj, your lordships interpreting section 96 of IBC have held 138 is barred, is stayed. I'm covered by that. I'm covered.
What do you have to say about Goenka's case? Goenka has considered.
I'm sorry, Goenka, my lord, I'm so deeply obliged. Goenka considers section 14 of the IBC. 14 in terms of content is very different from 96 IBC. 96, when it comes to not personal insolvency, is all encompassing in respect of all debts versus 14, which is narrower in scope. 96 is wider, which is why in para 27 of P. Mohan Raj, can you pass it on, please? P. Mohan Raj, no losses have held, there are 138 proceeding, which is essentially a civil proceeding, but given the color of a criminal proceeding, not is barred. Just bear with me for a moment. I'm covered by that. So, not para 20.
Give us a copy of Mohan Raj.
You can't do this. I'm sorry, bro.
ये क्या है भाई? हाँ, ये क्या दे रहे हो? You want us to go to the library and get it or what?
Sorry, we can't do this.
हाँ, आप practice करते हैं.
My apologies, Lord. Good losses have it tomorrow, Lord.
All right.
I'm sorry. I'm sorry. I thought not we have a compilation. We are passing that on.
Yes.
I'm so sorry.
We'll take it up on Friday. Friday.
Deep reply. I'm sorry for the
no.
Deep reply.
My lords, this FIR pertains to the batch matter, which is already pending before my lords.
We'll issue notice and stay. Yeah. We'll issue notice and stay. This is FIR, that next FIR, 54 of 23.
Yes, my lord.
So that we'll issue notice and stay of further proceedings in the FIR.
It may be tagged with the FIR number 28 of 2000.
It has to be tagged with which one?
My apologies. With writ petition number 28 of 2020.
Go check that one.
Rajendra Bintal, the cast title.
Yes.
Please, your lordships.
Where is that report you're
We have e-filed the latest report. He submitted it. We also have copies.
Have copies? Just give us copies.
With
Find
email.
it.
We've emailed. There were three issues raised on the last occasion, my lords. Apart from the e-filing status, your lordships had also inquired about the number of cases where the delay was of more than 200 days.
19, no?
And the cases where the monetary value cases. Check those 3 copies.
Yeah, Ms. Bakshi, can we just read it over the week and then Friday we can keep this? Yeah, हम तीनों को circulate कर दो. And which are the high courts where you're confronting a problem? If you can just tell us.
Para 5.1.3.
I think Nagpur bench you said you have, then
Yes.
Chhattisgarh.
There was a problem which is now solved, but Chhattisgarh, there is facilities not available. My lord, I'm reading from 5.1.3.
Yes.
And then the field authorities in Andhra Pradesh, Telangana, and Chandigarh, there is a problem when the documents are voluminous. Then Nagpur bench, Jharkhand and Jammu and Kashmir High Court. This is where we are facing problems.
What about the Supreme Court? Are you now e-filing all your appeals in the Supreme Court?
My lords, therefore, we have a large number being filed over here.
Large number means how many?
What is the Supreme Court?
Ms. Bakshi, we'll keep it on Friday. Just have a look
Yeah.
at what happens to the Supreme Court. We'll also study this and pass a small order on Friday.
Yes.
Item 20. It's for this right now. We are also held back today a little bit, so we'll take this up on Friday.
21.
20 को delete हो गया था.
Let's look at the last order passed.
Now, what remains here?
It worked itself out. There's only one small issue I must bring it to the notice of your lordship. The High Court passed an order, the division bench, noticing the single judge's order that in due course, the Andaman administration frame a scheme.
Yes.
But then we are bound by the government of India. DOPT says we can't frame a scheme and so many objections have been raised. The matter stands there. And the division bench will disposing the matter said, if they have a grievance, they can certainly come back to the High Court.
Now,
Therefore, your
on
lordship
14th August 23, we had recorded the contents of your additional affidavit, right? Our order of 14th of August 23.
But that came in the context of a contempt appeal.
Right.
Therefore, the contempt appeal, whereas.
So what we did, we closed all the contempt proceedings and substituted it with our own order.
Yeah,
Where is that order?
Initially, I think the authority filed an application
Page
for
11.
extension of time.
Page 11 of your MA.
If you lordship to look at paragraph 11 of that order of August 14, 2023.
Right.
So
the
we have
administration
now,
has, during the pendency of these proceedings, taken steps to withdraw the offending clauses. Order 2276, enhanced wages shall be implemented with effect from 1 September 2017.
that's been complied with.
Arrears payable from 9 September 2017 to 8 May 2023.
All that is fully done. The next part of it. Moreover, it's been stated the regularization would be framed in terms of statement made before the division bench of the High Court. This has been clarified in the additional affidavit. We said so in the additional affidavit, you are subject to DOPT's giving a clearance for this scheme.
Now, where is it lying with the, where is it pending with the DOPT? Mr. Attorney General, get it cleared. What is the difficulty now? Small thing remains. You use your good offices.
There is some issue. I went back to DOPT and there is some issue. If they have to do it, then it cuts across a large number of.
To comply with now the statement.
What happened is after the order, we filed an application for extension of time much before, but then now that's been complied with, the application doesn't have any relevance today. But the question whether in a contempt proceeding.
But why have you come here actually with an MA? What is your prayer in the MA?
The prayer in the appeal was the extension of time at that point of time. We needed some more time to comply with that. The question of payment, etc. That now that we have done that, that's become academic now. So the application is infructuous now.
No, are you taking time for regularization of the scheme?
No, your lordship did not say, except there's no direction with this, because there's a contempt proceeding and a contempt appeal.
So then you're not pressing this today.
My lord, may I submit, my lord?
For extension, I don't need to press it because we have complied with the question of payment.
Payment. Then we close it. Then we close your MA.
No, that's what I'm trying to point. As far as the other matter is concerned, that may not be subject matter in a contempt appeal.
My lord, there are two parts, my lord, of my lord's order of 14th August. My lord, may kindly see paragraph number 10, my lord. With regard to regularization, my lord. The administration has made effort before the ministry. My lord, may kindly read para 10 onwards, my lord. Administration is not at fault, but the ministry, my lord, because they have placed the proposal. And the proposal is very clear, my lord. Administration has placed very clear proposal. Ministry by a letter dated 13 December 2023 saying that it cannot be done. That is one of the, in one of the MA they have enclosed, my lord. That MA is fixed today, my lord.
I court's order in the SLP, in the appeal, contempt appeal, I court's order.
So it is only with.
From this order also. In the context of a division bench passing an extraordinary order.
Right.
That's
that
right.
we have set aside.
Correct.
Now the only point which remains is the regularization. Because we have said, moreover, it has been stated that the regularization scheme would be framed in terms of the statement which was made before the division bench of the High Court.
That's true.
Have you framed the scheme like that?
That's why we have to go back to DOPT. We can't do it ourselves.
So now tell
we are governed by DOPT.
Tell DOPT to sanction it now. What is the difficulty?
No, DOPT has explained why such a scheme cannot be framed. Therefore, in a contempt appeal, whether this matter would be gone into is what I'm trying to point.
No, but we have, Mr. Attorney, we have
I
said.
understand there is an issue, but whether this court will go in this contempt appeal. But at that point, we're not in contempt.
DOPT is bound by our order.
No,
DOPT is now bound by our order also.
No, there was no issue before your lordship as to who will frame the scheme. We filed an affidavit saying that we are bound by DOPT. We have gone to the DOPT and the DOPT is looking into it. And therefore, the question before the High Court was only about compliance regarding payment of this compensation, etc.
No, my lord.
The division bench said, I'll point out the earlier order passed by the division bench. I'm sorry, Lord.
If we grant you time for this purpose,
yes,
and DOPT has already taken a decision, and now you are in a fix.
That's
how time is going to solve your problem.
No, I won't be the Andaman.
Come out with some solution how to deal with the report or the view of the DOPT.
The Andaman administration cannot solve the problem today unless
if you don't press this, tomorrow the other side will come with contempt.
No,
This
there
part
won't be a contempt of your lordship, because see, I've traveled here in a contempt
Then
appeal.
why are you pressing the MA? We'll record your.
No, I'm not pressing that application.
No,
I'm
no, my lord, they have filed a new MA, my lord. They have filed a fresh MA whereby they, at page number 6, they have given the letter of the DOPT, 13th December 2023. My lord, may kindly
this court.
Where is that MA?
My lord, kindly see that MA, my lord.
That's true. We filed
In
an
that,
additional
my lord, there
affidavit.
is a letter because administration has made all attempt to comply the order. But the ministry in letter dated 13 December 2023 not at all consider the recommendation of the administration. And they say that in terms of the 7th October 2020 notification, we cannot comply. Whereas 7th October 2020 is for implementation of the judgment of Uma Devi. So, my lord, that has got nothing to do with this. Now, my lord, may kindly see.
We don't have that MA, Mr.
I'm so sorry. It was only asking for extension of time.
No, my lord, 2 MAs are there, my lord. Extension of
one MA and an additional affidavit. Only one MA.
No, my lord, 1 MA is there, 2531. 25313.
Where is that MA, by the way?
2531 of 2023.
Application for extension of time.
Page number 6.
Yes, 2531 we got. Page 6.
My lord, in page number 6, my lord, that is the letter of the ministry, my lord. That because of that, administration is unable to culminate this scheme, my lord. Scheme already administration has proposed.
So you wanted 3 months time for extension.
No, that is for complaints with the payment.
Now the present application for extension of time for further 3 months to comply with the orders dated 14 August 2023 of this court for taking action in compliance with inter alia directed in para 12 of the order of 14th of August.
We came in November 2023. By that time, the question of computation and payment had not happened.
Now you have paid.
That's right. Therefore, the
Payment has
application
been made,
become
Mr.
interest.
Binoy Kumar, Mr.
My lord.
Gopala Kumar.
My lord.
Payment has been made to your client.
Payment has been made, my lord. Payment has been made.
That part is over.
That part is over, my lord.
Fair enough. Now, what about the regularization, Mr. Attorney General?
My lord, they have filed a petition.
Now you have to sort it out with the DOP.
In page number 6, they have annexed a document of the ministry.
It's not a question of a few employees. And then it goes in fact, today there are a larger number of matters coming from various states vis-a-vis Uma Devi's implications. Uttarakhand, UP, I've been
Then we will simply close the MA, let them pursue proceedings in accordance with law.
That's right.
No, my lord. My lord has recorded on 14th of August.
It will be heard on its own merits. Matters will be placed, facts will be considered.
No, my lord may kindly consider my lord's order at paragraph number 10 onwards, wherein the administration.
MA, Attorney General says that we have made the payment which is undisputed and he is not pressing the MA any further.
No, my lord, there is a second MA, my lord. In that MA, they have said we cannot comply.
There's one MA.
My lord, I have
an additional affidavit which probably thinks affidavit.
That will be additional affidavit.
No, my lord, they have filed it. They have filed it on 5th of January 2024. A copy was served upon us, whereby they said ministry-wide letter dated 13 December 2020.
Mr. Attorney General, 5th of January, what have you filed?
Yes. Saying that ministry has rejected.
Give it to us.
What is it? It online. Date.
Page number 6, my lord.
letter of 13th of December 2023 of the Government of India and the Ministry of Home Affairs.
That's 13th of December 22.
Why don't you do this? We will close it insofar as the Attorney General is concerned. If you feel that you have any further cause of action, you pursue your remedies in accordance with law.
My lord, since my lord, only one thing, my lord.
Ministry a party to the Government of India, Union of India party?
No, my lord.
So they are
No,
not parties.
No, my lord. It was
They were not
not a party. Not a party. My
In
lord,
fact,
only
even
one.
it was even hinted to the division bench, they're saying it has to go to UOPT, but then of course never become part of the record.
My lord, only one thing, my lord.
UOPT was never a
Administration has
party to these
recommended.
proceedings.
Administration has recommended. Now, ministry, my lord, if my lord sees the letter of ministry, it is contrary to my lord's order and the administration recommendation.
Independent cause of action because Government of India was not a party to the proceedings.
But my lord's order is there. My lord, administration is the employer. They are ready. They have sent the scheme to the ministry.
Independent concerns. DOPT has independent concerns.
My lord, kindly see. Then, my lord, after the orders of the court, if we did not, then where we can agitate our grievances, because already the court has passed an order in our favor.
For the High
Take
Court.
the old order. So show me the old order. Division bench, first order.
And my lord, the ministry's reasoning is totally contrary to the order of the court. The court said in terms of 7 June 1988 office memorandum. Ministry said in terms of the Uma Devi's case, we cannot frame a scheme. That was not, never administration said them to frame a scheme under, in terms of the order of the Uma Devi judgment, my lord. My lord, if my lord once read the order.
Just say that the payment, which was envisaged in paragraph 11 of the order of this court dated 14 August 2023 has admittedly been made. Stop. This is not in dispute. This is not disputed by Mr. Gopal Binoy Kumar, then counsel appearing on behalf of the workmen. Stop. The Attorney General for India, Mr. R. Venkatramani, also states that payment has been made.
Yes.
Full stop. As regards the issue of regularization, it is common ground that the Union of India, that DOPT, that the Department of Personnel and Training of the Union of India was not a party to the earlier proceedings. That's correct, right? Stop. In this backdrop, all that needs to be observed at this stage is that if the petitioners have any subsisting grievance in regard to, if there's any subsisting grievance in regard to the scheme for regularization, it would be open to the workmen to pursue their claims in accordance with law. Full stop. The MA filed by the Union of India, accordingly, is disposed of as not placed at this stage.
2023 of the ministry, my lord.
Item 22.
Item 22, please enable the camera, sir. Kushal, sir.
Yes. Directed the NCLT to complete the proceedings by 31st of August. But then NCLT, the pleadings are almost complete there. They have fixed the matter on 20th of September now. So that's, I think that date will be concluded. So one more date I would request.
We can keep it maybe a week later. Because the proceedings before the NCLT are listed on 20th September
2024.
2024.
The instance of the applicant, so no more adjournment should be made.
No, my lord, in fact, this suggestion was made
We take it after a week thereafter.
My lord, may kindly give little more time because then in
2 weeks thereafter.
Okay, 2 weeks, my lord. Deeply obliged. Deeply obliged.
Ms. Bhatti, any?
Malas, we should the Geo kindly call it after 2 weeks. The payment would also be made. I have a copy to my colleague.
23rd.
On the joint request of the Learned Council, list on 23 September 2024, by which date the dispute is expected to be resolved.
Yes, ma'am. We've already issued Geo. We'll make the payments. Great.
Geo has been issued, no?
Yes, Malas.
Then why do we have to keep it pending?
Just may take it on record and
Lordship may have it on 23rd, my lord, because Lordship may have it on 23rd.
Who has issued the Geo?
The government, Malas, the state of Puducherry.
Lordship may have it on 23rd, my lord, because only then we'll get the payment. Lordship may have it on 23rd.
All right.
May I please, my lords?
The court wanted me to circulate a note And then we circulated a note, there is a response, there is a reply. It's as if the pleadings have been completed in his matter.
Yes. How long would you take?
My lords, I'll just take 5 to 7 minutes. I just have to show couple.
Today we were held back by the Calcutta matter for the whole of the first session.
I know that.
Yes,
We've got about 20 matters to finish our board today. So we'll take it up next week, because otherwise this will take us up right through to the end of the day. We'll at least be able to finish 15 matters in the next 20 minutes, you know.
Now that she is retired, the question may require consideration if at all, or want to still
Because my lords,
extend a helping hand if that's possible. She is retired now.
that she was the senior most serving army officer.
He'll deal with the grievance.
31st of
He'll deal
August.
with the grievance, but not today.
But my lords, we give a fixed date, otherwise the
We'll
matter.
do that, yes.
Obliged. My lords, we'll have it next week.
17.
17. Obliged.
We lost, may not have it on 17th and 16th, 17th.
All right, Friday after that?
11th.
What day?
No, this is actually a fresh matter. But it's an order of the NCLAT dated 9th of July 2024. The order was not uploaded, my lord, so when it came up before your lordships on the first time on the 12th of August, there was, my lord, 2 files, so your lordship, my lord, kept it on another date. It's come up, my lord, subsequently, but it's coming up fresh. The short point is this, my lord. An application is moved by the liquidator to include in the assets of the corporate debtor property that admittedly belongs to the promoter. Admittedly. That application is first allowed ex parte. It is set aside, my lord, subsequently. When it comes up the next time, my lord, I am now arrayed as a respondent. I being the promoter, I'm now arrayed as a respondent. Separately, I have also filed an application to implead myself in the proceedings. The application of the liquidator, my lord, where I'm impleaded as a respondent, is allowed again by the NCLT. I challenge that order before the Honorable NCLAT. NCLAT says you are not a person aggrieved, because although you are a respondent in the liquidator's application, you have not filed an independent appeal against the order dismissing your impleadment, disposing of your impleadment. NCLT disposed of my impleadment, saying that the application of the liquidator is allowed. That is not wrong on merits, I'll come to that. But not at this stage, I'm first ousted by the NCLAT, saying that while you have appealed the liquidator's application order, you have not appealed the order disposing of your intervention or impleadment.
Right.
That has to be wrong, Lord. I'll show your lordship paragraph 8 to 10. Now, that's the main appeal. Now, subsequently, my lord, the order of the NCLAT, as I said, is 9th of July. We have been before your lordship on 3 dates from the 12th of August onwards. My lord, it wasn't able to reach on the subsequent 2 days. Acting, my lord, in the meantime, and despite our letters, the liquidator has now put these properties to sale. So, my lord, today I'm requesting notice in the matter and a status quo. These are admittedly, my lord, assets of the promoter, not assets of the corporate debtor, not amenable to be included in the liquidation estate under section 36. And to date, my lord, by the NCLAT, there will be no hearing on merits.
You are for the Union Bank.
I am for the Union Bank, Your Lordship. Just two.
Are these properties of the corporate debtor or of the promoter?
It belongs to the promoter, mortgaged to us. So the properties are mortgaged to Union Bank of India, and we agreed to relinquish that or add it as part of the liquidation estate so that the hospital can be sold as a going concern to maximize the value. So it is wrong to say that the right of the promoters exists on the land. It's in fact mortgaged to us. We are lender to the corporate debtor, and we are also
corporate debtor is a hospital.
Hospital, and land belongs to the promoter, mortgaged to us.
So you would be able to realize your mortgage security ordinarily.
Yes, otherwise you can proceed in the surface.
So what you did was you gave up your security.
Yes, sir.
And on the condition, once you gave up your security, that was on the assumption that the entire hospital would be sold as a going
concern
together with the land.
To maximize the value, and therefore 36 crore rupees, it was auctioned and sold, not before the matter was listed. It was in fact auctioned in way back on July, 12th of July, after NCLAT order.
I am the caveator.
Under surfacing, no proceedings can be taken out.
May I say one thing, madam? I am the caveator, madam. May I say one thing, madam? Liquidator, madam. Just to address your lordship, madam. I am appearing for the liquidator, madam.
Yes, Mr. Satyanarayan.
I'm grateful, madam. Madam, also, madam, they have given the property to the corporate debtor 99 years registered lease agreement, madam. They have given the property, madam. One more thing is that, madam, already, madam, this honorable court, madam,
Registered lease.
yes, registered lease 99 years lease, madam, and this is the only hospital, big hospital in that area, madam. That Eratupeta municipality, madam, this is the only big hospital, madam. What happened, madam? They have not already, madam, third time before this honorable court, madam. Already, madam, if your lordship sees page 19 para R, they have already, madam, brought this issue to this honorable court, madam, in SLP number 12357 of 2022, madam. This court, madam, rejected their appeal, madam. They are the bona fide litigant, madam, where, madam, they will not, they have, madam, one side, madam, they
What my learned friend.
Your lease in favor of the corporate
Yes,
debtor.
but Lord, it has to be separately, Lord, sold under the SARFAESI proceedings.
Also, madam, one more thing is that, madam,
Gave up their first charge so that this could be entirety could
Sold
be
as a going concern to maximize the value.
maximize the value.
But still,
And also, your lordship, what my learned friend was strengthening liquidator.
Not a case.
This is
the bank has taken, madam,
third round of litigation, Supreme Court, your lordship.
also, madam, bank, madam, has utilized the section 13 subsection 11 of SARFAESI. They have assigned the land into the liquidation estate, madam. Your lordship knows very well that, madam, section 13 subsection 11 of SARFAESI, the bank can assign or, madam, transfer or sell their, madam, property which was mortgaged to them. Here, madam, they have given a property to the mortgage of 99 years to the corporate debtor. Other side, madam, they have given the corporate guarantee, and they have given the deposited the title deed with the bank. The bank, madam, because, madam, the land and building cannot be separated, has decided to, madam, relinquish the property into the liquidation estate using the section 13 subsection 11. They have assigned it to the liquidation estate. Then the liquidator, madam, sold the land for 36 crores, madam, and one more land and building is there, madam, which we will, madam, realize 10 crores rupees, madam. Here, madam, the promoter is before this honorable court, madam, without having any locus, madam.
Both are relinquished.
Today, Milord,
There are
I'm
two
against
banks.
an order where the NCLAT hasn't considered any of this.
No, but
The
what's
only
the
reasoning.
There's nothing on merits.
And they are third time, madam.
The only reasoning of the adjudicating authority.
Ultimately, this was a lease of 99 years.
Yes.
So, Union Bank of India was entitled to relinquish its security under 3611.
But that's not the reasoning of the adjudicating authority, with respect.
Look at it from this point of view. The purpose of doing this was to ensure that the entirety is sold as one going concern.
Well, today,
Otherwise, they would be selling off the hospital superstructure and the land separately. Who would
today, your lordship will see what's happened, Milord. Under the liquidation sale, out of 36 crores, 6 crores are attributed as a liquidator cost. If, Milord, there is a SARFAESI proceeding, there will be entirely independent rights of the promoter. And
If that is the case, let them deposit 50 crores, madam. Let them.
The NCLAT has not even addressed these facts. The NCLAT is only ousted.
But ultimately, this is the end of justice line.
Milord, here we're losing all, Milord, shape of the corporate identity, Milord. It's not the corporate
I
data
think
side.
we leave it.
Very well.
Thank you.
I'm obliged.
The Lordship was seeing two documents when the Lordship rose last time. The Lordship was seeing two documents when the Lordship rose last time. It has to be.
Translated plain last time we gave.
What, Paulus?
The translated plain.
Yes, we have.
Was this in respect of land used for trade and commerce, or was it really basically?
Well, the whole thing was converted, intended for that. Let me show the document. He has a copy of that. We can hand over the.
Intended to be used. Their order 711, they admit that it was intended to be used.
So it was not actually in use.
Lordship, the translated prayer, your lordship has. The translated prayer, your lordship.
Just for the benefit of my Lord, the Chief Justice.
I want to show Mullis 3 parts of the plaint and 3 parts of the agreement. That's it. So just let me show the plaint first, Mullis. May I?
Yes. Last time I gave you the copy. Huh?
Yes, my lords, give it. Why didn't you bring copy also? Arguing will do this.
Suit for a declaration.
I'm so sorry.
And then for an injunction.
Lordship.
Actually, mandatory injunction.
Can
to
I
hand over
show
vacant and
three parts of the plaint, well, very quickly, three parts.
Yes.
Straight away. Now let us kindly come to 122. 119 it starts. What is there is there, nothing else can be added. This is the entirety and then the agreement. 119 it starts, come to 122. A piece of uncultivated land known as Tulsi Industrial Stage in an area including the development thereof the charter which is follows at 122 mills. Now come to 123. My lord has got 122? Yes, 123 mills. Entitled Agreement for Development of Land on the top of 123. Then your lordship will come to 124. January 22 to 22 from the plaintiffs to the defendants and the development works etc. also shown on the spot. All the details are requested by him and all the documents made available. Now come to Mills 127. The purpose of the enterprise is well as development and the cost is given at 127. Now 129 is most important. The cost is at 127. 129 para 4. The party of the first part and the party of the second part have handed over a vacant peaceful possession. It is for the party of the third part on execution of agreement to sell. Hence this agreement for sale is with possession and the party of the third part is entitled to occupy and possess the above property for their bona fide industrial purposes.
This land was not today used, on that date used for them.
Yes, it was not on that date used, but the whole purpose of the enterprise is commercial. Now come to 131.
It's a simplicity agreement for land. It's
now
not really a
kindly see
commercial agreement in that sense.
Kindly see 130.
Not an industry. It was not a land for industrial use which was being transferred for industrial.
Well, it doesn't have to be. The purpose of the enterprise for which I entered into the contract was to develop for industrial purposes. The master plan was changed. Master plan was changed already. Just see page, let me just finish 131, then I want to show page 52. Just come to 131 first. Then I want to show page 52 is very, very important of the agreement.
What is the relevant part of the Commercial Courts Act? What does it say? What is the terminology?
Yes, Malas. May I just show the agreement after one page, Malas? 131. I want to show, Malas, the agreement after 131, Malas. Since the Lordship is on it. Please turn to 131. In the middle is, Malas, the same enterprise of Tulsi Industrial Estate. In the middle, para 11. Now come to, Malas, the agreement inter alia at page 52. We have applied for town planning permission. And well, they have applied for town planning. Just come to Wallace page.
1C is agreements relating to immovable property used exclusively in trade or commerce.
Lordship, please.
Yeah.
And your
Now
lordship
just tell to
used means
you were going to the intended use was for industrial purposes.
Now come to 52, just 52. Just come to 52. They had applied. They have obtained also subsequently. Whereas the party of the first part, this is very important, 52 mills, have applied.
There was nothing in the agreement or even in the plain to indicate that this was land which was immovable property used exclusively in trade or commerce.
Just see what exclusivity, page 52. Answer to my Lord the Chief Justice's query. 52. 52, if my Lord will see, last part. Whereas the party of the first part have applied to Town Planning Authority for necessary approval of construction plan and the said application is granted by the authority on 2020. Whereas the idea and the object is only one enterprise. What else?
It was not immovable property in use for commercial enterprise.
Let me put it like this. It does not have to be a full-fledged bustling.
Is exactly to that effect.
But it doesn't have to be a prior existing bustling commercial complex. It can be, the object of the agreement is what are your Lordship dealing with? Your Lordship is sending me or not sending me to commercial court on the basis of the enterprise. The enterprise is commercial. It is to convert. Now, it may not be at that time. It takes time.
The agreement between the parties. Simplicity and agreement.
May I say one more thing? May I say one more thing? This is a project of national importance for which I got it. He's not consequential. This is important for Lordships. Page 40 tells you that this is part of the Mumbai-Baroda Expressway. And this is vital for that. The contract was for 11 crores, 13 crores. 14 crores. I've paid him 3.5. I'll pay him the balance. If you want some interest for this project, just see page 40. You are actually affecting.
7-11, my lords, that is something.
Sit down and settle it
That
outside.
of course, that's independent. This is 7-11, my lords.
No, Malad,
And
in a-
7-11 have solid votes.
In a mediation, Malad,
7-11, there is no.
right, but in a mediation, if it goes, this project will be a small patch.
Negotiate with him. He pays, he will ask for his price. That's all. Thank you, Dr. Singh.
Grateful.
Malad, will you add one sentence that liberty to mediate if possible, we agree.
Malad, very independent. Any
27.
Grateful, my lords.
Obliged. अरे यार, फिर कभी सुधरोगे।
Hello, this is an arbitration petition, madam.
How much is the claim?
$54,000.
Euros. That will work out to approximately
41 lakhs, around 41 lakhs, madam.
That's all.
My lord, I have a suggestion, my lord. Maybe actually mediated, I think an attempt could be made at mediation under the Supreme Court Mediation Center. Subject, of course.
Are they appearing?
Service is complete, my lord.
On the Sai Entertainment?
Yes, yes.
We can say mediation, and then if that doesn't succeed in arbitration.
Yes.
Whom should we appoint? Such a small claim. Appoint. How much is the claim?
41 lakhs, your lordship.
41 lakhs.
Yeah.
We'll refer it to the Delhi International Arbitration Center.
Okay.
Arbitration and the auspices of the Delhi Arbitration, International Arbitration.
Or any lawyer, your lordship, if you'd like.
All should be any lawyer. A very large claim. Referring a matter to you for arbitration. All right, Balaji Srinivas.
Thank you, lordship. Deeply obliged. Thank you.
My lord, this is that matter where in a previous arrangement between the same parties, I was specifically made a party, and
here you are not.
Here I was specifically excluded because it's subsequent in time. Yes. Therefore, the exclusion is with intent. Lordship.
So I pay for responsible one. So I'm the affected party. I'm the Welfare Society of Indian Army Members, which promotes dwelling units for the army personnel, retired and widows. This was a project in Kolkata, where belongs the, in terms of the MOU, respondent number 2, as well as the petitioner were called upon to aggregate land, sell it to us, subsequently develop, and also will not pay to them for the obtaining the regulatory approvals from the competent authority to develop a housing group housing project. Now, what has happened is, the case of the petitioner is that he was not a signatory to the MOU. May I take lordships too? I just refer to 3-4 matters, 3-4 pages. Plus we have the petition, and plus we have page But it is annexure P3 at page 51. Lordships have it. Page annexure P3, page 51 of special petitions. Now, Lords, page 1 is the parties.
Sangha Builders Private Limited.
Now, Lords, we kindly come to the next page, my lord, that is 52. Paragraph number 2 and 3, my lord, set out the terms of development. Terms of development, but I need not read them out. Then, my lords, we kindly come to page 53. At paragraph 5, my lords, we'll see the first party has informed the second party and has acknowledged a total of 84 crores 53 lakhs onward to be divided among following manner. So, my lord, the 50, the respondent number 2 before lordships gets 58 crores 91 lakh odd rupees. Then, my lords, the petitioners are to be paid 13 crores 94.
Mr. Pasha's clients are Mirage Land Developers.
Number 2
and 3 in that lordship.
Oh,
they have received a amount of 18 crores. Apart from that, my lords, they were supposed to give the bank guarantee to secure the money, which they have given. Then, my lords, at page 54, your lordship will see, and come to paragraph 17, my lords, which is the arbitration clause. Lordships have it. The arbitration clause. Clause 17, my lords.
But they are not a party to this agreement.
I'll come to that. My lords, at page 55, your lordship will see, petition number 1's managing director is the witness to that. Is a witness to that, Narendra Chandna.
Yes.
Then, my lords, I take your lordships to, my lords, next page, my lord, 56 is annexure P4. And my lords, at page 57.
That's a deed of conveyance.
The 3 conveyance deed, by virtue of 3 conveyance deed, my lords, 12.254 acres was transferred to me. And my lords, we'll see at page 57 is conveyance deed number 1. In my lords, at 3.3.
And Chandna Developers is a
petition 1 is a consenting party. Then, my lords, next page, lordships turn to 3.4, my lords. It is petition number 2, which is the consenting party. Then, my lords, I take your lordships to the other conveyance deeds. Subsequently, annexed here to my lords. Same issue. All of them.
Petition numbers 1 and 2 are consenting parties.
Consenting parties. Now, my lords. Thereafter, my lords, I take your lordships to. Then, as it happens, my lords, there's a breach of contract. They fail to develop. They fail to protect my land. They fail to get all the regulatory approvals. As a result, my lords, by more than 7 to 8 acres, the land is unauthorizedly occupied. It's a matter of record, my lord, along with the counter. They are regularly being told for more than 2.5 years, please do the needful. They fail to do so. Then, my lords,
there is respondent number 2, not us.
Now, no, you are also addressed. Then, my lords, will kindly see the party.
Land belonged to you.
Yes. They were those 12.7278 acres was transferred to me by these 3 conveyance deeds, in which both of them are the vendor and the consent.
They were to develop the land.
They were to develop the land. They were also to get the regulatory approvals before development of land. Now, my lords, will kindly come to page 177. What happens thereafter is, my lords, they're summoned to carry out the, give us the relief for the breach committed. And then what ultimately transpires is that insofar as the petition is concerned, you will kindly, then that you committed breach, refund that 18 odd crores with interest to the lords. And my lords, we kindly now turn to page 177 and actually P17, your lordships, for the special petition.
P17?
Yes, my lords. P17 is at page 177.
Yes.
Now, my lords, we kindly turn to, this is the petitioners, it's a joint memorandum addressed to me, my lords, by petition number 1 and 2.
Appointed?
Yes, my lords. Justice,
Lordship, may I point out certain facts, because there are certain things that my learned friend has said that are factually incorrect.
You are both conforming parties to the conveyance deeds.
Lordship, the arbitration agreement is the memorandum of understanding entered into between R1 and R2 for aggregation of land. Lordship, just 2 or 3 pages I want to show.
Narendra Chandna is a witness, who's a developer, is a...
One of my directors is a witness to one of those agreements, and I want to show that the difference in the intent of the parties, Lordship may just see page 39, my first annex.
Now take my counter. They admit to counter. They admit that they will refund along with the interest balance. When the matter reaches to the point of time, paying the interest component, which is running into 8 to 9 crores, what happens is, at page 194, 194,
yes,
is a compilation filed by me, in the counter. But at page 195, what they say is there's a dispute relating to the interest component. And what he says is, we are working out all possible modalities, including clause 17 of the MOU, dated 29 September, settle the interest component. So they are themselves admitting, they are going to settle it by way of our arbitration clause, as clause 17. What else? He is admitting that. So therefore, I fail to understand. It meets the intent of section 7 of the Arbitration Act. You yourself are admitting.
Lordship may have page 39 of the SLP paper book.
He pays the amount. He admits to pay the interest.
This is a memorandum of understanding.
And then says, okay.
Entered into between
P1 and P2 are, you signed the MOU as confirming parties.
No, Lordship, they don't. That's what I'm trying to point out.
With regard to the Jaipur agreement.
That's right, Lordship. So in
The
2007,
only thing is, then why do you say in your reply that you are working out all modalities, including clause 17 of the MOU of 2019?
and that's just at that stage, they are saying that they are working out and to seeing whether it even applies. So Lordship, at that stage, they worked out and realized that it's not even applicable. And that's so all of this is prior to them seeking legal advice. But be that as it may, the language used is that we are working out, and they consider it, and they come to
shows that you are aware of the fact that you would be bound by the agreement.
Lordship, so I'll just take 2 or 3 minutes.
Once it goes before Justice Lokur, you can push all your
Lordship, in fact,
applications.
I'll indicate exactly what reservations I have. Before that, Lordship, I'll just show 2 or 3 pages. Lordship will just see page 30.
Why should we spend time today? You can always raise a jurisdictional issue before Justice Lokur.
Lordship, I'll explain why. Lordship, because in fact, all along, this has been a collusive intent. Lordship, I asked myself a question. R1 has a claim against R2. They serve a notice of arbitration. Arbitral tribunal is constituted. Earlier, it was Justice Deepak Gupta, a tribunal constituted. They constituted a tribunal behind my back, making me a party. So I filed an application with the tribunal saying this cannot be done. And so the tribunal released the reference. In the meantime, Lordship, it's been 2 years. No claim has been made by R1 against R2, even though the memorandum of understanding is for them to aggregate land for R1. Or the entire effort is only to somehow bring me into this litigation. Lordship, I approached the Delhi High Court. The 18 crores my learned friend spoke about, I have refunded. Now they're claiming interest on that 18 crores, for which I said that my checks given as security for 18 crores for refunding an amount that I had received can't be used for interest. That is pending. For 1 year, no written submission is filed by either party. Today, now, when I have there's an application pending there for the right of the filing of written submission to be struck off, written statement to be struck off. They are now again coming here and saying that by virtue of my having said that I was working out, or I even read section 17, therefore I'm a party. And I want to point out page 37, because when the same parties intended to be bound, and that's the test that Lordship has laid down in Cox and Kings, did they intend to be bound? When they intended to be bound, they made me a party. I'm a confirming party in the as far as the Jaipur line is concerned. There are rights and obligations which are
Can be raised by Justice Lokur.
And Lordship, the second thing the second wrong statement that was made, I am not a developer. Lordship, I am in the position of the person who is, once R2 aggregates the land for R1, I construct the boundary wall and do the leveling. Lordship, I asked myself a question. In case of a sale of land, can the gardener be said to be a necessary party because there is some...
I know, but this is not exactly a gardener.
Lordship, my responsibility as per my plaint are construction of boundary wall, leveling and street lights, where the underlying transaction is aggregation of land.
When you were asked to refund, why do you at the first opportunity say that, look, we are working out all modalities?
Lordship, it's not at that stage. Lordship, again, that's a wrong statement.
In 2000, look, sorry, there's no arbitration agreement at all between...
Lordship, so again, that's a wrong statement. In 2015 itself, I was asked to refund. I have been refunding, for which, because I had received money at the instructions of R2, he said part of the consideration may be paid on my instruction to the person who's...
How much of the amount have you, how much did you receive?
18 crores, I've refunded 18 crores. Now today, R1 is asking for interest on that amount.
He admits to pay.
So Lordship, just a second, let me finish. Lordship, so from 2015 to 21, I was repaying, I gave securities, bank guarantees, etc., saying I'll repay, I'm not running away. Once I finished repayment, Then this question of interest came up after they had given me a letter of saying full and final settlement. Now, Lordship, at that stage is when that letter has been written saying that formalities are being.
We'll keep open your objections under section 16 of the arbitration.
Questions of interest, my lord, which offers.
We'll keep open your objections under section.
Lordship, so
16
again,
for the arbitration.
on the collusion, the section 8s are filed by both of them on the same day. They've already appointed an arbitrator once behind my back, because the idea is not for the aggregator of the land and the clients to be arbitrating against each other. The idea is only for the person who was to eventually construct the boundary wall to somehow be dragged in. Lordship, because the Jaipur arbitration is going on, when my cases, neither of them has a claim, they're trying to mix these two facts. All along, what they do is that these two unrelated disputes, they intermix the facts, and I have very deliberately said that the parties have kept them separate by not making me a party to this arbitration. Lordship, the intent of the party.
We'll dismiss it, but we'll keep open your objections under section 16.
Absolutely. Absolutely.
All right. In the facts and circumstances of the case, we are not inclined to explain the specially petition under Article 136 of the Constitution. However, while dismissing the petition, we clarify that the rights and remedies of the petitioners, including by way of appropriate jurisdictional objections under section 16 of the Arbitration and Conciliation Act 1996, are kept open.
Thank you very much. Please, my lord. I'm appearing for the petition, my lord. When the matter had come up last time, the respondent had appeared, my lord. I'm appearing for the petitioner, my lord. This is for the appointment.
Yes, Vilas. Mr. Constable.
Yes, my lord. Am I audible, my lord? I'm appearing for the petitioner. The respondent had appeared on the last occasion. They had entered appearance on the last occasion. Your lordship had issued notice. They had accepted notice.
I'm for the petition.
Who's appearing for the respondent?
Lord, they had appeared the last time. Mr. Bhardwaj is on screen. In item 30, there's somebody by the name Mr. Ankush Bhardwaj. He had appeared last time, Mr. Ankush Bhardwaj.
Please, Your Lordship. I appear for the respondent, Your Lordship.
Yes.
Please, Your Lordship. Lordship, the instructions I have is any High Court, retired High Court judge may be appointed. There are claims and cross claims by both the parties.
Delhi High Court judge.
Please.
9 is going on before the Delhi. Section 9 is pending before the Delhi High Court.
Please, Your Lordship. Section 9 has been taking time in Section 9.
Appoint Justice Jain.
Yes. Very good. And my lord, can I make one more request which your lordship allowed in the other case as well? Can it be under the aegis of DIAC, my lord? It will help because it's a lord.
The arbitration shall take place under the auspices of the Delhi International Arbitration Center.
Please.
31.
It's matter may not detain your lordships. It's only the IA. The main matter is coming on 24th. All that I'm saying is I was to deposit 51 crores. 50 crores.
What is this for actually? This
was a matter where I'm the applicant. Allow me to explain.
If I am the petitioner, you are saying I
It's
want
my
to change the
application
fact.
only listed today. It's only my application.
No, I am not opposing this application.
This
I
is
am
all
only saying-
listed.
My lord asked me, what is this all about? Therefore, I thought
Maharaj, can I just
want to know the background of the case.
This is the
matter
only
has-
application listed
Justice
today
Najeeb
according
and then
to-
Justice Hima Kohli.
according to-
So it was before a different bench. So if your lordship want to know
we
about
have no clue about the matter because this is only an application for extension.
Can I explain? Can I explain in 2 minutes? By your lordship's order.
How much so far?
Let me just take 2 minutes by the clock. I was to deposit under your lordship's 23rd August order 50 crores.
51 crores.
51 crores by 6th of September. I was ready with in my hand with draft on 5th of 21 and not 51. I brought it to the registry. They said, no, the order is 51, therefore the whole must come. So you can't deposit the 20 you have. On the same day, I filed an application saying the balance 30, I will deposit on 20th of September, 15 days later. I went and mentioned before my Lord Justice Bindal's bench. He said listed on 6th. 6th they did not list is coming today. So today the only application listed, the main matter is on 24th, says allow me to deposit my 20, allow me to deposit my 20, allow me to deposit the balance 30.
Let it be placed before a bench of which Justice Bindal is a member.
Very well.
Lordship, there's only thing one thing I wish to point out.
21 I am carrying in my hand. Let that be deposited.
Permission of the court. And they admitted that we have got this 51 crores in hand with us.
Yes.
So in the bank.
Yes.
So if they had it in the bank, they could have deposited it. Lord, they're asking
Registry
time for
refused.
the purpose of deposit. When you have the money in the bank and which is not your money, you sold some property which we are not entitled.
Anyway, just Brother Bindal was he was conversing the matter. Let us go before Justice Bindal.
Put it on Friday.
I'm
before
not coming in the way.
Before
Friday.
Bindal on Friday. We'll keep it before.
Meanwhile, can I put my 20 crore at least inside? I've got it in hand. 20 crore.
Friday, let him pass a composite order.
What, yes, whatever.
Very well. Very well.
Lordship, please.
The first time I learned opposing a deposit money back. It's the other way around.
I'm not opposing
money.
On that, it will not be listed on Friday.
Friday was
32 is to be tagged with the.
32, my lord. Tomorrow the matters are fixed, my lord.
So notice and tag will do.
Lordship, the matters are coming tomorrow. Application for deletion of pro forma respondents. There are a huge number of pro forma respondents, so that may be allowed.
All right. Application for deletion of pro forma respondents is allowed. The risk and cost of the petition. Notice and tag.
The matters are anyway coming tomorrow.
Or should we just tag it with it?
No, Lordship can issue notice and tag.
Notice and tag.
Because Lordship has differentiated between those who are appointed and not appointed.
Right.
34.
May I please? Because the present SLP is by nearly 150 students of MBBS.
Matter is pending before the High Court, right?
Yes, fellows. Please have your lordship's order just a second.
That is the order passed by Justice Bhatt and Justice Datta.
Yes, fellows. Just imagine what is happening, Millards. 2018, when we take admission, Millards, we are told 5 lakh is the fees.
Yes.
2018, we take admission, 5 lakhs is the fees. It is, of course, subject to their writ petition, Millards. 5 years have gone by. Suddenly they say, now I'll enhance the fee from 5 lakhs to 13 lakhs. So give me 37 lakhs more. Otherwise, I will not let you start internship. So we come before your lordships. Lordship says, all right, you pay 2 installments. So we paid 8 lakhs more, 8.5 lakhs more. So 22 lakhs is the total fee as per original notification. 8 lakhs more is paid. And your lordship said, let the High Court decide the writ in 3 months. Lordship page 168 and extra P13. So we paid 8 lakhs, started internship, writ petition is pending. In the writ petition for last 1.5 years, continuously there is a stay order, so no further demands are made against me. Now, the High Court, now we appear for PG. So we are all MBBS, we have completed, we are sitting at home, we have taken the PG exam, we need the documents so that we can enroll and start practicing as doctors and also appear and join PG if we are admitted. Now the High Court says in the impugned order, your writ is admitted. Your appeals against the order in my learned friend's client's favor are also admitted. Questions of law and framed, but the High
questions are framed.
2 questions are framed, but the High Court says if you want the documents, then you please deposit the balance amount of 25 lakhs and 17 lakhs. Otherwise, you will not get documents. And the university, they're saying, I have my sole discretion to fix the fee.
Now, what is the total fee as fixed by the university?
Well, I'm very grateful for that question. Please have the additional documents. I'll give the figure straight away.
Give us the figure.
I'll give you the figure straight away. 2018, there are 2 quotas, All India and state. Let me focus on All India quota. 2018, when I'm admitted, 5 lakhs is the fee notified by the government. When the counseling begins, 5 lakhs per year. Per year. 5 lakhs per year is the fees notified for All India quota in 2018.
So 20 lakhs.
So 22.5 because it's a 4.5-year course.
22.5.
22.5. That we have paid. All internal 3 lakh security deposit also they have. So 25.5 they have, when I start the course. Then, after 5 years in 2023, the fee committee fixes a fee of 13 lakhs. Because for the All India quota is 13 and odd lakhs. I'll give the exact figure to your lordships. Just give me 1 minute. Page 52A, 13.22 lakhs per year. So it becomes roughly 60 lakhs. I have to pay roughly 60.
By 2023, so you had cleared your MBBS.
Right, I had cleared my MBBS. So 2023, when I have cleared my MBBS, the fee committee, fixes a fee for my year retrospectively from 2018, 5 years later. Then, 2 more developments, 2 more developments. Then two more developments. I gave an undertaking because my learned friend's writ was pending. I'll pay the difference amount. No difficulty with that. The differential comes to 36 lakhs more I have to pay. 36 lakhs more. Just imagine a parent who has admitted his child at 5 lakhs is told that all right, 22 lakhs you have paid, 25 lakhs you have paid, 36 lakhs more. I could understand if the fee increased by 4 lakhs, 5 lakhs. It's
already secured admission in PG.
no, now the counseling is to begin. For counseling, I have taken the PG. I have cleared my internship. I have completed. I have taken part in.
So you would be now liable to pay 36 lakhs.
36 lakhs. Now, just one more development. So because of Justice Bhatt's order, I paid 8.5 lakhs more. Because your Lordship's order at page 168, I have paid 8.5 lakhs more. Now, Milos, just see.
What is the idea in asking you to pay 8.5?
Milos, what happens? Difference was 36 lakhs. High Court divided it into 9 installments and said you deposit 9 installments every month till your internship is on for 1 year. You divide it into 9 installments and pay that in 9 installments. So we challenged that order before your Lordships way back.
Court said pay 2 deposits.
And let the writ be decided in 3 months, Milos. So we said all right. Writ is pending, adjourned to March 25. Writ is adjourned to March 2025, Milos.
College?
Yes, Manoj.
At least let these documents be given to them.
So if I can make two brief submissions, I think
you can ask them to pay another 4 lakhs each and give them the documents.
Mr. Agarwal is absolutely right. The High Court should not have pushed it off to March 25, especially after your Lordships have said it should be disposed of within 3 months, and it can cause hardship to the students. Identical matters come before your Lordships regarding documents. Just please see this. There are 2 universities. Mine is one.
Let us see
the other one is the one which is dealt with here, which is the Himalayan University. Do you have a copy? This, in which this university also was a party, Malod, which is who I am representing in a tagged matter, which came up later. But just see on the right side, Malod, these are identical issues. Final judgments, and this is final judgments from many high courts have come in favor of the institutes. It's not unique only. So if you just see on the right side, the 3rd paragraph on the right side page, Malod, the students are now requiring their testimonials, such as so-and-so, which would enable them to pursue higher education or look for sources of employment. At the same time, the interests of the self-financing institute cannot be overlooked, particularly when they've succeeded before single judge division bench for realization of fees. Taking note of the above, we deem it appropriate to say that the concerned testimonial should be released to the student subject to remitting the area fee payable by each student as noted in the chart produced on so-and-so.
Court said you pay up the full amount.
Yes, the full amount has to be paid. Now, I must tell your Lordship in fairness what happened after this. After this, based on this statement, the whole bunch of checks that were given by the students and the documents were given back. Once the documents were given and no due certificates were given, they discovered that the checks bounced. And then they filed applications now, but you can't. Now, in those cases, this case, the checks bounced after the new no dues had been given, all the documents had been given, and there's no way these institutes can go after. So they filed applications. These matters are still pending before your Lordships. Now, the second thing is, it's not correct to say that they were not.
Plus 150 students. And just see the demands for each
91 in this SLP,
but
of which 65 have withdrawn their IA, and therefore they would be.
Can we ask the High Court to prepone the hearing?
I think that will be ideal. Just make it even.
Counseling is on.
Just make it even 4 weeks, Malod.
Because this is a university which the state confers university status. They arbitrarily fix the fees themselves and say, please pay this.
It's not arbitrary. It's been fixed by the appellate authority. It's not been fixed. Can I just speak for a minute?
Because some
figures, I must correct Mr. Agarwal on this. The figures have been fixed by the appellate authority. And when the students took admission, it has been noted in a previous interim order, when the students took admission, they were put on notice by the NEET fee fixation guidelines in 2018 that for college numbers 4 and 5, which includes their college, the fees of 5 and 4 lakhs are subject to the outcome of the writ petitions coming. So they knew that the figures would be higher. They knew this. But this is students' issue, so I don't want to. I think the ideal thing is if it can be disposed of in 3 weeks or 4 weeks.
Lordship said I can deposit 5 lakhs and I can get the documents. High Court can decide.
Only trouble is once you pay 5 lakhs, it's impossible to change the students.
No, but because it will be amounting to contempt, it will take action against them, but you can't hold my careers back, Milots. PG exams will be held, have been already held. Now you have, it is not some unsubstantial amount, Milots, 22.5 first, 8 subsequently, 3 security deposit they already have. Your Lordship said 5 lakhs more, I'll deposit 5 lakhs more, Milots. What else can I do?
Lots of
Milots?
students have
But
already paid.
just take this, Milots, after 5 years, a parent, Milots, just as a parent, I pay 4 lakhs or 5 lakhs. You are told pay 3 times the more amount in 2023, Milots. I would have taken admission somewhere else, Milots. There are colleges and colleges. I could have gone somewhere else. A university becomes a state university. The fee committee says, without any reasoning, says 13.9 lakhs, 13.22 lakhs. I have challenged that fee committee order before the High Court, Milots. So, Milots, where do we go as students, Milots? We end up being pushed by all sides, Milots. You can't practice as a doctor. You can't take admission in PG. You have paid 8 lakhs more. Lordship may direct one more installment of 4 or 5 lakhs, Milots.
Now, you have paid about how much?
Plus 22.5 towards fees I have paid for at 5 lakhs per, for I'm talking of all India quota, Milos.
Now that will go up to almost 60 lakhs.
That has gone to, yes, Milos, 65 lakhs, Milos.
So you are asking for your documents against 5 lakhs?
No, Milos, I'm just saying, please take more. 3 lakhs is security. Milos, please take more payments. 22.5 paid, 3 lakhs security deposit, 25.5, 8.5 under your Lordship's orders. That Justice Bhatt's order. So 34.5. Now I'll offer 5 lakhs more, Milots. So 40 lakhs as against 22, roughly double I paid. One can imagine, Milos, suppose I give an undertaking, I will pay. If I suppose I have a parent, I admit my child, I'll at 2 lakh rupees. I'll say double ho jayega.
Go technically. Manoj, they have put out our office order where we have given the arrears for each of the students.
Yes.
That's at page 6 of the IA.
Just look at this, Milos.
For
25 crores more they want to recover from us.
25 lakhs?
No, per student. There are 150 students.
So 25
So the university
lakhs,
says pay me 25 crores more.
it's
They have run
25
for 5
lakhs,
years.
25 lakhs per student who are all India quota and 17 lakh 74 for state quota. These are the areas per student.
Furnish some solvent security for the balance.
Plus, what I was saying, Lordship, you put 5 lakhs. The writ is pending in the High Court. The university has run for 5 years. Despite me not paying, the university has run for 5 years. It is not that my fee was important. It was earlier 5 lakhs Milots. They became deemed university and then they persuaded the fee committee suddenly in 1 year, Milots. How can Milots, asking a question to myself, a college is charging 5 lakhs for the previous year. In 1 year, what it has achieved, that it becomes 13.5 lakhs, Milots. I can understand. Your Lordship will say that total amount of 10 lakhs may be paid. I can understand that.
Where is the order of our court of...
Page 168, Milots.
Page?
168, annexure P13, Milots. And after that, 11 orders of the High Court. Sorry.
As per their demand,
Yes.
figure comes to 65.
Roughly 62 Milots.
Now,
Yes.
22.5 plus 3.
Plus 3, 25.5.
5.5 plus 8.5.
Plus 8.5.
34.5.
8.2 actually, Milots.
And
So I'll pay so that it becomes 40.
after 34.5,
Yes, Milots.
you have paid 8.5 more?
No, Milots. 34.5 includes 8.
Okay.
Yes, Milots.
Can you make only those who only instruction. So you can ask. Reasonable. Well, the petitioners haven't indicated how many of them are applying for this PG. So otherwise, if
whoever
the,
pays, whoever
if
has,
the High Court can dispose it of in 3-4 weeks, it's only the PG people who are on some urgent.
no, I can't practice as a doctor also. I will not be registered. So you're sitting at home. Sorry, PG is one aspect. I will hear they're not giving me the certificate. Minutes.
The dispute in the present case relates to the fixation of the fee for the undergraduate medical degree course.
Get it.
Full stop. On 4 April, following the enactment of the Fee Fixation Act 2006, right?
Yes, my lords.
The Sri Guru Ram Rai Institute of Medical and Health Sciences College was affiliated with the university. Full stop. On 4 April 2018, the nodal agency, this was a nodal agency appointed under the
Counseling, my lords, under the state government, which tells the students that this is the college, this is the fees, my lords, page 46.
The nodal agency appointed by the state government replaced the fee structure in place of the fees which were prescribed by the second and third respondents.
Correct.
Full stop. The revised fee became the subject matter of a writ petition before the Uttarakhand High Court.
Correct.
Full stop. The High Court, by an interim order, directed that admissions may be carried out.
Correct.
And the fee collected would be subject to the final outcome of the writ petition.
Correct.
The Fee Fixation Committee prescribed the fees for the years 2019-20,
correct,
2020-21, and 2021-2022 at rupees 13.22 lakhs per annum for the All India quota.
Absolutely right.
And rupees 9.78 lakhs
Correct.
annually for the state quota.
Correct.
The appellate authority affirmed the fee structure and the same fees for 2018-19.
Correct, Milos. Absolutely right.
A letter was addressed asked by the college principal on 1 March 2023 asking all the petitioners to pay the outstanding fees of rupees 36.99 lakhs.
Correct, Milos.
For the All India quota students and rupees 26.01 lakhs for the state quota students.
Absolutely.
The order of the appellate authority was challenged by the petitioners. Full stop. By an interim order dated 3rd April 2023, the High Court directed the petitioners to deposit the amount in 9 equal installments.
Correct.
When the interim order of the High Court was challenged by them before this court, an order dated 28 April 2023 was passed in SLP Civil number 8760 of 2023.
Correct.
Permitting the petitioners to continue in the internship program subject to the deposit of 2 installments in terms of the interim order of the High Court.
Right.
The High Court was, however, requested to dispose of the pending writ petition expeditiously within a period of 3 months, preferably within 3 months. Let's stop. When the petition came up before the High Court, by the impugned order dated 6 August 2024, the High Court admitted the petitions and directed that subject to the deposit of the fee as fixed by the university, the documents would be returned to the students. Next. We have heard Mr. Gaurav Agarwal, learned counsel, appearing on behalf of 91 students who are before the court in these proceedings.
Correct, Manoj.
And Mr. Gopal Shankar Narayan, learned senior counsel, appearing on behalf of
Respondents 2 and 3.
the second and third respondents. Full stop. The original fee, when the students took admission to the All India quota seats, was rupees 5 lakhs per annum, and for the state quota,
4 lakhs.
Rupees 4 lakhs per annum. Full stop.
On that, just for completion, if you see page 46,
Yes.
where those amounts are mentioned, this is from the NEET centralized counseling itself. This is annexure P2, page 46.
Yes.
Right, Manoj? You see item number 4, that's college number, the college name is Guru Ram Rai.
Yes.
Now just see the footnote at the bottom of the page. Fee structures of institutes shown
Yes.
in serial numbers 4
At the
and
same
5.
time, comma, it is
Just, I'm sorry, I'm just saying something else. But serial number 5 is the other order I handed up to your lordships.
Yes.
Serial number 4 is this one. And both are subject to the outcome of writ petitions.
Which is the other order, this one?
Yes, the one I handed up.
That is that Salman Badar.
Yes, that's Himalayan Institute. That's Himalayan Institute. Item number 5. Because these two are the ones which are subject to outcome of writ petitions.
This is also part of the same batch?
That order, I am not even aware that it has passed. My learned friend tells me, even my learned colleague is not aware. Manoj. We are not aware. There's no reference to this order.
It's in fact,
Is it?
in fact, subsequently for that year, the serial number 4 also intervened in the Supreme Court in the same batch.
At this full stop.
It appears that's the final order because it says the challenge to the fee has been rejected by single judge and division bench.
The fee structure as posted by the nodal agency on their website into brackets annexure P2 indicated that the above fee of rupees 4 lakhs for state quota seats and rupees 5 lakhs for the All India quota was subject to the final decisions in the writ petitions which were pending before the High Court. Let's stop. Admittedly, the challenge to the fixation of fees is yet to attain finality.
Correct, Manoj.
Since the petitions have been admitted by the High Court. In the meantime, it is common ground that the petitioners have paid an amount of rupees,
Roughly 34 lakhs.
approximately rupees 34 lakhs.
Yes, little bit here, there for all India quota.
For the All India quota
For the state.
and rupees.
Just 1 second, Manoj. No, see, only fees.
Fees.
Just give me 1 minute. 18 plus 3, 21. 21 plus 6, 28 lakhs, roughly 27 to
28 lakhs per student
for the
for the state quota seats. This is in addition to the 3 lakhs their security.
No, totally. They have also adjusted security.
All right, that's fair. And this includes the 8.5 lakhs paid under the.
Yes, Manoj. This includes
This
security at 8.5 lakhs.
Mr. Gaurav Agarwal, learned senior counsel, states that the above figure, as indicated to the court, is inclusive of bracket 1, the security deposit of rupees 3 lakhs, which has been adjusted, semicolon, and bracket 2, the two installments, which were paid in pursuance of the order of this court dated
28th April.
28 April 2023.
Correct, Manoj.
Full stop. At this stage, next. At this stage, bearing in mind the above amounts which have been paid, we are of the view that an equitable interim order should be passed so as to enable the students to obtain the return of their testimonials to pursue their postgraduate studies. Full stop.
And also practice, my lords.
And practice medicine.
Yes, my lords.
Full stop. Absent such a direction, comma. The students, despite having completed their MBBS, the course of their undergraduate medical studies and internships, would be unable to either pursue medicine or seek admission for higher studies.
Grateful.
Full stop. We accordingly issue the following directions. Bracket 1. The petitioners, conditional on the petitioners, I don't say bracket 1, conditional on the petitioners, bracket 1, depositing an amount of rupees 5 lakhs each in with the second and third respondents in over and above the amounts which have already been deposited, comma, they shall be entitled to a refund of a return of their testimonials submitted at the time of obtaining admission, subject to the condition that the petitioner shall file an undertaking to pay the balance in the event that they are called upon to do so upon the conclusion of the final
Pending matters.
upon the at the final disposal of the pending petitions. The petitioner shall submit solvent security for the balance other than cash stroke bank guarantee to the satisfaction.
This will become an because 100 students will be landing up before
I have a counterbalancing suggestion, which is this. These documents, original documents, they need for showing at the counseling or for registration as medical practitioners, after which the originals revert to them. Let them give the originals back to us. That's the security I have against them.
I mean, I don't know. This,
Or you give me solvent
the
security.
university has trained us.
No, or you
We
give me
are
solvent
not run
security.
away. The
I have
matter
no
is
problem.
pending.
No, you are. I know that many of you did run away. Many of you gave me bounce checks. Now I don't know if it will happen again.
The university shall, don't say solvent security mat likho. The subject to the condition that the university shall depute an authorized person for the production of the documents of the petitioners, either for the purposes of registration,
yes,
or for the purpose of counseling,
yes,
for obtaining postgraduate admission. Full stop. The documents shall be returned back to the university, to the second and third respondents after the above purpose is completed, to abide by the final result of the proceedings before the High Court. In order to facilitate this exercise, the petitioner shall furnish intimation to the second and third respondents in regard to the place of counseling, stroke registration, where the documents are required to be produced.
As watches are passed an order, it may be unworkable is all I'm saying.
You are also
PG counseling takes place
all over the country.
All over the country. Now, my lords, please take it. Lordship, if suppose you don't pay, the university will say, I have nothing I can do about it. A student is not paying. Out of 100, 50 will pay, 60 will pay, 70 will pay, or 50 won't pay. Ultimately, when your lordships are doing a balance, lordships are also considering as against 5 lakhs, it becomes 13 lakhs. Lordships will prima facie see what is the reasons which has weighed with the committee. So, my lords, lordships may, these are all doctors who have been trained, who are ready to practice.
What we'll do is this.
Yes.
Instead of 5 lakhs, we'll make it 7.5 lakhs and put an end to it.
Right,
Because,
please put an end to it. My lords,
solvent
lordship will do that.
security, we also see the solvent
Yes,
security.
lordship will do that. It puts an end to it.
It's such a large batch of students.
Yes, my lords.
I'm only saying,
So make it 7.5 lakhs.
Lordship may take
और वो
it.
latter part आप delete कर दो, हाँ?
See, suppose the High Court directs the petitioners to pay. They don't pay. University will not leave us. It will file contempt against us. It will come out everything.
We'll say that you'll file an undertaking to pay the balances. That we've already done.
That your lordships have already done, my lords, and you have paid substantial amounts. Lordships will balance the whole
I'm
thing.
just saying that in the Supreme Court, students have deceived the universities. They have done it. I'm not saying that they will do it, but I'm saying it's happened and they've given checks which bounced. They took their documents and they've disappeared into middle distance. Now, if that happens here, it's all very well to sit on this, make it seem
How long do we keep them pending? We thought
No, that's
obviously brother Bhatt and brother Dipankar Datta felt that, well, we should direct the High Court to dispose of the.
correct. So, yes, that is
High
correct.
Court simply admits it and keeps it
No,
in
no,
March.
High Court should not have done that. High Court should have disposed of it.
We
Now,
also
those
thought whether
two-
we'll ask the High Court to prepone and now hear it, but again, they'll be left with the same problem.
Take a look at the situation. 9 installments are assured. It becomes 2. They are allowed to go on with their internship. We keep quiet. The internship completes. Now they say,
said one more installment. We have basically given them one more installment. Also.
there's no security now. Now they've taken all the documents and gone, then there's no security.
Today, the university
As far as we are
fixes its
concerned.
own fee, my lords.
That's only.
This is a situation where for MBBS, when you go to fee committee, university today fixes
No,
its
the
own
From
costs.
middle class parents.
High Court judgments have finally decided.
It's okay, great.
Thankfully, my lords, we have moved on from the capitation fee days.
And take it like this. Grateful to you, Lordship.
Grateful, man.
Lordship will dispose of this SLP. Lordship will dispose of this SLP because this.
Yes, we'll dispose of
Yes,
it.
grateful to your Lordship.
Your lordships have clarified that it's only after the payment that this document.
Yes.
Yes, my lords.
Grateful.
The High Court order may be modified. This interim order, High Court order may be modified.
Some indication of them disposing
Now
of.
it's kept in March 2025.
No, but if it can be explained, now foot is on the other foot, I would be happy to have it. Grateful.
35.
May it please, Lordship.
Lord, I'm sorry, my video seems to have been playing up. I'm sorry.
Lord, this is a matter, my lord, in which the
Yeah, there was a delay of 402 days, no?
there is a delay, my lord. Now, two things, my lord, on the delay. My lord, the same judgment, my lord, is under appeal.
On the same side, my lord.
Lord, may I just, my lord, make a
Me and this
submission?
Devan on the same side.
Right.
Lord, actually, just to cut short the issue.
Lord, may
as
I
far as
may
this
I
is
cut
concerned,
the matter
delay of
short
402
connection?
Lord,
days.
they may have a better
Let me just answer that
case in
question,
another
my lord.
matter. I'm
If
sorry,
you
I'm
want to
interrupting
answer
Mr.
the
Yes, what
Gupta.
about the delay? What do you have to say?
Yes, my lord. First of all, my lord, this is a judgment which is already under appeal before your lordship. Two matters, my lord.
That is pending before Justice Bela Trivedi.
That's right, my lord. Now, this is an order which, if your lordship looks at the operative portion, is not divisible. It is not as if somebody, it is not as if, my lord, in some cases it can be upheld and in some other cases it cannot be upheld. I'll explain that on facts, my lord. The second thing is, my lord, I do get an opportunity.
Pertains to the grant of those 6 marks for the
6 marks. The entire marking will have to be redone for the entire batch. So, my lord, it cannot be, my lord, that this judgment will remain for some and will not remain for the others, because, my lord, it is a composite order.
on delay and we'll tag it. Justice Bela Trivedi says of the other matter.
If your lordship may kindly see page 60.
As a matter
Just tag it, my lord. I'm not
this is the board of primary education. You can't-
Just,
Only, my lord,
I'm
two
so-
submissions, my lord, page 60.
My lord, also one other thing I wanted to say.
issue notice on delay and on the special
Yes.
petition.
Lordship,
Tag
I
it.
wanted to
Lord, I just want to point out one thing that I'm the
just one more
sole
thing, my lord, if I may.
respondent.
Ms.
I
Devan,
just,
please, one
I'm
more
not
thing.
affected one bit. I should not be vexed, my lord. They can bring petitions against whomever they want, but I have in any, even without these grace marks, even if I'm not given a single out of 6, I make it to 82, which is a pass mark. I should not be vexed because I've been serving for 4.5 years.
That's all right. Anyway, you are here. Who's passing an interim order?
Whoever doesn't need those 6 marks, my lord,
That's
does
right.
not affect.
If people are making it without those 6 grace marks, it makes no difference to them.
Lord, I'm the sole respondent in this petition, which is why we are raising this. They may bring it in another appropriate matter.
But this order has to be given effect to, if it is to be given effect to, my lord, the whole batch, my lord, will have to be given 6 months more. 6
Lord,
months.
I will not interfere with that, but they must bring it in an appropriate petition where they
There's only a
respond.
sole respondent.
There's sole.
Yes.
My lord, the entire panel has to go.
But here there's
Because here
only
it
one.
says West Bengal Board of Primary
Let me
Education.
show you a lot.
Pratibha Mandal.
And then
Pratibha Mandal, we appear for
Lord,
Pratibha
this is the
Mandal. She's
confusion, my
not.
lord, which I was
5,000
afraid of.
5,000
Please see the
candidates.
operative portion.
They
Please
have
see
said-
the operative.
They have said give 6 marks across the board.
Across the board. Now, if this, my lord, the question is, my lord, can this order be upheld for some petitioners and not
No,
upheld?
obviously not.
It cannot be, my lord. There has to be one result.
We are only saying by all means challenge it. We have nothing to say, but bring it.
At the final hearing before that bench, this will go before that bench. You can say that, look, I'm covered anyway because I have not attempted these questions.
Would your lordships consider recording that our submission is this, that we are not affected at all, and that we make the grade even irrespective of the judgment.
Milord, I cannot give effect to Milord the panel till it is finalized.
We'll tag it. We also
5,000 appointed, only 1 minute, 5,000 appointed.
All right, now we'll hear this with that other matter.
No, my appointment should not be disturbed, Milord, because
have we stayed the appointment? Yes.
But no, just see the conduct of the board. Six wrong questions by them, Milord. Then, Milord, they are asked to.
See the board if it didn't do that.
They should be saddled with cost, Milord.
Milord, this is completely wrong.
It's happening
One
every
of the
year.
first problems with this judgment is that the question is not wrong. The answer is wrong, Milord. That is what is the finding is.
All right. Item 36.
Deeply obliged.
Lord, would they be making all others the parties, Milord? Because here I'm only one. There are about,
their choice. Let them
there are about 200 writ petitions. 200 writ petitions, Milord.
It's a petitioner in person, Your Honor. So the petitioner is my son, Shrikar Taluri. He is a minor, 17 years old. And this is against the NTA. But please note that we are not asking for a
But you have suffered from hyperhidrosis.
Yes, he suffered.
So that he wanted a hanky and he was not giving a hanky at the NEET UG. But now what do we do?
Sir, we are not asking for a re-exam. I want to make that
retest
clear.
Is now out of question.
Yes, sir, we understand that ship has sailed, but there is a new ship that has birthed. That ship is called counseling right now. So in the prayer that we put in front of the High Court itself, we said there were two other prayers saying give us concession in terms of the seat that he gets, or after reviewing the evidence, which is that 10 minutes of video evidence that we asked in the interim application in the High Court, that was not provided to us. Once it is clear to your honors that yes, this medical accommodation was taken away from him, that he really suffered during the entire 3 hours, 20 minutes of the exam. Once you are comfortable with that, then give him some kind of relief.
If he doesn't have a hanky, all that he does, he had to wipe it on his shirt sleeves or his trouser.
Thank you for asking. That's your honor. The honorable learned judge also asked the same thing. And I would like to hand these two documents over.
So now, but now there's no question of holding a fresh UG exam again.
No, we are not asking for a re-exam at all, sir.
What are asking for today?
We are asking either because he's a meritorious student. He's got a double promotion even during his schooling.
Right, but what can we do today?
Either give him a seat in a better college, number one, or I'm trying to assess the court.
That means we will be reassessing his merit performance and saying that, well, he must be given more marks than he got.
Sir,
he can't change his merit position.
Just let me just refer to page number 103.
Now declared.
Yes.
You will be allotted a seat in accordance with your position in the merit list. How can we say that give him a better college? That means we'll be giving him 2 marks more.
Yes.
Or 1 mark more, 5 marks more.
Okay. There's one more prayer, Your Honor. It says in the event it's not possible to conduct a retest for the petitioner, direct the respondent to pay compensation to the petitioner to the tune of the difference between the fees for an MBBS degree at a government medical college and that of a private or deemed university.
It's difficult for us to direct that, who will pay the compensation?
So
National testing.
Whoever caused this harm, we have absolutely no doubt, sir, as an anguished father and a reasonable person, I teach my sons not to be greedy. So this clearly happened. He suffered throughout the 3 hours, 20 minutes of the test. So the people who lost 20 minutes, their justice has been served to them. Re-exam was done. That is done with. He suffered for the entire 3 hours, 20 minutes. So whoever, it's a law of natural justice, I believe, which says that whoever caused the damage should have to pay. So the third one that I just thought of today, in round 1 of counseling, we took a category C seat, which is the most expensive seat. So he has got admission into a certain college. It's not one of these colleges that we have mentioned here, but at least, why should he have to suffer? Why should we as a family have to suffer because of no fault of ours? So at least in that college that he has already got admission to, kindly give us some relief.
However, that college is not to blame, right? I mean, how do we tell that college you charge less?
By giving them, an additional seat, maybe next year, maybe later this year. Sir, I'm trying to help your honors. I'm using my brain to the best of my ability.
We can't, these are not orders which we can pass. That ask the college to get one additional seat next year so that they give them a concession in the fees for this year.
Or maybe, in round 4, 5, and 6, when seats are left, and the college is trying, and the MCC, Medical Council Commission, is trying to fill those seats. If there's a vacant seat in one of these colleges, then maybe you can permit him to switch from the college that he has taken permission in now to a vacant seat in one of those colleges, Your Honor. So we are trying our best. We have not done anything wrong, and you have to permit me to say this one maxim.
When did you first raise the grievance? After the examination on 5th of May?
On June 5th, I reached out to them for an OMR sheet which was not being given.
So exam took place on the 5th of May. For a month thereafter, you don't raise any grievance at all?
That
means, this is really an afterthought. You can't wait for a month.
Sir,
You're appearing for NTA or?
So may I answer that?
Your Lordship, the exam was held on 5th of May and the petitioner approached NTA almost a month later and his representation was also replied to. And Your Lordship may see para 11 of the...
The hanky was allowed to be kept?
Hanky was allowed, Your Lordship.
Your Honor.
Your Lordship, it is not a banned item.
It was allowed on paper, but it was prevented by the security guards. And all you have to do, Your Honor, is take a look at the 10 minutes of video from 11:51 a.m. to 12 noon. And if he took a hanky into the exam hall, I am willing to pay the cost. And whatever, I'll subject myself to the court. You can...
Para 11 of the impugned order. The learned division bench has clearly considered all these aspects. If I may read, the petitioner appeared in the examination on 5th of May 2024, but did not prefer any representation, immediately appraising the authorities about such restriction in not permitting him to carry the handkerchief inside the examination hall. The respondents.
So may I respond to that, Your Honor? May I respond to that, Your Honor?
And Your Lordship.
There is your own judgment.
The excessive sweating, a wrong digit was bubbled in the OMR sheet. How is that possible?
Let me explain.
All the other
The question, Madam, the question
questions
was asked to
have
me.
been properly marked, Your Lordship. It is not the case that all the...
He attempted all the questions.
No, he did not attempt all the questions. He was short of time.
122 questions in the entire duration.
Out of?
Out of
180.
185. Yes, Your Lordship. It was... But Lordship, so it's not the case that he suffered during the entire examination or 3 hours, 20 minutes, because he has attempted 122 questions. And Your Lordship may kindly see the OMR. There are no smudging. So it is not the case that the entire OMR has got smudged because of the sweating. This is one question. He says that it is wrongly marked. So which is not the cause of which is not the result of hyperhidrosis.
Your theory that this,
can you please
resulted in some one question, one option being bubbled up, as you say.
No, not at all, Your Honor. Not so.
Why did you keep quiet for 1 month after the exam? 1 month you said nothing.
And even
Your Honor,
examine.
Yeah, respond, please.
These are objections you have to raise right up front. That look, for 1 month, if you keep silent.
So may I respond, Your Honor?
Late then to.
And NT also has
Your Honor.
enters a report where it has not mentioned.
Yes. So I went through the bulletin. In the bulletin, it says in 17.6, and you must recognize that I'm not a lawyer, Your Honor. I'm just a father. So I went to section 17.6, which is there over here, if you can kindly care to take a look at it. And here is the second copy. The NEET bulletins 17.6, it says any grievance can be raised up to 1 month after the results are announced. And my second worry was that if I approach the government without proper proof, they will just push me away. That's the reason I waited for the OMR to be released. And the day I realized that the OMR has not been released, I immediately reached out to them. And the next point I request you to keep in mind, Your Honor, is when we reached out and filed the representation, grace marks were in vogue at that time, but we did not ask for the grace marks. So I'm asking you to take a look at 17.6. We never asked for grace marks because I know the potential of my son. And even before the NTA themselves decided to conduct a re-exam, we asked them, we said, please conduct a re-exam for us. So there's one more point besides this. There's a case law, Your Honor, that you had written yourself. I have 2 points, Your Honor. I have 2 points, Your Honor.
Said that your performance was not affected by the ailment.
It was, sir.
Possible view of the High Court. How do we say that the High Court is in error in that?
The 3 things that happened during the exam, it's not just during bubbling. If you can see, this has been a constant companion with him throughout his life. Whenever he's writing something, when he's playing, he uses a glove. So, Your Honor, I request you to just listen to these 2 points. One is the sweating is continuous. It's not sporadic like a cough or a sneeze, like the Honorable High Court pointed out. So the sweating is continuous, and the Mayo Clinic themselves said that the sweating can be so profuse that even the clothes become wet and the sweat drains as if it's coming out of a tap. So what happens and how it affected the exam, Your Honor, is that the paper that he was writing on which he has to do physics and chemistry calculations. And
what we'll do is we'll close orders. We'll look at it at home and we'll pass orders later. We'll just close it for orders. We've heard you.
Okay.
You've heard so and so.
May I say one last point, Your Honor? One last point. All of you might have heard.
Deeply obliged, Lordship.
38 हो गया था भाई. 39.
May I please,
Yes.
I am granted. Sorry, you're also.
By the order of the 8th of June, Mr. Diwan is appearing for?
No, he's the. I had.
My learned friend is doing it. I have no problem.
All right. Whoever is appearing. By an order of the 8th of June 21, the High Court directed that CITCO may continue the work either through the petitioner or through any other party by following due process.
Correct, but it has to be the project.
But you see, the fact that the work could be allotted to a third party was known to you by the 8th of June order.
Fair enough, but what has happened here? But
they issue a fresh notice.
No, but just see the two, my lords, there are 2 essential points over here. First, your lordships would have noticed that before CITCO arrived, there was a Konkan irrigation department which was conducting this tender. The original work order was issued by them. I completed substantial amounts of the work, and thereafter the scope of the work changed. Now, thereafter, there were controversy after controversy.
Now they issued a fresh tender.
But that's the whole point. The point is the
participate in the fresh tender or not?
No, that's been extended, so I have time. But that's not the point. The issue is, please see the directions of this court. But please see the directions of this court. There is already a project. I have completed substantially. Because I have completed substantially the project.
Your claim may lie if there's an arbitration agreement for recovery of whatever work you've done, loss of profit.
That's a separate issue for that. Recovery is
so we can't. After the earlier judgment of the High Court, we can't say that they must only award it to you.
No, may I just say this? Once there is a award of there is a project. That project has certain parameters. Now, there are 2 High Court orders which your lordships will see, both in my set of writ petitions.
8th of June and 9th March.
That's right. And both are, so there were 2 sets of petitions. One the PIL, one was the set of petitions that I filed. On the basis that the Konkan Industrial Irrigation Department Development Corporation had said that, look, there was no wrongdoing which was found at all with regard to the project. We are going to continue with the project.
Round 1, they cancelled your tender.
They had historically.
Right. Then you challenge it in a writ petition.
Yes.
High Court says that, look, they may either give it to you or give it to any third party.
So now that, I said, I will.
The fact that it may not, that you had no indispensable right to get the contract, it appears from the earlier order. You accepted the earlier order.
So, Millers, may I put it this way? If your lordship goes to the tender notice at page 118, which is the subject matter of my challenge, they have completely changed the parameters.
I think there's nothing.
Millers, would your lordship just have a look?
Nothing, Mr. Diwan.
Millers, please see.
Thank you, Mr. Diwan.
Very grateful.
Lord, this is April 24 order, my lord. We are trying to protect ourselves. But it's a 1700 crore award. But please see the trajectory. My lord, the award is passed on 7th of April 24. So far as our counterclaim.
Yes, that is about 1764 crores.
Yes, yes. So now, right now it's 1700.
Then you file a section 9.
Section 9. Section 9, my lord, because so far as my counterclaim which is allowed by the tribunal is concerned, they are not challenging. My lord, my section 9.
You would notice in the execution petition.
Execution, even, my lord, the section 9 is heard and no orders are passed. The difficulty is.
When is it now coming up before the High Court?
I'll just tell you, my lord, tell your lordships, my lord, the trajectory. My lord, the section 9 petition comes before the, my lord, the learned bench. Somebody appears and there is a recusal. It goes to vacation bench, notice is issued, no injunction is granted because we are apprehending that they will dispose of the property from where we would recover our 1700 crores. I am NHAI. My lord, next day, the learned second judge, my lord, also had to recuse because of some appearance. Now comes some counsel from outside who is not one of those two counsels, my lord, who, my lord, appeared and recusal was the result of that. Now, my lord, High Court has heard section 9 on 3rd of July 24. I'm sorry, 19th July 24. And judgment is reserved. My lord, since there was no protection, we approached the Honorable Division Bench. Lordship may kindly see page 411. The Honorable Division Bench, my lord, passed an order that we request the learned judge to decide it. Obviously, my lord, the Division Bench cannot say either way. My lord, yes. In the meanwhile, the other side filed section 34, which is filed, my lord, somewhere in July 24. So it is tagged with section 9. So we had to file 36, my lord, for enforcement and sought the same relief that till our enforcement is decided. Please attach the property or injunct them from transferring the property. Only notice is issued.
Now, the notice is issued in that OMP enforcement 179 at
Yes,
page 1.
yes, my lord, which is the impugn order where we insisted.
Now it's coming up on the, it was to come up on the 2nd of September, right?
Yes, it's now coming up tomorrow, my lord. I'm not on that, but it's coming up, my lord, only for my lord, hearing, my lord. Section 9 is heard.
Section 9 and section 34 are before the same judge.
Yes, and 36 also, my lord. Then it followed, my lord.
We'll say that since the matter is before the Delhi High Court tomorrow.
My lord, 9 and 34 are reserved for orders. 34 was filed in July
and
immediately heard and reserved.
9 and 34.
Yes.
What is the date of the reservation? CAV?
24th of July 24.
24th of July
34.
24.
19th July is heard and reserved on 19th July. That is section 9.
Yes.
And 34 is reserved on 24th of July 24. So tomorrow what is coming is only execution.
Your execution.
Yes. And my 34 against the rest of the award.
Oh, I see. Following the award of the arbitral tribunal, the petitioner, moved an application under section 9 of the Arbitration and Conciliation Act 1996. The Learned Solicitor General states that on 19 July 2024, the proceedings under section, judgment was reserved on the application under section 9.
Yes.
At the same time, the court, don't say at the same time, the court is apprised of the fact that a petition under section 34 of the Arbitration and Conciliation Act 1996 filed by the respondent has also been heard and judgment has been reserved on 24 July 2024. In the meantime, the Solicitor General states that a petition under section 36 for enforcement was listed on multiple dates.
No, 20th of August 24.
Was listed on 20 August 2024.
And only notice is issued without any protection.
On which notice was issued. It has been stated that the petition is now due to be listed for hearing tomorrow.
Yes.
In this view of the matter, since proceedings under section 9, arguments under section 9 and section 34 have already been concluded and judgment is awaited, it is not necessary for the court to exercise
In the
jurisdiction.
meanwhile,
of the
your
present
lordship,
case.
this is status quo be maintained, my lord.
Full stop. However, it will be open to the petitioners to move the High Court when the proceedings are taken up immediately tomorrow for appropriate directions.
My lord, the division bench did make that attempt, my lord, page 411, if your lordships can.
Annexure,
Yes, my lord. Annexure P10, my lords. It's an order dated 5th July 24. And please see, my lord, the last part after recording everything. Para 4 and 4.1. We are also informed by counsel for the parties that aforementioned petition under 9(1)(b) is listed before the single judge. Given this position, the appeal is disposed of with a request to the learned single judge to take up the aforesaid petition and dispose it of within a reasonable time frame. Look, their conduct is such, the respondent's conduct.
Transfer the property?
Which property, Mr. Mehta?
Yeah, yes,
Which
my lord.
property?
Can you see the prayer clause, my lord? We have, my lord.
Where is the description of the property?
Yes, my lord. Page 573, my lords.
annexure,
No, it's my prayer, my lord, in the execution. There is no description. P17,
Which paragraph?
C, my lord. The details are in C. What is that? It's an SPV, so they won't be having any properties.
now the judgment will
574.
be reserved. Judgment will be delivered any moment now after the 34.
Lord, that's what we have been, my lord, hoping since May.
Section 9, the judgment should be delivered very shortly. How much time will Section 9 judgment take? It's been reserved on 19 July.
Lord, it was filed in May and it was heard in July.
Let the High Court decide the Section 9. Ultimately, if you succeed in your 9,
My lord, after 2 days, my lord, on Friday.
or they will take it up on Friday. Because, Section 9 will conclude it because they'll protect you pending the execution.
I hope so, my lord.
Fair enough. Keep it on Friday.
Grateful.
41, Lord, may I please also.
Kind of relief.
Lord, this is.
You say you are a former employee of Ramesh Flowers Private Limited.
Yes, yes.
How is it a PIL?
Lord, this is not a matter, Lord, Mayor. The matter, Lord, actually.
You want an investigation into R6's business?
No.
Search and seizure of harmful products.
Only.
Room sprays with their manual, all at the base of a former employee.
We want an
This is what we have to read
inquiry.
in
We
the
want an
notice.
inquiry because now the point is they have manufactured the bottles and sent it to America. And because of that,
Don't worry, the
bacteria,
Americans are
some
extremely
people died.
harmful. The Americans will look
people-
after their commercial interests.
Some people, American people died and some went into coma, Miller. We only want an inquiry and give the particulars to America.
Not a case for our to entertain.
Miller, may submit this, Miller.
No, Mr. Karpak Vinagam, thank you. Dismiss.
Miller, Miller, may submit,
No,
Miller.
no. These are all set up petitions, yes.
Miller, Miller, may withdraw application, Miller. Yeah.
All right, you can withdraw.
I saw-
42.
42, Manoj, there are two applications. Lordship will recall, Manoj, 11th of March, Lordship, Manoj, extended the period which was to expire, Manoj, on 15th of September, Manoj.
Right.
Now, what has transpired is, Manoj, on the annual.
Thereafter,
I have no difficulty if your lordship wants to extend it by another 2 months, 3 months.
Well,
No difficulty at all. I'll tell your lordship
Well,
what they are playing with. This
It is my
dangerous.
application, Manoj, let me
An
submit.
application under Section 27.
That's right, I'm grateful.
Then, Manoj, what they do, in fact, Manoj, there is in fact an order of the trial court. There is, Manoj, a civil revision where, Manoj, that entire 27 has been dismissed. The arbitrator says, come and
What happened against the order of the trial court?
So the witnesses never came. Now, what you are supposed to
Trial court closed the.
what you're supposed to do is go back to the arbitrator, file an application under 27.5. The arbitrator.
No, Manoj, with great respect, Manoj.
They file a civil revision. Civil revision gets dismissed. They don't challenge that before my lords. File another MA here. All that the arbitrator said is, please come to me.
No.
You hear the matter. Let's finish the final hearing. They refuse to appear. Now,
Lords,
all I'm saying is
Lords,
this.
may I submit?
There-
Lords, may,
All right, by when, how long does the
My lords,
arbitrator
let me
take?
submit, my lords.
Look,
How long
well,
does the
My lords, the
arbitrator?
substantial
make a
issue is, my
concession.
lords, the substantial,
I will make a
let me
concession
submit,
so
Mr.
that-
Dewan.
Just one second, Mr. Basa. I will make a concession which may bring lots of quietness to this matter. I have argued the matter and the order is reserved. But I also appreciate, my lords, that today, if it's an ex parte order, because while they have participated in the trial, they have not argued finally, they may use that as a ground to set it aside.
You're the claimant.
I am the claimant.
I am the
They are
claimant, I am the claimant.
I have no difficulty if, my lords, they wish to, my lords, your lordships were extended by 3 months, because otherwise the arbitrator is ready to pronounce the award. In fact, your lordships had given until 15th of September, arbitrator is ready to pronounce the award. If your lordships wishes to extend it by 3 months, give them an opportunity to make closing submissions, well, then I have no difficulty. I will, my lords, concede that much. But
My lords-
beyond that, for them, my lords, to revive this 27, my lords, then to go beyond the civil revision which they have not challenged, and my lords, derail the whole process, my lords, in my respectful
My
submission,
lords, may
cannot
I,
be
my
permitted.
lords, my lords, may I submit? Just give me a moment, my lords.
Tell us.
Now, my lords, on the annual, my lords, at the time when evidence was being taken, they had, my lords, submitted a list of 7 witnesses. Out of that, my lords, 2, Mr. Ravi Shankar and Mr. Murthy, my lords, were extremely relevant. Now, after RW1, my lords, Mr. BL Suresh is examined, the evidence is closed. I immediately filed, my lords, a section 27 on 19th of March. 19th of March, my lords. By that time, my lords, the time was to expire. So we came before your lordships, my lords. On 11th of April, my lords, or 11th of March, your lordship extended the time. So my application under 27 was fairly taken up by the Learned Arbitral Tribunal, my lords. And on 7th of April 2024, A3, my lords, an order was passed. And the operative part is, my lords, page 31, paragraph number 19, which categorically states that these 2 witnesses are extremely important, are relevant, and form the substratum of the dispute. And the dispute whether a settlement has been arrived at or not, my lords, which is the allegation of the other side, can only be decided upon after this evidence of these 2 witnesses come. Based on that, my lords, the learned arbitrator sends us to the City Civil Court. We file the application, my lords, before the City Civil Court. The witnesses are served, my lords, and they are asked to appear on the 2nd of July. They don't appear before the court, my lords, on 2nd of July. And without, my lords, enforcing their attendance, the City Civil Court, my lords, just sends it back to the arbitral tribunal. Now, the Learned Arbitral Tribunal, my lords, because of the compression of timelines, my lords, because it was more, my lords, apprehensive that 15th of September, my lords, time is to expire.
I know, but that tribunal, what the court did was it simply closed the proceeding. because
Yes,
it
that's
didn't
it.
stop.
And send it back to the arbitral tribunal.
Right.
Right. Now, the arbitral tribunal, my lords, instead of having the evidence, my lords, either, my lords, it has sent it back to the City Civil Court.
Just see section 27.
I'm
The court may, within its competence, one says the arbitral tribunal or a party with the approval of the arbitral tribunal may apply to the court for assistance in taking evidence. This was a reference by the court.
The application shall specify in the names and addresses of the parties and
Nature of the claim and relief.
the general nature of the claim and the relief sought, the evidence to be obtained in particular one, the name and address of any person to be heard as witness or expert witness, and a statement of the subject.
Let's please see 27.5, my lords, that's the relevant provision.
My lords, my difficulty is, my lords, today, I'll read, my lords, again. And 2, the description of any document to be produced or property to be inspected.
Be provided directly to the arbitral tribunal. So the court may direct that the evidence be provided directly to the arbitral tribunal.
Right.
So the court issues a summons.
Right, my lords.
And says, go before the arbitral tribunal.
No, my lords. That's why, my lords. The court issued.
What was the direction of the
court issued the summons.
What is the original direction?
Of the arbitrator was that the court will record evidence. And after recording of evidence, the entire records will be sent to the arbitrator. So
there's no such provision in 27.
My lords, that's what the learned arbitrator's order was, my lords.
Actually, the arbitrator should have really placed it before the court for issuing summons to a witness.
That's right. I'm agreeing. Yes.
And then that summons would be made returnable before the court.
Right.
And the witness then appears before the, made returnable before the arbitrator.
Right.
And the witness will then give evidence before the arbitrator.
Right. But by law, the order of 7th April of the learned arbitrator was that it will be referred, my lords, to the learned City Civil Court. The learned City Civil Court, my lords, will record the evidence. And after that, my lords, the entire records along with the evidence will be sent back to the arbitrator. Now, the difficulty is, my lords, Now, we have, my lords, an award which is being, I'm sorry.
Lords, can I draw your lordship's attention to 27.5? Lords, which covers matters where witnesses don't appear.
My lords, I'm on a slightly different
Lords,
point, my
my
lords.
point is this. They were my witnesses. I have now chosen, my lords, not to lead them in evidence. My lords, if the arbitrator believes that I should have led that evidence, my lords, my defense will go.
That's over.
My lords, it was my witnesses. I chose not to lead them in evidence. So, my lords, if today the arbitrator is going to take a view.
But they are the claimants, no?
That's
They are
right,
the claimants.
yeah.
So I had led evidence in defense.
Now, who had asked for the 27?
They filed a 27 because what happened was this. Two of my witnesses, my lords, I chose not to, my lords, proceed with their evidence. While I had, my lords, in the list of witnesses, named them, I, my lords, chose not to proceed.
Have you given evidence or not? Evidence on your
Lords,
side?
yes,
is
my lords,
What
that's
is reserved at the moment?
My lords,
Trial is over.
kindly have, my lords, kindly have.
So your evidence was concluded.
That's right, my lords.
Their evidence was concluded.
That's
These
correct.
were two witnesses who were their ex-employees.
That's right.
You wanted them to be present.
That's right. My lords,
And so
kindly
my
have, my
point is
lords.
this.
My lords, just one page, my lords. Page 31, my lords, nothing more.
Better their case.
Kindly have, my lords, the learned arbitrators. My lords, today I'm on a slightly different point.
No, but tell us one thing.
Yes.
Today, right or wrong, we are in the conduct of the arbitral proceeding.
Yes.
Arbitrator has reserved award.
Right.
And is going to pronounce award because the period which we have prescribed is coming to an end by the 15th of September.
Right.
At the most, he is making a concession that, look, you extend time by a period of 3 months. All right? If you want to be heard, because you have not been heard on your claim, only he has been heard.
They've refused to come.
My lords,
The arbitrator has written to them
my lords,
twice.
my submission
They've
is, my lords,
written-
my difficulty.
If you want to be heard on your claim,
Yes.
the stage of arguments, we can certainly give you that liberty. The order of the trial court closing the proceedings and not issuing summons to the witness, right or wrong, has attained finality. You have never challenged that order.
My lords, the witnesses were summoned, my lords. They did not appear on 2nd of July.
Right.
Right. Now, my lords, my concern is a little different, my lords. Now, today, my lords, at page, kindly have, my lords, just one paragraph, my lords. Page 31, I'll read it, my lords. The learned arbitral award order says, my lords, at page 31, from the answers given by RW1 vis-a-vis statement of defense, there appears to be some variation in payment of money of Mr. Ravi Shankar and Mr. Murthy. Apart from the above, as stated earlier, one of the issues that may arise for consideration, whether there was any settlement between the claimant and the respondent in respect of the scheduled property. 19. Having regard to the answers given by RW1 vis-a-vis the chief affidavit of RW1 and para 25 of statement of defense, this tribunal is of the view that the request of the petitioner for assistance to examine Ravi Shankar and Murthy can be accepted more so when section 27 of the act is to facilitate the production of evidence that is extremely crucial and relevant to the matter. Since the material which is sought to be produced.
Did you want them to be produced as your witnesses or his witnesses?
If I'm moving for, there will be my witnesses, my lord.
So, lords, otherwise, and thereafter, my lords.
So you wanted his employees to be cited as your witnesses.
No, he wants to cross-examine them. He wants to cross-examine them.
On the issue of settlement.
So
One second. You wanted to cross-examine his witnesses. What is the nature of your application?
Lords, I'd be very surprised, Lords, if they want them to leave evidence in their favor.
You are the claimant.
That's correct.
You led your evidence.
Yes, my lord.
Your evidence is complete.
My witnesses have been examined completely.
Right.
Yes.
Then he examines two witnesses.
I don't.
One.
One
Only
witness.
one. RW1.
That witness is complete.
Yes.
And
Now you file an application before the tribunal for assistance in summoning two more witnesses,
Who were in my list of witnesses originally at that I provided.
whom you had dropped.
Which I dropped, which I'm entitled to do
my friend
in a trial.
But
question is
one
an answer,
second,
to answer.
tell us one thing. They are his witnesses originally, right? The Privy Council has commented on this, on the practice of a plaintiff summoning the defendant's witnesses. Now, insofar as his two witnesses, which he dropped, it's his discretion. You can draw an adverse inference, whatever.
That's right, I have no difficulty.
Now, there's no difficulty. But if you want to lead his witnesses, as your evidence was closed, you wanted to produce those two to cross-examine them or as your evidence?
Naturally, the
My
cross-examine, then there's no
lords,
other
if I may put
purpose.
it, my lords. My lords, it
How
is,
can you cross-examine his
That's exactly,
witnesses?
Milords, the point.
my
If
lords,
he
And that's
leads,
why, Milords, they've not
look,
challenged
if
those orders.
he leads the evidence of a witness, you cross-examine him. If he doesn't lead the evidence of two witnesses whom he had originally named,
right.
you can certainly argue before the tribunal that he chose to suppress the best possible evidence.
Right.
That's another argument which is open to you. But how can you seek to adduce as evidence his two employees? You're taking that's you just can't do that.
My lords, if I may, my lords, respond to that, my lords. My lords, have moved an application. Now, the arbitral tribunal, my lords, the arbitral tribunal has the discretion, my lords, to call for any witness, even otherwise also.
That order was wrong.
Right. Now, therefore, my lords, the arbitral tribunal records that the...
Are you trying to lead
My lords,
as your witnesses his employees?
my lords,
Because then you take the consequence of whatever he says in the box.
Milords, I want to make.
They are his former employees. You feel that they would favor you. Therefore, you wanted them to step into the box.
That is an area that I don't know yet.
You know, there was,
Milords, I want to make.
I still remember, a very leading member of the Bombay Bar, Mr. Ashok Modi, he was appearing as his junior in an arbitration where I asked him to ask two questions to the witness. This is what is the answer to these what is the answer to these two questions?
We've heard that, Lasha said
Yeah.
so in a function. That's right.
Right. And exactly this. And second, how can you possibly ask for the deposition of a witness who is cited by him? He gives up that witness. Then your arguments, and you can cross-examine those witnesses who deposed on his behalf. If he suppresses the best possible evidence, you can say that, well, discard the evidence of these two witnesses because those two are not going to be produced. You could have cross-examined his witnesses. What about those two others? Were they in charge of these dealings? Did they enter into a settlement? You can certainly cross-examine his witnesses. But you can't ask for his witnesses to be produced as your witnesses.
Just one more aspect. Can I just draw your lordship's attention to?
Completely unknown to the law.
The
May I
reason
just
for
draw
calling
your
them was,
lordship's-
there was a contradiction. While I was examining, RW1, there was a contradiction, So that contradiction.
Show the
Milords, may I-
contradiction to his
No,
witness.
that's the reason, why I moved the application
Milords, may I
thereafter.
just draw your lordship's attention to one paragraph of his application for directions? I'll tell your lordships what the ploy is.
So I
See
think
paragraph-
we'd rather close it here.
That's right.
We'll only extend time for Justice Praveen Kumar to complete the arbitration from 15th September to we can say 15th November.
That's right.
If you want then to be heard, we'll also record Mr. Divan's concession that he has no objection if you apply to the arbitrator so that your arguments can be heard, since your arguments.
And Milords, I just wish to,
told
Milords,
you
why
one
I'm making
point,
this
just
point
last
is-
submission, and I'll leave it at
Mr.
that.
Basu, just one.
Just record only
Yeah.
this.
Milords, I'll just make one. Can I just draw your lordship's attention to one paragraph?
Submission, I'll leave it at that, after this order, which I was reading at page 31, where the learned arbitral tribunal itself records, about the importance and, about the decisive nature of this particular evidence. We are looking at a conceived award, which is in the process, of being formulated, which will be with great respect, will have certain deficiencies because the arbitral tribunal itself, is recording.
How can you prejudge all this?
The learned
Milords,
arbitral,
There are
the learned
allegations they're
arbitral
making
tribunal
against
says,
the
my lords,
arbiter. With respect, they tried it on the last occasion. Your lordships, Milords, Mr.
Thanks
Basu
for the
withdrew that
conclusion of
MA
the arbitral
on the last
proceeding.
occasion.
The
They're
time
doing it
for
again.
concluding the arbitral proceedings, which was is to come to the time for the conclusion of the arbitral proceedings. It has been extended till 15th September 2024 by an order dated
Milords, 11th
11th
of March
of March
2020.
March 2024 passed by this court. Full stop. In the meantime, an application was moved on behalf of the petitioners before the arbitral tribunal, seeking the assistance of the court under section 27 of the Arbitration and Conciliation Act.
sorry, the application was earlier than 11th of April, technically.
Don't say in the meantime.
Few days before.
The petitioners had moved an application before the arbitral tribunal for assistance for the taking of evidence in terms of section 27 of the Arbitration and Conciliation Act 1996. Full stop. The two witnesses who were sought to be summoned are, it is common ground, former employees
No, my lords. They
were persons who were cited as witnesses,
The list of
by the
witnesses
respondent.
submitted.
cited in the list of witnesses submitted by the respondent, but who were eventually not examined.
That's correct.
Full stop. The trial court issued notice to the two witnesses, but eventually, when they did not appear, the proceeding was closed. Full stop. A revision application against the order of the trial court was dismissed. Correct?
That's correct.
Yeah, that's right. That's
On the 6th of September.
On 6th September 2024. Full stop. In this backdrop, as it appears before this court, time for the conclusion of the arbitral proceedings is to end on 15th September 2024. Full stop. Next. Mr. Nakul Diwan, learned senior counsel appearing on behalf of the respondents, has made a concession in the following terms. Has made a concession. Uske pehle likho. It is common ground that the arguments of the respondent in these respondent, into brackets, who is also the respondent to the arbitral proceedings, who is the defendant in the arbitral proceedings, bracket, is respondent to the arbitral proceedings.
Were concluded on 6th August 2024.
6th August 2024.
And the award was reserved on 19th August 2024.
The award has been reserved on 19th August 2024, correct?
That's correct, my lord.
So stop. Mr. Nakul Diwan, learned senior counsel for the respondent, makes a concession that in order to obviate any further difficulty in the award being an ex parte award, it would be open to the respondent would have no objection if the time for the conclusion of the arbitral proceedings is extended by a further period of 2 months, so as to enable the respondent to move, enable the petitioner to move an application before the arbitrator for being heard at the stage of final arguments. Full stop. Next, we extend time for the conclusion of the arbitral proceedings till 15th November 2024. Full stop. In the meantime, it would be open to the petitioners to move the arbitral tribunal so as to have an opportunity to address the tribunal on the merits of the final arguments.
May I just
Full stop. However, it would be open to the tribunal to take an appropriate view if such an application is made. So we have recorded the concession which has been made on behalf of the respondent in terms as noted above. Full stop. Subject to the grant of the liberty and the extension of time till November 15, 2024, these proceedings shall stand disposed of.
I'm deeply grateful. Just one request, please. Let it, in case the application is moved and it's allowed, let it be a bipartite hearing, because then they will argue first, I'll argue again. That's
Naturally. Yeah.
Naturally.
Very well. I think the tribunal will
The tribunal will give you
I'm
liberty
not sure
to.
whether my friend got the dates right. I think the 19th of August is when they finish their submissions.
correct.
But nothing turns on it. Ashwin, just correct it.
19th August.
Is when they concluded their submission.
That's correct.
All right.
6th and 19th August.
6th and 19th August to conclude in the submission.
That's correct.
And orders have been reserved on
19th.
19th.
I'm deeply grateful. Lord, in this matter, my lord, the dispute arises out of, my lord, an agreement entered into under the Delhi excise policy, which is under investigation now. What we argued, my lord, was that this is a matter in rem.
Your inter-se dispute between them is, of course, arbitrable. Any criminal wrongdoing,
yes,
by the state will be investigated, charges has been filed, but if they have a claim against you, inter-se, under the arbitration agreement, why should that not go?
My lord, I'll answer that.
Anyway, you can raise this point before the arbitrator.
Yes.
No.
Lord, I appear for the party who invoked arbitration. Lord, I am the manufacturer of spirits. He is my dealer. He has to pay me for the liquor he has taken. And the Lord, investigation in the Delhi excise case is
for Pernod Ricard.
Yes.
Yes. I have not supplied liquor. I must get it. How can you say you will not pay?
My lord, please see what the High Court says in para 16.
You have to go on with it's a,
No, no,
it's a
my lord,
claim by them
just
for payment of their dues.
Just see the
You are
judgment.
saying that because of the fact that there's a criminal investigation in respect of the Delhi excise policy, the wider policy issue, Therefore, this arbitration can't go on. That's
No, no,
not
Milord,
so.
Milord, just see what the High Court has said.
To say between the two of you, there's a distributorship agreement.
Just 1 minute, Milord.
Yes.
I know, Milord, I'm traveling a lot after 5 o'clock. Please see para 16. What is the point that the High Court has decided? That it cannot go into non-arbitrability under the Drolli.
Now we are telling you the real, the nub of the matter is this, that why is this dispute not up?
Because, Milord, now I'll tell your Lordship, Milord, that answer, because that answer, Milord, has not been considered as far as the High Court is concerned.
Yes.
Milord, the entire process, Milord, is governed by the Delhi excise policy.
No.
In the Delhi excise policy, Milord, the manner in which it proceeds is that Pernod Ricard decides who will be my sub-distributor. The sub-distributor has to pay me for me to pay Pernod Ricard. Now, I am saying that therefore, under this kind of a contractual agreement, you are in control of the sub-distributor paying me, and only when he pays me, I can pay you. Now this...
But that is your defense in the arbitration.
That's my defense. That's my defense. But, Milord, the defense, Milord, will depend upon, Milord, what is the nature of the agreement under the policy. The nature of the agreement is governed by the policy.
Distributor whom Pernod Ricard is going to appoint will pay you and you will pay them.
That's right, Milord.
That's your defense.
And that is, Milord, following out of, Milord, the Delhi excise policy.
Okay. Thank you.
Milord, the background...
Lord, when they took my liquor, that time they didn't bother. Now they are intoxicated with my liquor. That's why these submissions are being made.
My learned friend has gone home, Milord. What I'm saying, Milord, just 1 point, Milord. Just one thing.
Yes.
What I'm saying is that the background of this contract is, Milord, the policy. Now the policy, what is the nature of the policy, Milord, becomes absolutely relevant in order to decide this contract, any dispute. Milord, I will have to, Milord, make some disclosures there. Very good.
Deeply.
It's too late.
Please, Your Lordship. Well, the matter has to go back for this reason, Your Lordships. Lordship may kindly see, well, page 333. What?
Which matter? Just.
Well, there are three matters, 44, 44.1 and 44.2. I am appearing for SEBI. 44 and 44.1, BSc is appearing. He is, my friend is.
Milords, I am appearing in another connected matter, Milords. There are 3 SLPs arising out of this.
Under what provision did you freeze doctor's demat account?
There are 98C of the regulation. More importantly, but what we are
now, Srinaj and Company Limited, that was a company of his father-in-law, promoted by his father-in-law.
Yes.
Now, in his demat account, doctor is based in Singapore.
He is a promoter. And
he has acquired shares in the promoter's quota.
Yes, and he's a promoter. He is declaring himself as a promoter.
Of that company.
His own annual returns, I'll show.
His means whose?
The petitioner's, one is wife, she's herself a promoter. Another is the son of the promoter, father's son. Son, under the definition of promoter, son by default becomes the promoter.
But he was.
And he has acquired share. But more importantly, more than promoter, this is what has happened. This is very important because about 4,000 accounts of demat accounts are now at stake. The hearing was only for an interim order. Please see page 333. Well, that is very
in my learned
My lords, I am for the respondents.
Your page number.
Well, at 44.2, Your Lordship may take.
Just one second, page.
Your Lordship may take the matter 44.2. Page, well, at PDF page 393. Lord, Mr. Dada was to appear on that day.
4.2.
He sought for time with the court. The court said we will decide interim.
1 second, 44.2 is it?
44.2. Your Lordship may come to PDF page 393.
There's only 392. Last page is 392.
Annexure P27.
Yes.
Annexure P27, my lord.
We have heard arguments on behalf of the parties on interim orders to be passed.
What has happened? Mr. Dada was to appear on the day. My lord, he couldn't appear. He asked for the court for time. Court said we will hear interim application and not final. So, my lord, what is reserved? We have heard arguments on behalf of the parties on interim orders to be passed on the writ petition. Please note the date, my lord. It is 12/3/2024.
Right.
Order reserved.
Now, my lord, order is reserved. The learned counsel. Now, my lord, please come to my lord, PDF page 56. The order gets passed after 5.5 months on 26/8/2024. Final writ petition is disposed of. Now, what is disposed of is very critical. Your Lordship may note 2 pages. My Lord, PDF page 56, the judgment starts.
Right.
Date of the order is 26. My Lord, reserved order, my Lord, 12/3, page 2 or PDF page 57, reserved on 12/3/2024, which is for interim order. But my Lord, order pronounced on 26th August is my Lord final order. Now, what is final order is very important. Please come to his prayer.
Arguments were not.
Not at all. Addressed.
Unfortunately,
Not no.
judges seem to have, because there was a gap, so.
5.5 months. 5.5
My
months.
lords, my lords, I am for the respondent.
1 minute.
May I be given
I'll show what is
2
important.
minutes after they complete?
One more page I will show, then my Lord, let my friend respond. What has been decided? Please come to his prayers, which is very, very critical. Now, 270 PDF. These are the prayers which all gets decided without holding it unconstitutional. The judge says we are not getting into it, but he holds every prayer in his favor. Please see the list of prayers, 270.
That is?
PDF page 270, his writ petition.
Same, no? 44.2.
So 44.2. Please come to my Lord, PDF page 270.
That is internal page 216?
Internal page 210. Printed page is 210.
Yes.
44. May I read the prayer, my Lord?
To quash regulation 97, 98.
The petitioner in the interest, yes, issue a mandamus or to quash regulation 97, 98, 99 of the LRDO regulation issued by respondent 2 as being ultra-virus SEBI Act and declare the respondent's number 2 has no power whatsoever to come out with any circular or notification that creates offences. 2. Issue of writ of mandamus or any other writ to quash the circular issued by respondent number 2 under the powers granted to itself under regulation 9.
Yeah, about A to H prayers.
Prayers, Lord, please see what the learned judge Lord says and paragraph 82 of 86 of the order, which your Lordship will get PDF page 137 and printed page 82. For 44.2, if your Lordship will. SEBI is the
right.
20734. 207.
Easing of the demat account.
And out the petitioners pursuant to so and so is declared to be illegal, not interim order, declared to be illegal and invalid. The petitioner shall be free to deal with all his shares as held in demat accounts. SEBI BS are directed to jointly pay petitioner's cost. My Lord, in one petition is 30 lakhs, another petition is 50 lakhs.
Just 1 second. Mr. Shenoy.
Just to go back.
Yes, Mr.
Shenoy, it appears that the orders were reserved only on the interim relief because the judge says that we have heard only interim relief.
Yes. My lords, this is where, you know.
1 second. Is it correct that parties were heard only on the interim relief?
My lords, during the course, what actually happened is the matter was argued and we went on to this. One of the issues was this promoter shareholding. Unlike anything, both me and my wife.
Two petitioners, mother and son.
This 12th March order seems
Father and son.
Father and son.
Father and son.
Order. The 12th March order indicates that arguments were, that we have heard arguments on behalf of the parties on interim orders to be passed on the writ petition. And then orders reserved, and then the final petition is disposed of. How can that be?
And one last thing, page 83, the order says, having regard to our discussions and conclusions, we keep open all issues of law on the challenge raised by the petitioner to the legality of the statutory regulation. After saying so, it declares every act of us as, my Lord, bad. It says he is not a promoter. It says you can't go and defreeze his account. Everything is in terms of the regulation. After not touching the regulation, after not holding it as ultra-virus, keeping it open, it gives the final relief and awards cost on us without hearing, my Lord. All that we see is please remand it, my Lord. Let them hear us. We want only an opportunity of hearing. We'll be able to show, my Lord, whatever action we have taken, my Lord, we can trace the source of power to SEBI Act 30 and also to Security Contract Regulation Act. We can show the circulars which are governing the field.
All right.
My lords, may I make a submission of only 2 minutes? Only 2 minutes.
5:40. Let's finish with him now. Yes.
My lords, only 2 minutes I will take.
Yes.
As my learned friend said, yes, everything is right. I had challenged these regulations, and what I have challenged is very specifically placed in 38, page number 38 of the petition, my lord, which is the copy of the order.
Yes.
In that, section 11(4)(e) of SEBI Act is reproduced, my lord. Please see section 11(4)(e), what it is.
But you answer the only point which they have argued, that the judgment is reserved on interim orders.
Yes, my lord, please, for a minute, where I am coming from, let me point out. Where I am coming from is, even the parliament in its best sense allowed SEBI to freeze any account for 90-day period. Now here what they are doing is, through circulars, SEBI is not anywhere in the picture. BSE and NSE, which are private parties.
My lords, I appear for National Stock Exchange. My matter has been tagged along with the main.
The High Court, by its judgment dated on 12 March 2024, the division bench of the High Court of Judicature at Bombay reserved judgment in two writ petitions, bracket 1, writ petition, bracket 1, Pradeep Mehta versus Union of India and others, bracket writ petition 1590 of 2021, semicolon, and bracket 2, Neil Pradeep Mehta, NEIL Pradeep Mehta versus Union of India and others, writ petition 2228 of 2021. क्या लिखा मैंने? Reserved orders, reserved interim orders. Reserved orders on the prayers for interim relief in two writ petitions. The order dated 12 March 2024 reads as follows. ये आपको मिलेगा 44.2 में, annexure P27 में, दोनों में, and we have heard से लेकर orders reserved. Order reserved आप copy कर लीजिए. Next, by the impugned order of the High Court, however, by a judgment dated August 2024, the High Court, however, the High Court allowed the writ petitions writ petition there are two separate orders in the petition. Paragraph 80.
Common order.
It's a common order disposing of
last
two.
two paras are devoted to the second petition.
All right. Allowed the writ petitions in terms of the following order. ये page 90 को copy कर लीजिए.
No, page 82, I think, comes the first order. That is in the father's case.
I thought so.
Yes.
And then there's a separate order in the other case.
In the same order.
Same order.
Page 82.
In fact, my lord,
Both the petitions were, however, were allowed finally by the impugned judgment and order of the High Court dated 26 August 2024. Full stop. The High Court has set aside the freezing orders by the communications dated 23 March 2017 and 8 August 2018. Correct? Both are the same date, no?
Declaring them to be illegal and invalid.
Declaring them to be illegal and void. Full stop. The High Court has also imposed costs of rupees 50 lakhs in one case and rupees 30 lakhs in the other case, in the companion case. Full stop. For convenience of reference, the order in one of the two writ petitions is set out below. ये page 90 को copy कर लीजिए.
No, the more complete order is at page 82.
82, 86.
Because that order sets out
everything.
That all questions of law are kept
Right, ऐसा कर लीजिए.
Page 82.
The order which has been passed by the High Court in one of the writ petitions is set out below. para 86 copy कर लीजिए at page 82. In the companion writ petition, writ petition 2228 of 2021, the High Court passed the following order. ये आपको मिल जाएगा
103.
Page para 103 at page 89-90. Okay. Next, we have heard the Mr. N. Venkatraman, the Additional Solicitor General, with Mr. C.U. Singh. You're both appearing for BSc or you're for SEBI?
For BSc.
Millards, I appear for National Stock Exchange.
All right. Mr. N. Venkatraman, learned ASG, appears on behalf of the
SEBI.
Of SEBI. Full stop. Mr. C.U. Singh, Learned Senior Counsel, appears on behalf of the Bombay Stock Exchange.
Now it's called BSc Limited, officially.
BSc Limited, while
Mr. Aman Sinha.
Mr. Aman Sinha, Learned Counsel, appears on behalf of
National Stock Exchange.
the National Stock Exchange Limited. Mr. Yashwant Shenoy appeared on behalf of the original petitioners before the High Court, namely the respondents to these proceedings. Next, clearly, from the narration of facts and the record before this court, it appears that while the orders have been reserved by the High Court only on the prayers for interim relief on 12 March 2024, judgment has been pronounced by the High Court allowing the petitions finally. Full stop. As a matter of fact, the order which has been delivered on the first petition, as extracted above, keeps into invert commas, open all issues of law on the challenge raised by the petitioner to the legality of the statutory regulations, into invert commas complete. The reliefs which were sought in the writ petitions covered comprehensive challenge to the regulations framed by SEBI in question, among other prayers. Full stop. In this background, there was an error on the part of the High Court in disposing of the petitions finally, when admittedly, as the record indicates, orders were reserved after arguments only on the prayer for interim relief. Full stop. We accordingly allow the appeal and set aside the impugned judgment and order of the High Court dated 26 August 2024. Full stop. Writ petition numbers 1590 and 2228 of 2021 shall stand restored to the file of the High Court of Judicature at Bombay for fresh disposal. Full stop. It will be open to the parties to move the High Court afresh for the grant of interim relief in view of the fact that they had addressed for the grant of interim relief, should they be advised to do so. Full stop. The High Court may either take up the application for interim relief, or if it is so convenient, dispose of the petitions finally after hearing final arguments on the petitions.
Millards, my petition on behalf of NSE was
My
tagged.
lords.
So would your lordships like to record that my petition is tagged and disposed of along with this?
Is it on board today?
Millards, actually, Millards, the office report says that arises from the same common judgment. Millards, it inadvertently got listed before Court 6. I appeared there, Millards, and they have directed this matter to be tagged along with this matter.
The above petition, was arises from the common judgment, and the above petition, which has been instituted by the National Stock Exchange of India Limited, arises from a common judgment and order of the High Court of Judicature at Bombay, dated 26 August 2024. Full stop. This court is apprised of the fact that the petition was listed before a coordinate bench today. It has been directed to be tagged
along with this,
with the specially petitions filed by the
SEBI and BSE.
By SEBI and BSE Limited. Full stop. For the reasons which have been, the petition shall stand disposed of in terms of two petitions.
Four petitions. 3 + 1, 4.
You filed 2.
BCS filed 2. BCS filed 2. Totally 4.
4 SLPs are there.
Lordships. Our SLP number and office.
My lords, may I request one?
It's taken on board. and shall stand disposed of in terms of the above order.
Obliged, my lord.
My lord, will your lordship be taking, lordship be taking canon tomorrow as item 1, my lord?
Yes, canon is going to
Yeah,
stand
ready.
tomorrow early.
My lords, may I make one request, my lord?
Yes.
My demat account, I am a gynecologist basically. My demat account has been frozen for 8 long years. And even if we mention before Bombay High Court, my lords know the scenario there. So at least let my interim prayer be heard in the next 3 months or so.
But he challenged it in the SAT, he lost it. Then he now files a writ petition. Let the
SAT
court
asked him to submit a representation.
That's right.
My
But he
lords,
continues to be a promoter of the company.
my lords, I am not a promoter of the company.
The High Court deal with it.
But perhaps if
But-
my friend is anxious, then
My
perhaps
lord,
he can just go straight for final hearing instead of again having an
I know,
interim.
provided the High Court has time for final hearing.
Yes, yes.
Let the High Court decide.
Lordship.
interim
Right,
prayer,
45 will take up some other day.
Lord, my lord, the review petition has been heard, my lord. The judgment is awaited. If your lordship could take it up after 3 weeks, my lord, the review order should be there.
Court is apprised with the fact that the review petition has been heard by
Reserved on 16th August.
Reserved on the request of the Learned Counsel. List on Kardo after 3 weeks. 46?
Lordship, may allow me to give physical appearance in this matter.
Yes, you can, yes.
Milords, 46 has to be taken up with this other matter, RKM Power Gen. They were all listed together, my lords. The first issue is whether Supreme Court will hear these matters or it will be remitted back to High Court.
I know that.
Yes. So, my lords, it may be listed. I've given the diary number. Not listed on 4th with that matter, but because 4th court did not sit, my lords.
Both have, that matter is also before our bench?
Yes, before your bench, my lords.
All right.
I've given the diary number. So
All right. Place it after 2 weeks before our bench.
very well. Deeply.
Grateful.
47?
I appear for the state plot with Mr. Kumanan.
47, I'm for the petitioner. But we have filed a written submission as my lord.
Yes.
So if my lord, what I would propose to do is I will not take more than 13 to 15 minutes. What I propose to divide my submission is I will take my lord through the quick relevant list of dates.
We keep it on Friday or?
But may I just make a suggestion, Lord? Lord, there is another matter which was listed along with this, which because they had filed 2 petitions, they wanted both of them to be taken, which is the multiple FIRs.
Clubbing cases, your lordship may, my lord, they have somehow not been listed today. Your lordship may put all of them together on Friday.
Not Friday, sir. Friday, Mr. R.G.Kar, I have some difficulty.
All right, my lord, we can have it on Tuesday because Monday is holiday.
Have it not after, have it next Friday, Lord. Friday night.
I have difficulty, my lord.
Whenever.
But I have some difficulty, not on this.
All right, my lord, we can have it.
My lord would make.
Who Mr. Surwati is appearing for?
My lord, I and Mr. Luthra are for the state. My
For
lord.
the state, Lord. This Friday, Lord, there's a problem.
File your written submission.
I have filed, my lord.
Mr. Rodgi, Mr. Luthra's file your written submission.
He will file, my lord. He will file it by Thursday, my lord.
You file your, we'll reserve judgment.
Lord,
File your written submissions.
But my lord, allow
we have
us
to be heard on this, Lord. Not we have to be heard on this.
All
But
right, we'll do this. We'll give them, we'll list it on Friday. You make your
But
argument.
don't list it, not Friday. I have some personal difficulty. I have to travel for some marriage, blood in the family. Have it on Tuesday next, Lord, 16.
My lord, I have one request, my lord. Now I have been detained in Madurai jail, my lord, where I am kept in solitary confinement.
no,
Would my lord make an interim arrangement to send me to Chennai, my lord? At least I have there a library. I can read.
Actually, not for 5-7 days, my lord.
16th, Lord. We are only saying 16th.
16th is not far.
17th.
I was detained again on 12th. I've been kept in solitary confinement. If my lord would make arrangement to send me to Chennai.
Mr. Rodgi, why is he being kept in solitary confinement in Madurai?
Lord, I will check it, my lord. I will check it and revert. I have no idea.
Every time.
We'll verify, Lord. If there is something like that, we'll verify. Mr. Rogi has my learned.
We'll verify. I will find out, my lord. If there is a problem, I will make amends.
On behalf of the petitioner, states that the petitioner has been lodged in solitary confinement pursuant to the order of preventive detention at the
Madurai jail.
At the Madurai jail. Full stop. We see no reason or justification for the detention of the petitioner in solitary confinement. Full stop. The jail authorities.
May intervene, my lords. I am for the state. I am assisting seniors, my lords. I have very clear instruction that he is no more. He is not in a solitary confinement at all, my lords. I got a very clear instruction.
What's your name, sir?
Kumanan, my lord.
He's standing up.
Kumanan.
Mr. Rodgi, should we record this?
Yes, Lord, yes. He's standing counsel, Lord. He's the standing counsel.
Lord, he is the standing counsel. He has instructions. He also may record it.
States that he has specific instructions to the effect that the petitioner is not under solitary confinement. The written submissions, if any, of the respondents shall be filed by this Friday. List for final disposal on Tuesday.
Grateful.
Grateful. Deeply.
Everything was urgent today. Tuesday may reflect upon 10 minutes from Monday.
Lordship, there is a request for urgent listing of a particular matter.
What is it?
This is Dr. Shashi Tharoor versus the state of NCT.
Yes.
The learned trial court has called for his appearance tomorrow. So we just wanted to request it for a listing for tomorrow itself. This is a defamation private complaint which was filed against him. We moved the High Court for quashing. That was dismissed on the 29th of August. Immediately within a week, we'll file the SLP. The SLP is also being numbered.
Just circulate an email to the registrar listing. I'm just going to attend to all that right now.
Please.
Just circulate an email right now, straight away.
Right now as well. We have done that in the morning, so we'll do it again. Please. Much.
Lord, I'll take only 2 minutes.
Anji, yes.
I am 86 year, completed 87.
Yes, sir.
I tried for the senior gown. I gave 40 applications. I didn't put it properly, so I lost it. Now the rules are changed. It has gone to other side. I want you.
What do you mean other side?
Since it is a super bench of super court, you have every authority to
No, we
grant
can't do
me.
that. You have to apply on the administrative side for designation as a senior advocate.
Otherwise, you know, I don't
There's some things which are dealt with on the administrative side.
I may not, I don't know how long I will live.
No, so you will live to be 100. We
Please.
pray for you.
Please
But
permit me, this super bench of the super court, you have every authority.
sir, what you do is this. If you have not been designated as a senior,
Tell me.
Balaji, please. Mr. Balaji will explain to you what procedure you have to follow. All right. Thank
Please
you.
help me so that I can continue.
Right, sir. I see your predicament, sir. Thank you.
This your bench can
Balaji,
me.
yeah. Balaji, explain.